No, no, no. Mindy? Okay. Holly, I'm just keeping quiet just in case. I don't want anything to go on online that we don't want to put out there. So let's just, we're playing it safe. That's all. Okay. And Holly, I'm just going to record our interview, okay? We might reuse it.
Recording in progress.
Today, later on today.
If you can send me a link to the recording, I'd appreciate it.
I will. I'll send you a link to what goes on online. It's it goes to our YouTube page once it's clipped. It's gonna be a hectic day, but I'll remember. Let's see.
Were you able to use what I told you about severance to any useful purpose yesterday?
Well, that was for my own personal use, so I have a better idea of things.
Oh.
Mindy? Okay. Well, welcome in, folks. You're watching First Coast News' online coverage of the trial of 3 men accused of murder in the shooting death of Ahmaud Arbery. Ahmaud Arbery, at just 25 years old, was shot and killed in Brunswick, Georgia. Now, this happened back in February of 2020. There wasn't an arrest made in that case until several months after his shooting, and that was in May of 2020 as well, May of last year. We know there have been a lot that has transpired since that time, including federal hate charges that these men have been now charged with. That won't happen. That actual case is not expected to be tried until February of next year. But where we are right now, in November of 2021, is the trial of these 3 men, again, accused of murder in this man's death, Ahmaud Arbery's death. So at this point, we know that the jury has been seated. They finally came to the point where there is now 12 impartial jurors that are now sitting on this trial. The issue, something that we heard come up a lot yesterday once we finally got this jury, is that there's a problem with the number, according to just what folks are saying out there in the area, as well as Ahmaud Arbery's family. We're talking about 11 white jurors that have been seated in this trial and just 1 black. We know the majority of those who were black in this jury pool, they were all struck. Now, joining us this morning is Holly Weiss-Friedman. She's an attorney there in Georgia. She's going to give us some insight into all of this, exactly why we're moving on in this case. Now, Holly, I've got to tell you, as I said, this is causing a lot of buzz online, just people you talk to in general. The judge did find intentional discrimination throughout the jury strike process, yet and still, this jury is still seated. We're still moving forward with this because, again, we're in week 3 right now. Jury selection is done. They're expecting to start opening statements on Friday. So can you explain to us how come, even though the judge did find intentional discrimination, we're still moving forward, we're still holding on to this jury that has been chosen?
Well, I can explain it in a way that gives you an analogy, and that is the question of whether bias played a role in this actual strikes for each of these jurors. There were 12, now there is 1. These 11 jurors, there were only a quarter of the number of total jurors were black, and so, there wasn't a large pool to choose from out of the many, many, many black jurors there were initially. The issue was many, many, many people in different communities had different insights and input into this case. Obviously, the black community was probably following the case somewhat more closely, perhaps, than some sectors of the white community. I will not say that we are so polarized in Glynn County that we have a white community and a black community. We have a lot of intersection in our community, and I don't feel that, that's really an issue. But obviously, small groups, families, people were talking. Black jurors, I think, generally were a little more forthcoming about their sensibilities and their feelings about the case than white jurors in some respect. And so some of the things that were out there with the black jurors were very clearly biased in their initial reaction. I could not be fair in hearing this case. That was said. I have had too much exposure to pretrial publicity. We have been talking about this nonstop with my family. I mean, people were honest. I'm not saying that anybody lied, but just a little bit more forthcoming. Some of the jurors gave very short and curt answers, kind of like Ernest Hemingway wrote his books, very simple sentences. But the question basically becomes, it is a racially charged case. There's no question about it. You have 3 white defendants and a black victim. So automatically you have a climate of a racially charged environment. Then you have the question of whether there's a claim of self-defense, whether this is some kind of vigilante justice, whether this is, systemic racism at play. And so to say that you can remove race from the case is literally impossible. I don't believe that the judge was saying, oh, we just seated, 9 members of the Ku Klux Klan and one black juror. So good luck to that juror. I believe the question is, was there intrinsic bias by the defense, or was there intrinsic, effort by the prosecution to seat an all-black jury? I mean, it goes both ways. And it's very similar, to a sex discrimination case or a race discrimination case or a case on the basis of religion or ethnicity, where the employer says, we fired Keisha because she was a terrible employee. And Keisha says, oh, no. I was fired because I'm only one of 3 blacks. I haven't been promoted. This has happened, that has happened. And the employer says, no, Keisha, don't you remember you were counseled on February 11th for being late? You were counseled on, May 30th for failing to turn in some important report. And then your final warning was on such and such a date and we fired you. If the employer could give a racially, sexually, religious, ethnically neutral ground for why you were fired, your race discrimination case, sex discrimination case, ethnic background case falls apart. They have given a non-protected reason for getting rid of you. And unfortunately, off you go without your claim.
Now, Holly, a quick question. So is it difficult to actually prove bias then in this situation?
I don't think there's any question that there's some intrinsic bias in every decision that every human being makes. If anybody watches that show where the guy plays the forensic trial psychologist, Bull, that's what, I hope it's on your network, but if it's not, okay, where they, look at bias. The whole case is about, what do people bring to their decision making? What is their mindset? How do they look at the world? What is their level of experience of this factor or that factor? Obviously, you have a group of women who have experienced trauma. They're going to try the Bill Cosby case differently than a group of men who've been yelling off of construction sites at women all their life. Hey, baby, you're looking good. So, people come to a jury in the same way they come to their coffee in the morning, a totality of their own circumstances. So I can't read the mind of the judge. I do understand in the framework of the judicial system where he's coming from. Should they have tried to go through a few more jurors? I wasn't there, I haven't been sitting there in the courtroom watching. So I just think that they have a lot of women. I question women have a certain compassion and a certain sensibility they come with. Listen, that may be sexist that I'm saying that, but I do believe that women are generally nurturers. And so, you say that the case is strictly a murder case, but in fact, there are 4 other charges that these men could be found guilty of. Mm-hmm. So even if they're not found guilty of murder or felony murder, you don't pull the trigger, but you're involved in an activity that is criminal, mm-hmm. and it causes death. If it's a felony, it's felony murder. Sure. So you've got manslaughter, you've got voluntary manslaughter, you've got first-degree manslaughter, you've got voluntary manslaughter and involuntary manslaughter, and then you have reckless homicide. You have a number of other charges, mm-hmm. going down in level of severity from, a life sentence without parole, life sentence in terms of sentencing. What are you facing when you're convicted of felony murder versus what are you facing when you're convicted of involuntary manslaughter.
Holly, for those of us just now joining us, I'm just going to clarify a couple of things because you mentioned the multiple charges. We're just going to go over them briefly. We're talking about Travis McMichael, Greg McMichael, as well as William Bryan. Each are facing charges of malice murder, felony murder, aggravated assault, false imprisonment, and criminal attempt to commit a felony. Now, this is all for the death of Ahmaud Arbery, which we know happened back in February of 2020. So just to clarify that for folks who are just now tuning in, not sure exactly about the charges that they possibly face. And as you mentioned, it's such a wide range of penalties that can happen associated with each of these charges.
Absolutely.
Holly, if again, as we mentioned right now, something that you're hearing a lot of people talking about is the makeup of this jury. Now, you are there in Glynn County, not born and raised, but you've been there for several decades now. So you are well aware of the makeup of this area. Do you believe that this jury is actually a good representation of Glynn County?
Well, you know, I wasn't privy to the questionnaires that the jury, you know, asked and answered. I wasn't privy to the questioning that the jurors went through. There's so much that's involved that was not covered. Their body language, their facial expressions, their sense of nervousness. Did they answer very fluidly? You know, did they seem very forthcoming? Did people have to pull the answers out of them? You know, was there some suspicion that they weren't being forthcoming? And that's part of that issue of why the judge is, you know, there to kind of oversee this whole process.
But let's talk about what we do know, Holly. So we do know that the racial makeup, 11 white, 1 black. Also, we did hear from William Bryan's attorney saying that the bubbers of Glynn County aren't being represented in this as well. So again, your thoughts with what we do know. Is this a fair representation of Glynn?
Well, you know, I don't have the demographics, and maybe you do, Keisha, of exactly how many of each, you know, how many women to men in the community, how many, you know, senior citizens to young people in the community. I'm sorry, I don't have the demographics on hand. So I you know, do I go to the grocery store and I see, you know, a diverse community made up of old people, young people, black people, white people? There are no Asians on the jury. You know, there are no blind people on the jury. There's nobody in a wheelchair on the jury. I mean, if you want to pick various groups who might be protected, who bring whatever sensibility they bring to the jury, no, it is obviously 11 white people, 1 black person. It's largely women. And as we were talking a moment ago, I don't know, you know, whatever color anybody is, you know, I can't answer that, because a jury doesn't ever usually end up being representative of anything. The jury is representative of what happened in those days of jury selection, with those 1,000 people, then those 200 people, then those 100, then the magic number of 64, and out of that 64 comes 12 jurors and 4 alternates. Mm-hmm. No one has talked about what's the racial, you know, age and sex composition and demographics of the alternates. Some juror might fall down the stairs of their house and break their leg and be, you know, substituted with an alternate. So the alternates are in the mix as well. Yeah. We're really talking about a larger number of people, but I don't think I've heard that there's a black in the alternates either.
Because as you know, they're being very limited with the information that even we as media are able to obtain or share, because they're trying to protect the jurors. That's what we've been told by the judge, but they're being extremely limited. We can have a separate conversation about that and exactly on what we're able to share with everyone, even the information that we are being privileged to. I want to ask you as well about what you're seeing in your area, because we didn't mention this, but your office is literally a block away across the street from the Glynn County Courthouse. So you have a front row seat to exactly what's going on. What are you seeing in terms of demonstrators out there? I know the numbers have pretty much dwindled over the last couple of weeks. We're in week 3 now. Jury selection just wrapped up. But what are you seeing in that area? Because you have a lot going on. Plus, we know there's a filming of the Black Panther movie pretty close by as well.
Yes, yeah, that's very ironic. However, my office is actually kitty corner, directly across the street from the old courthouse, kitty corner from the new courthouse. The courthouse is in a block that has the old courthouse, the new courthouse behind me, the annex building for all of the county offices. So I'm really, the street on which I'm on has been barricaded on one end. There are giant concrete whatever you call them, that they have for literally, I think, for bombs. And it's a little scary. The police have called us a couple of times to say, you know, there may be demonstrations this weekend. You may want to, you know, bring in things or lock things or not just allow people you don't recognize into your office. So the heightened security is definitely there. I did get a call from a city police officer who I'm, you know, familiar with, who said that supposedly Jesse Jackson was going to be here. I don't know whether that's true or not true, but clearly.
I did hear that as well, but then I heard he had an accident. He fell shortly
Speaking
after
of
that.
someone having an accident and not being able to appear, as I said.
Well, we know he's a little up in age. He's in his 80s, I believe. So, yeah, if he has a fall, that could lead to, but you never know.
In any event, supposedly busloads, quote unquote, of demonstrators will be arriving in Glenn County for the start of the trial. So the question of whether the trial starts tomorrow or the trial starts Monday, you know, they're either going to be here over the weekend and give an influx into the local economy, or they're going to, you know, be arriving later. But I don't, you know, I don't have a sense that anything is really any different on day one than day, what are we on, day 21?
No, it's 13, I believe we are.
13, okay.
Point. Yeah,
it feels like a lot of preparation.
It feels like it's been a long time, correct, yes.
It feels like 3 weeks. It feels like
3 weeks. It definitely has been 3 weeks since the jury selection process started. But folks, if you're just now joining us, you're watching First Coast News' online coverage of the trial of 3 men charged with murder in the shooting death of Ahmaud Arbery there in Brunswick, Georgia, that happened back in February of 2020. Fast forward now to November of 21, and we are seeing that we have finally seen a jury seated. There are 12 jurors that have been chosen, as well as 4 alternates. There is some controversy with the makeup of this jury. It's 11 whites as well as just 1 black. So that has been quite an issue that is raising a lot of concerns, even among the Arbery family. I've got to tell you, joining us, by the way, is Holly Weiss Friedman. She's an attorney there in Georgia. And Holly, I'm just going to say this quote briefly from Wanda Cooper Jones. This is Ahmaud Arbery's mother. We spoke to her yesterday, and she said, "Seeing the African-American jurors come and question so harshly, it's unreal. I was very shocked, and that was devastating." Just Wednesday, we saw 1 juror. We heard from the judge that she walked out shaking her head because she was so harshly questioned. The judge even called it a cross-examination, and this was by Kevin Gaw, the attorney for William Bryan. So they were asking very intense questioning, and that too is something that is causing a bit of controversy. So your thoughts on that? Is it just something that is expected in a trial like this?
Well, it's a very high profile trial. It involves a lot of moving parts, and probably the woman's reaction of becoming so emotional was a reason for her to be disqualified, because jurors have to be neutral. They have to be able to listen to the evidence. They have to lay aside bias and emotion and their own sensibilities, take the judge's instructions, you know, listen to the evidence and make an impartial decision based solely on what goes on at the trial. So if you're questioning me in a very direct, and Kevin, I know Kevin personally, I won't go there, but if the woman broke down or was, you know, devastated by the questioning, she obviously should not be seated as a juror. And so to feel that, oh, they're picking on her, you know, if I was on a jury, ask me anything, don't ask me about my sex life or something that has nothing to do with the case. But as long as you ask me probing and direct questions to determine my bias, to determine my fairness, to determine my impartiality, if I don't react well to that and I have a terrible emotional reaction, I cannot be on that jury. So through one lens, you see that, oh, they're picking on her because she's Black and they want to get rid of her. Through the other lens, you say, well, that woman literally could not be a fair and impartial juror. She's got to go.
And that's exactly what happened in the end. We know she was struck by the judge.
Correct.
Yeah.
Correct. But you see, perception is reality in every instance. And so the perception of different people in different communities, and clearly the family is devastated and distraught, and everything that happens feels to them like their son, their nephew, their friend, their colleague, their cohort is being murdered all over again. Excuse me, not murdered, is killed all over again. I should not have used the word murder. I apologize.
Yeah.
Allegedly murdered all over again.
Yes, Holly. Let's look ahead right now, because you mentioned this earlier. What's to come? The opening statements are set to happen tomorrow, Friday morning. What can we expect? What should we be looking out for?
I think that both sides, the state and the defense, are going to lay out their respective theories of what actually happened that day in February. And they're going to try to get as much background as they can to paint a full picture. I know that the video is a picture and it's a snippet. It's a limited point in time. I don't believe the whole video has ever been played to the public. There are 3.5 hours of video, as I understand it, from a pretty reliable source, of the police after the incident, from the minute they get there through 3 hours later, the call to the district attorney, Jackie Johnson. So, is that something that's going to color how the trial is conducted? Is that jurors going, oh, now we're getting the full story? So obviously the opening statements are a means to lay the foundation on which the trial is built. And each side gets, the amount of time they need to take to show the jury why their side is the side of justice, fairness, righteousness, and the other side is just off the mark, wrong. It's a tragedy, it's a shame, but it wasn't the way it's been described. And, at that point, the trial really becomes a living, breathing thing that is more, it's not so dull. I mean, no offense to the process, but 3 weeks of juror number 379, juror number 486. I mean, it has been a lot of repetition. Now it's going to be moving along at a somewhat brisker pace, but the wheels of justice still move slowly. And between question, objection, ruling, restate the question, as the trial starts, it will drag at times, surely. It's not, it's not going to conclude immediately. Did that answer your question?
It definitely does. I know we've been mentioning Kevin Godd's name a lot, the attorney for William Bryan, but he tends to be the one that says things that are a little jarring. Something that we did hear is that a motion he might bring up today, because that's what they're going through starting at 9 o'clock this morning. The judge will be going through motions, is to possibly make his client have a separate trial than the McMichaels at this point, to sever his case. But do you actually see that happening at this point?
My understanding, as I read the law, is that the motion to sever has to be brought before the jury is impaneled. So that's my understanding.
And you're there in Georgia. You're a trial attorney there, so you know.
I know, but as we've said at the beginning, I do not practice criminal law, so I have a little bit of a unique perspective on this. I practice domestic relations and family law. From time to time, people behave badly in my divorce and custody cases, and they may be involved in criminal law, but not a lot of the time. So it's my understanding that no, that motion needed to have been brought before the jury was seated and all the strikes were in. So I could be wrong. That was a change of venue, motion to strike, motion to sever. We discussed previously the issue of whether motion to sever would be a good idea, bad idea. I know that was not on camera, The issue would be, assuming that it's not too late, and maybe the judge is giving special dispensation that I don't know anything about, or maybe I'm wrong. I hope I'm not, but if I am, the motion to sever, yes, we will. The motion to sever would allow Roddy Bryan to be tried separately, which would bring in or take away, the protections that are available to these defendants to have confidentiality with one another. So any statement one of these defendants made to one another or made in the presence of one another then would be admissible because they're not co-defendants and they don't all come under the same Fifth Amendment privilege. So I would think that it would be very disturbing and frightening to the other defendants for any of them to be severed because, you know, literally they know where the bodies are buried. They were out there before the police were out there. They were out there, you know, they got involved in this incident substantially before it was an incident. So, you know, they really have the backstory. And if they're severed, they can be compelled not to incriminate themselves, but the Fifth Amendment does not prevent incriminating others other than a husband or wife, which is the spousal privilege, which is something different. So neither of these men are married to one another, and family doesn't have the same privilege. So, you know, I would think severance would make the other defendants very nervous. The other thing is, as everyone well knows, all of the mechanics of putting this trial together, if William Roddy Bryan is separate and tried independently, the state could decide, okay, we're going to trial for you Monday or Friday.
Just
and
like
we're
that.
sending the McMichaels, but we're sending the McMichaels back to jail. You want to be tried separately? Come on.
Wow.
It's tomorrow morning.
Wow.
That would be, you know, something. The protections that are lost would be something, you know. And then the other thing is, if they try the McMichaels first, he's separate, he's called in as a witness. Yeah. He then becomes a witness. He has his own privilege against self-incrimination, but he ain't got one for them. So that's a problem. Or he then loses all the protections that went with this trial. He's just a garden variety defendant who gets tried. Regular jury, regular judge, maybe even in this circuit, you know, all of the protections, quote unquote, that have gone to the three of them together may not necessarily attach to Mr. Bryan. So that could be a very significant change in the posture of the case if it's severed.
Very interesting, Holly, as is this case. We're going to wait to see where this trial goes. Again, motions are being heard today by the judge. Opening statements are set to happen tomorrow, Friday morning. I'll be out there in Brunswick. Holly Weiss-Freedom, as always, we appreciate your time, your candor.
Thank you.
Always
My
have
candor,
great,
yes.
great insight. We do appreciate that, folks. It is 9 a.m. right now, and we are going to go ahead and turn things over because we know that court is set to start at 9 o'clock, so we're going to let you tune into that. Thank you, Holly, again. We appreciate your time.
Bye, Keisha. Have a great day.
You as well.
I hope I get to see you in person tomorrow or Monday.
You likely will. I'm going to give you a
Stop
call.
by my office. You know where it is.
I'll give you
Bye-bye.
everybody. Well, that was almost as good as one of the jury panels. Like a mumbled something. All right, we're on. The defendants are present, represented by counsel. The plan for the day is to try to get through motions and get the case into a posture where we are ready to go ahead and move into the openings and evidence. The plan today for the court is to start moving through some of the motions that have been filed subsequent to our last motions hearing, and then address any other miscellaneous matters that maybe I missed during that process. And then, depending on when we get done with that, give everybody an opportunity to figure out exactly what they need to figure out in the courtroom itself so that we don't have any issues getting started tomorrow morning. So that generally is the plan. With that being the case, anything from the state?
No, Your Honor, nothing from the state.
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
We're ready.
From Mr. Bryan?
Nothing, Your Honor.
All right. The way I have this ordered is I've got the outstanding states motions, outstanding McMichael motions, and then I have a list of motions from Mr. Bryan. I don't think we've had anything formally submitted to the court since the last motion hearing, but we've addressed a number of things on the record. I just don't show anything on my list formally.
Motion amended yesterday. Court's already ruled on that.
And I've already ruled, yes. Okay. We may be 24 hours behind on this list, but yes, yes. Okay. I just want to make sure that there wasn't something else out there that I was missing.
I was hoping to file a whole bunch of motions this morning. It just didn't work out. To be fair, Your Honor, when I can get there, we will file a motion for reconsideration of the special demur as to count 7, the aggravated assault with motor vehicle count. We're troubled by it, but we're not quite there yet.
All right. Beginning with the state's motions that I have. All right, the last matter that we addressed at the prior motion hearing was 4.67. I'm now looking at motions in limine. The next motion in limine I have from the state, 4.68. is the state's motion in limine to exclude Travis McMichael's use of force actually, it's the McMichaels generally, I think, use of force experts.
Your Honor, we join their request to use that expert.
Okay, we'll go ahead. Yeah, it's the state's motion. And let me go ahead and address that. I think the way we did it last time is that we just formally on the record, if you're adopting the motion, that we said we'd go ahead and just take that on the record as we got through the motions, and we'll do the same thing here, as opposed to a uniform adoption.
Agreed.
Okay. All right, from the state.
Thank you, Judge. So, Judge, on August 25th, 2021, the state filed 4.68, the state's motion in limine to exclude the defendant's use of force experts. We were given the defense's witness list, and it included Mr. Key and Mr. Register as potential experts in use of force. And when we actually called Mr. Key, he was willing to speak with us, and his statement to us was, well, I've taught at Flexi, but I'm not Georgia law, a Georgia law enforcement officer. I'm from Baltimore. And he kind of generally outlined what he was going to say, but he said that he wanted to be in court to hear what Travis testified to, so he'd know exactly what Travis was going to say his training was, so that he could then explain that training to the jury. And so that's our understanding of what's going on. And that is also confirmed by defendant's response from October 17th. And the reason the state is filing this motion to exclude any use of force experts is because the defense has put up citizen's arrest and self-defense as their defenses. At the time of this incident, no one, not Greg McMichael, Travis McMichael, or Mr. Bryan, were post-certified law enforcement officers. Travis McMichael had previously been in the Coast Guard but had been out for years. Greg McMichael had lost his post-certification in 2018, and Mr. Bryan had never been in law enforcement. So no law enforcement officers were actually involved in any of the events that led up to this indictment or the death of Mr. Arbery. And therefore, having someone come in and testify to law enforcement's use of force is basically a bolstering situation and misleading and confusing to the jury. Basically, it's going to be confusing and highly prejudicial because it's irrelevant. It's going to incorrectly let the jurors think that this was a legitimate citizen's arrest, because we're talking about use of force during an arrest. But that use of force during an arrest by a law enforcement officer is a completely different standard, because a law enforcement officer has three things. Number one, he is in uniform and has a body cam usually these days and a marked patrol car. He is employed, meaning there's something for him to lose or for her to lose if for some reason she violates the use of force policy, namely a salary and a job. And that officer has been trained on the standard operating procedures for that particular police department, has training on that policy, has training in that department's policy of use of force and the consequences for what not following that policy, what those consequences are. None of that applies to any of these defendants. None of them were law enforcement officers. Nobody was employed by a law enforcement agency. So we don't have any of those elements in this case. The reason this would be really highly prejudicial is because it doesn't go to any issue in this case. The state will cite to State versus Copeland, 310 Georgia 345. This was a 2020 case. And in that case, the Georgia Supreme Court held that law enforcement officers who are seeking immunity, basically self-defense in an immunity motion in advance, are subject to the same exact self-defense standard as a private citizen. In other words, you have to be reasonably in fear of receiving serious bodily injury or death before you ever use lethal force. And that force used must have been based on the defendants, whether they're law enforcement or whether they are a private citizen, their reasonable belief that such threat or force is necessary for self-defense. So inserting use of force in all the standards and explaining to the jury at Flexi this is what we train law enforcement officers has absolutely nothing to do with this standard from Copeland. I also cite to Kilpatrick versus the state, 308 Georgia 194, also a 2020 case from our Georgia Supreme Court. There they found it was not an abuse of discretion when the trial court refused to allow the expert to testify because it did not believe the expert's testimony about use of force, fight, flight, freeze responses, and human physiology during high stress and life-threatening situations would be helpful to the jury. And the reason is because self-defense is not outside the ken of an average layperson. No one needs to explain self-defense to an average juror. The law is very, very clear that the use of force, the force used, must have been based on the defendant's reasonable belief that such threat or force was necessary to defend himself. Prior training, or even lack of training, has absolutely nothing to do with that reasonable use of force. Therefore, the expert's testimony would be irrelevant under 401, It would be confusing, misleading, and of course highly prejudicial to the state. Because having a use of force expert come in and go, well, I'm law enforcement, I taught at Flexi, I know all these things, I'm going to explain the training these men had in use of force, it actually implies that they were entitled to basically make an arrest, and that they were acting somehow in the capacity as law enforcement officers because they had some sort of previous training in use of force. Now, the state's not suggesting that if Greg McMichael takes the stand, or Travis McMichael takes the stand, that they can't talk all about what they knew, when they knew it, and what training they'd had, what year it was, what they'd been taught, how that affected what they were doing to explain their actions to the jury. That's perfectly acceptable. But you can't have an expert come in if they don't take the stand and go, well, my understanding based on some records are they had this training and this is the training they had, because it's not relevant and it's bolstering that particular defendant's position. And the defense's response to this is exactly what we're talking about. The problem with the defense's response here, Judge, is they've conflated objective and subjective. They first assert that the defendant's belief in the necessity of using force must be reasonable. The actions must have been motivated by the fears of a reasonable man. A reasonable man is also a reasonable woman. So what we need to do is look at this from the perspective of, and I'm just going to randomly pick somebody, a 50-year-old Asian female. Okay? So what's reasonable for her has to also be reasonable for them. And if she's never had use of force training, it's still the standard of reasonableness. The defendants, however, here conflate it by then saying jurors are permitted to consider how a reasonable person in defendant's particular circumstances would react. That's subjective. That's a subjective standard. Now, they're allowed to go ahead and explain this in order to go ahead, the defendants can take the stand and explain this and go, well, this is why it was reasonable for me personally, but to have an expert take the stand in order to bolster, without them testifying, it was reasonable, or even if they did testify, to say, oh yes, this was reasonable because they had this training, we're now on a subjective standard. The defense say they're basically saying the jury will hear evidence regarding Mr. McMichael's training and experience while he was in the United States Coast Guard. Not sure how that's going to come in except through Travis McMichael, because such training and experience is not relevant at all for the reasonable man standard. He can testify about his training, but for him to be held to the reasonable man standard, it's anybody. It is against this background that the defense intends to call a retired federal law enforcement officer to explain the concepts that Mr. McMichael knew, relied on, and employed on February 23rd. That's strictly bolstering what Mr. McMichael would testify to. Travis McMichael takes the stand, he can talk all about what he knew in his training. And the problem is, if he gets up on the stand and says, well, I got trained in use of force, gets off the stand, then this expert gets up and goes, well, here's what he was trained, and then explains it in minute detail. That's bolstering, because it's not saying what Travis McMichael had in his head specifically. He's the only one who can talk about that. It's now explaining back in the day, however many years ago, he got some training, and this is what the training was. I'm going to explain it to the jury. The defense goes on to say, use of force continuum, perception reaction time, de-escalation techniques, restraints on the use of deadly force, weapon retention techniques, the ability of an unarmed person to inflict serious bodily injury and to continue to inflict injury even when injured. And then we have the determination of probable cause. Well, you're going to explain the law to this jury. And probable cause is a law enforcement standard, not a standard for the defendants in this case. And the reason that the state has serious concerns about the determination of probable cause is that's a jury charge. That's something that's going to be explained from the court, not from an expert in use of force. Obviously, the state, if the defendants want to get up there and basically say, oh yeah, I determined I had probable cause, then that's an avenue that they can do, and the state will cross-examine them on that. The defense then goes on to say expert testimony on issues to be decided by the jury even the ultimate issue, is admissible where the expert's conclusion is one of which the jurors would not ordinarily be able to draw from themselves. They concede that experts are only required when it's a conclusion that is beyond the ken of the average layman. Jurors are asked to determine the reasonableness of self-defense claims all the time without expert testimony. This case is absolutely no different. It's not outside the ken of the average layperson. Basically, at this point, the defense claims that they want this expert to educate the jury on the aforementioned concepts at issue in this case. Concepts at issue. None of these concepts are at issue in this case. Travis McMichael takes a stand and talks about his training. He gets cross-examined about his training. Those concepts, I guess, are use of force continuum, perception, reaction, weapon retention techniques. Travis McMichael can talk all day long about what he knew and was in his head at the time, but none of those concepts are in dispute. He's just subject to cross-examination. They want to educate the jury on concepts taught at Flexi. Well, that's not relevant. And concepts that inform Mr. McMichael's decision-making. There's no need to have an expert educate the jury about what was in Mr. McMichael's head. Mr. McMichael's the one who needs to do that. And then how Mr. McMichael's actions were consistent with his training. In other words, they want this expert to get up here and go, yeah, everything he did was okay. He's allowed to go ahead and do this because he was trained. That would bolster this, and it's not outside the ken of the average layperson to determine whether what Travis McMichael did was reasonable or not reasonable under the circumstances. This is, of course, very troubling. Mr. McMichael's expert will educate the jury on what Travis McMichael was taught about the guardrails imposed on law enforcement officers by the Fourth Amendment. Once again, no one here is a law enforcement officer. The expert's testimony about Travis McMichael's implementation of his law enforcement training. Well, he can go ahead and discuss that, but once again, this bolsters this concept of citizen's arrest in the minds of the jurors by implying that he was acting as a law enforcement officer at this particular time when he was in no way hired, retained, acting in the capacity as any sort of law enforcement officer. As we all know, he was employed at Metzen Marine at the time, not with any law enforcement agency. And they then claim it will assist the jury to assess whether Mr. McMichael's actions and beliefs were objectively reasonable, not outside the ken of the average layperson. And this idea that an expert should come in here to bolster his subjective reasonableness, the state objects to that. Your Honor, in addition, I believe I emailed your office and provided the defense with the state, Cantrell versus the state. If you do not have a copy, I have an extra one right here. Thank you.
When did you email that?
I emailed it to you guys about 3 weeks ago. So I apologize, I only gave you 2 copies. It's Cantrell versus the state. It is from August 12th of 2021, so it's A21, A0773. It's a Court of Appeals decision. And in this case, the defendant Cantrell had been convicted of 3 counts of child molestation and 1 count of aggravated sexual battery. So the underlying facts are different, but Cantrell contended that the trial court erred in restricting his cross-examination of the forensic interviewer. And basically, the court said the permissible scope of cross-examination is committed to the sound discretion of the trial court. Georgia law forbids expert opinion testimony that implicitly goes to the ultimate issue to be decided by the jury when such issue is not beyond the ken of the average juror. So in this particular case, what we had is we had a teenage girl who didn't want to live with mom and dad anymore because she was being, I think it's mom and stepdad, because stepdad was molesting her and she wanted out. The defense's argument was she just wanted to be free of mom and stepdad, and they wanted this expert to be cross-examined on this whole issue of, well, isn't it possible that she's just an ornery teenager who didn't want to live with her mom and stepdad? And that is not a concept outside the ken of the average layperson, that teenagers might not like mom and dad, and that's what the Court of Appeals held. An expert may not testify as to his opinion as to the existence or not of a fact unless the inference to be drawn from the facts and evidence is beyond the ken of the jurors. That is, unless the jurors, for want of specialized knowledge, skill, or experience, are incapable of drawing from facts and evidence such inference for themselves. Self-defense is totally within the jurors' ability to draw inferences from the facts and evidence. Do it all the time. Jurors do not need specialized knowledge. They don't need skill or experience to keep them from drawing a conclusion from the facts in this case as to whether Travis McMichael, Greg McMichael, and defendant Bryan were acting in the capacity of self-defense. Where the path from evidence to conclusion is not shrouded in the mystery of professional skill or knowledge. That sort of special skill and knowledge is when you have a firearms examiner, when you have a medical examiner, where you put up that kind of specialized skill that the jurors are not going to have. The conclusion determines the ultimate issue of fact in a case. The jury must make the journey from evidence to conclusion without the aid of expert testimony. So there's absolutely no reason for expert testimony on use of force when no one was a law enforcement officer here. They then cited to the Harris case, and they noted here that the jury heard ample testimony from the victim and her aunt, and they were subject to cross-examination. In this case, if Travis McMichael takes the stand, the jury's going to hear from him. They're going to be able to judge his reasonableness in these actions if he's claiming self-defense. And once they hear from him, and or maybe his father, Greg McMichael, they will be able to make that decision themselves. The jurors will, because it's not outside the ken of the average layperson. This is why we are motioning based on 401, it's not relevant, and certainly 403, it is far more confusing and prejudicial than it is probative on the issue of Travis McMichael's reasonableness and his claim that he was acting in self-defense. Thank you, Your Honor.
Mr. Rubin.
Thank you.
Your Honor, I do want to be clear about a couple things that the state seems to be under the misimpression of. Number one, we don't intend to offer an expert on the ultimate issue in the case. Did Travis McMichael reasonably believe that deadly force was necessary on February 23rd, 2020? Nor do we intend to offer an expert opinion on whether he properly believed that citizen's arrest was appropriate in detaining Mr. Arbery for the police on that day. But this case is unlike other self-defense cases, and that's why we do believe it's proper to use a use of force expert in this case. It's different because although Travis McMichael was not post-certified, didn't have arrest powers, he'd been trained for 10 years on the very law enforcement techniques that all police officers get. It's not standard operating procedures of a particular police department. These are the national standards set by the U.S. Supreme Court in Tennessee v. Garner and other cases on use of force decision making and when it's appropriate or how it's appropriate in particular situations. So these are standards under the Fourth Amendment search and seizure law that are taught at every police department, both state, local, and federal. Travis McMichael, and I agree with the state on some points. Believe it or not.
Just marking the time.
Yeah.
Before the first day.
You may not hear this again. The use of force expert has to be informed about the facts of the case. The use of force expert has to be informed of what Travis McMichael's training was in the United States Coast Guard. So we know, and the state knows, exactly how Mr. McMichael was trained because we all have his records. We all have the lesson plans. We all have the transcripts from Mr. McMichael's tenure in the Coast Guard. Those are that is training and experience, both hands-on training and classroom training, that every federal law enforcement officer goes through. That is also the same training that state officers go through either at their local police academies or, as you heard through voir dire, some go to FLETC to get this training. There's nothing unique about it in terms of police officers. But it does inform the actions of Travis McMichael on February 23rd. You don't just throw away your 10 years of training when you become a private citizen, especially when that training is drilled into the Coast Guardsmen or other agents repeatedly so that it becomes muscle memory. That's the whole point of it. You're not supposed to be thinking out there. You're supposed to be acting on muscle memory. That's how you save your own life and the lives of others. Travis McMichael's training and the video, and Travis McMichael even testifying, would inform an expert on what he did, what he was thinking at the time, what he understood the facts to be, and how he implemented his training on a particular day. Now, this expert's not going to testify that Travis McMichael acted reasonably on February 23rd under the self-defense statute, but it is proper to use an expert to corroborate the information the jury would receive from both the video, where they can see actions, and Travis McMichael's testimony. The state charged, for instance, Travis McMichael with aggravated assault. And they're going to argue that the act of pointing the shotgun as Ahmaud Arbery is rushing him was a crime. I would anticipate the expert to educate the jury on when it is proper to show a weapon, when it is proper to point a weapon, not for the purpose of hurting someone or killing someone, but for the purpose of de-escalating the threat or the violence at issue. The Georgia courts in Bracewell versus State, 2000 case, 243 Georgia Appeals 792, and Dasher v. State, 146 Georgia Appeals 118, a 1978 case, have both held that the jurors are permitted to consider the defendant's particular circumstances in their determination of whether he acted objectively reasonable. These are the factors the jury has to consider. The concepts that an expert would testify to that are the same concepts that Travis was trained with or trained on are outside the ken of the average lay person. No one outside of law enforcement understands de-escalation techniques the way it is taught. No one understands the use of force continuum that police officers have to think through and are trained on how to implement. No average person understands the ability of an unarmed person, which we've heard of repeatedly in this case, the unarmed person's ability to inflict serious bodily injury on an armed person, whether it's a police officer or a citizen. And at that point, Your Honor, it doesn't really matter whether that person is post-certified or just a citizen. They both have the right to use deadly force if they reasonably believe that they are in danger of death or serious bodily injury. OCGA section 24-7-707 says, in all criminal proceedings, the opinions of experts on any question of science, skill, trade, or like questions shall always be admissible. Again, assuming they're beyond the ability of the jurors to draw those, to understand those facts for themselves. And I would say in this case, given the amount of training law enforcement officers receive, the years of training and the continuing training year after year that they receive, shows the court in and of itself that these are concepts and scenarios that are beyond the understanding of the average layperson. I agree that we would have to lay the proper foundation. This expert can't just come in and look at Travis's training records and testify to what Travis understood or what Travis knew to be true, but that's not what we're doing in this case. This expert, who taught at FLETC for years, continues to teach. And it's not Joe Key, by the way, it's Rick Register. It's a different person who's also on the witness list. Former ATF agent who specialized in teaching use of force decision making, has both met with Travis McMichael, has reviewed the evidence in this case, and has reviewed the training records of Mr. McMichael. Assuming we lay a proper foundation, which we understand, his testimony on the proper use of force in various scenarios, including the ones at issue in this case, would be admissible. If the court has any questions, I'm happy to answer those.
I have a moment to confer with counsel. Your Honor, it appears that Ms. Sonikowski and I are actually in agreement. We might want to write that one down too, in the sense that I think we agree that the rules of force in the context of an arrest are in fact identical, whether the individual is a policeman, a bail bondsman, or a private citizen. And I think that informs the discussion here. I'm surprised, and the reason I specifically wanted to address this, aside from the fact that the court's charge in this case and these motions affect Mr. Bryan, is it seems to me that the testimony proffered by the McMichael defense is relevant because of the state's decision to indict these defendants on malice murder. Now, if the state were simply pursuing an aggravated assault claim or even a felony murder claim, that would be one thing. I think the McMichael defense is correct even on those, but with malice murder, there's no question that this testimony would be admissible. The question with malice murder is the mental state, and whether or not the jury finds that Mr. McMichael can justify an aggravated assault by a misapplication, what the state contends is a misapplication of use of force, it seems to me that in explaining Travis McMichael's mental state and why he did what he did, because why he did what he did becomes the issue on a malice murder charge. He may have been mistaken. He might be guilty of aggravated assault. He could be guilty of felony murder. But as long as there's a malice murder count in this case, then why Travis McMichael does the things he does are incredibly important. And since my client is charged as a party to a crime in that murder, we certainly have a dog in this fight. The training that he received is certainly relevant to a jury's determination of whether he acted with malice. In other words, it gets to his credibility. Now, if Travis McMichael testifies and he explains what he did and the state doesn't contest it, if they don't challenge it, if they don't go after Travis McMichael's credibility when he tells the jury this is why he did what he did, then that's one thing. But taking a wild leap here and assuming that the state plans to challenge on cross-examination the credibility of Travis McMichael when he gives the reasons why he did what he did, then at that point, that testimony is going to be relevant and it's going to be highly probative on the issue of malice. Your Honor, I'd also note, interestingly, we do disagree. The state just told you that probable cause, and if I got this wrong, someone will correct me. The probable cause is not she said probable cause is a law enforcement standard. It is not a law enforcement standard. Probable cause is the same whether it's a police officer making an arrest, a bail bondsman making an arrest, or a private citizen making an arrest. She's got that completely wrong. And that informs the whole argument here. The probable cause standard is the same. The state wants to make a big deal about talking about objective versus subjective, and that's always a very interesting conversation. The state also contends for the last 18 months that what's in the mind of Ahmaud Arbery doesn't matter. All that matters is what's in the mind of the defendants. Well, when you're looking at it from the defendant's perspective, you might as well put badges and guns and mark police cars for all of them, because from their perspective, when they're trying to conduct an arrest, they're looking at it from that perspective. And the state's whole point for 18 months is what Ahmaud Arbery sees isn't relevant. What's in his mind isn't relevant. It's only what's in the minds of these defendants. So again, I think the state is unintentionally proving Mr. Rubin's point. Your Honor, and again, in closing, I'm not suggesting that the training that Travis McMichael received or didn't receive ultimately makes anything he did that day okay. But it is relevant for a jury to determine malice in this case. And for that reason, if for none of the other reasons offered by Mr. Rubin, that expert testimony should be admitted. Unless the state is willing to concede, and that would be nice to know before opening statements, unless the state is willing to concede the credibility of Travis McMichael on that subject. Because if they're going to challenge it, then it's fair game, and we should all be allowed to talk about it in opening statement. Thank you.
State's motion, any final word?
Yes, Judge.
Your Honor, we were handed two names, Charles Key and Rick Register. This is the first time I'm hearing that the person going to be testifying is Rick Register. I have no CV for Mr. Register. I've gone to his website where he offers training classes and then lists, I've had this many years of experience, but I have no way to determine whether he's ever testified before, what cases he's testified in before.
That's a different issue, Judge. That's not on the admissibility, but they can voir dire him. There's no obligation for me to provide a CV or anything, and I'm happy to, but that's not a different issue.
I'd kind of like to do this to keep everybody from popping up. Let's let everybody finish their thoughts, finish their arguments. If there's a response to it, happy to hear it.
Thank you, Judge. So, back again, I have no CV, wasn't provided that in discovery, was not provided with any report. According to Mr. Rubin, Rick Registered spoken with Travis McMichael. I believe the state's now entitled to those statements. If he's going to base his opinion and you allow this in, then at that point the state is going to want to know exactly what it is that Travis McMichael said to this expert in order to make his determination of whatever he's going to say. Now this, of course, is if you allow it in, because he said he's talked with Travis, he's reviewed the evidence in this case, and he's reviewed the training records, and he's now going to render some opinion. So those are just the two issues the state has. If this is allowed in, need the CV. If this is allowed in, Mr. Register did not return my phone call when I called him. Mr. Key did. And to know exactly what is going to be in his testimony. Right now, I have no report or any analysis or any statements from Travis to Mr. Register upon which he's basing his opinion. So those are some of the issues the state has with that. And defense counsel brought those up, so I wanted to bring it to the attention of the court. Once again, we're back to bolstering. As Mr. Goff just argued, malice murder, an abandoned and malignant heart. Malice can be formed in an instant. So the state's not contending there's a misapplication of any use of force. The state's contending what the law is that this was unreasonable to pull out a shotgun and start pointing it at somebody who was not a threat at all, but was simply running while being chased by Mr. Bryan in his truck toward a man holding a shotgun. And then he tried to avoid that man. That's what Mr. Arbery did. So this whole idea that we're claiming it's a misapplication of use of force, we're not even talking about use of force. Those are not our words. Those are their words. Why Travis did what Travis did, Travis can take the stand and explain that. And Mr. Goff just made the state's point. They need this expert to bolster his credibility. That's exactly what they're doing here. This is bolstering. Travis McMichael can get up and talk about his training. He can talk about what was in his mind. He can talk about what he was thinking. But then to have an expert come in and go, yes, this is what he was thinking, this is what he was thinking, and let me explain to you how 10 plus years ago or whenever it was, he got some of this training and this is what he was trained on. I didn't train him on it, but this is what we train people on so that the jury understands what he was trained on. Maybe they do, maybe they don't. But Travis McMichael should be able to explain his training. Because here's the other problem, Judge. Memories fade. And while the defense wants to talk about muscle memory and he was acting in the capacity as law enforcement in their minds, well, they can explain that. But the problem is if Travis McMichael takes the stand and says, I was doing A, B, and C, and the Rick Register gets up there and goes, well, he was trained to do A, B, C, D, E, F, G, and H. Well, there's all these things that Travis McMichael didn't testify he did, and now we have Rick Register going, but he was trained in all these extra special other things that Travis McMichael never said that he knew about. And of course, it begs the question as to the preparation of Travis McMichael for his testimony by an expert in use of force. So, Your Honor, once again, no one here was acting as a law enforcement officer. If they want to claim in their minds they were acting as law enforcement officers, they can take the stand and explain that. The use of force expert under 403 is far more confusing and prejudicial than it is probative on the issue in this case. Because Copeland says so. Law enforcement officers are subject to the exact same standard. I mean, this is 2020, the Supreme Court of Georgia. Law enforcement officers are subject to the exact same standard as regular citizens. 50-year-old Asian woman who takes the stand and says, I was acting in self-defense and this is why, her reasonableness is analyzed under the exact same standards by those jurors as someone who comes in here and says, well, I've had law enforcement training and this is why I did what I did and this is why I was acting. An expert to bolster his credibility and an expert to explain his behavior, all it does is bolster the idea that this was a legitimate citizen's arrest, which is, by the way, the state has to prove it wasn't beyond a reasonable doubt. And so the state is very concerned about this, and we ask you to prevent the defense, to grant the motion in limine, to keep an expert in use of force to come in here simply to bolster his credibility and to make it seem as if he was acting as a law enforcement officer. Thank you, Judge.
Can I make one or two points? Three very small points.
Small points.
It's interesting that the state says that a law enforcement officer stands in the same shoes as a private citizen, because that's exactly true. And the jury's entitled to know, just as they would if a law enforcement officer was on trial, what training and experience that person, whether they're an Asian woman who has no training, or someone who spent 10 years in the United States Coast Guard who has extensive training in law enforcement techniques. The argument is kind of all over the place for the state. Memories fade. Travis McMichael might not remember his training. those are all questions for Travis McMichael if he testifies. Those are questions for the expert if he testifies. Those are cross-examination questions. What the state calls bolstering is actually corroboration. Travis McMichael, if he testifies, and testifies to what he was taught in the Coast Guard, can be believed or disbelieved by the jury. But a FLETC teacher who teaches the same exact things and who has reviewed Travis's records and reviewed the video and spoken to Travis McMichael can corroborate the concepts, not what was in Travis McMichael's mind, but the concepts that are taught to everybody who goes through the training that Travis McMichael had. It's not bolstering, it's corroboration. We're entitled to corroborate the testimony of our witnesses through expert testimony. Thank you, Your Honor.
I'll tell you how I normally do it. It's the move-ant, response, and then a rebuttal. So just to make sure the day doesn't expand to 7 to 8 o'clock tonight, I'm going to try to keep to that. But
And Your Honor, given the extra travel distance from my seat to the podium, may I speak from here?
yeah, I can hear you just fine as long as everybody can hear you.
Your Honor, I have 2 points. One is, and I would suggest the court should be offended by the suggestion made, but not personally, as an judicial officer, that the state's burden in this case should somehow change the rules of evidence. Is the state really trying to suggest that the ends justify the means? That because the state has a need that the rules of evidence change? That's not the way I was taught. The state has to live with the rules of evidence as they are. And my second point is, echoing Mr. Rubin, we do this in all kinds of areas of law. This suggestion by the state that there's something unusual or remarkable here about this motion, I think the court should find troubling. When you challenge the credibility of a witness, you open doors. It's not bolstering, it's corroboration. And that's exactly what the state just cites a child molestation case. We deal with these issues in sex cases, sex offense cases, and child molestation all the time. You do this, you do that, you open doors. And again, the state didn't even respond, and I think before the court goes any further, the state needs to put the court needs to put the state on the spot. Do they intend to challenge the credibility of Travis McMichael if he's going to get up there and testify that he acted the way he did based on his training, and whether right or wrong that he didn't have any malice? Is the state, are they conceding they're not going to challenge his credibility? Because if they'll acknowledge that they are, then this conversation becomes real short and real simple for the court.
All right. This motion was filed back on August 25th with the defense responding October 17th with the additional supplemental information that was provided by the state. Considering the record, considering the arguments of counsel, the court is granting the motion in limine to exclude the use of force experts. There's going to be a written order that will provide more detail on the court's ruling, but generally relying upon Kilpatrick, and actually Cantrell, I guess, is more recent than Kilpatrick, but talks about the same things, where jurors can take the same elements and constituent factors which guide the expert to his conclusions, and from them alone make an equally intelligent judgment of their own, then expert opinion testimony is not admissible. That's Kilpatrick, which again is consistent, I think, with Cantrell. Here we're discussing the objective standard that the jury is going to be using in order to evaluate, it sounds like, the defendant's actions, which are on video and evidence will be presented on. At the time that the defendants were acting, they were not specifically acting as a law enforcement officer. They were private citizens who were acting, as I understand the defense will be, a citizen's arrest. The Kilpatrick was a case, I've got it down here in my notes, where the trial court, there was a finding the trial court did not err in excluding a use of force expert's testimony on grounds it would not be helpful for the jury in determining whether there was a justification in shooting. There's also Mosby versus the state, let's see, 296 Southeast 2nd, 277. The Georgia Supreme Court has also previously held that an average juror generally can determine without the aid of an expert whether conduct allegedly taken by an individual in self-defense was necessary to protect against death or great bodily harm. It's also Perry v. State, 295 Georgia App 264, that cites Weems versus State, which is a Supreme Court case from 1997, 268 Georgia 142. And again, as was said by most, law enforcement officers are held to the same self-defense standards as private citizens, and that gets into State versus Copeland and Kidd versus Coates. All those sites will be available in the court's written order. I do also point out that there's additional support from other jurisdictions, again, obviously not necessarily holding the weight of precedent in this court. Under more similar circumstances, there's some federal cases, Hart v. Howard, use of force expert excluded, where neither party was acting as a law enforcement officer. The altercation was on video, and the expert's testimony would not be helpful to the jury. There's also one out of, the Northern District of Florida, where trial counsel was not ineffective for failing to call a use of force expert under similar circumstances. There's one out of Maryland, use of force expert not allowed to testify to police officer appellant's use of force as a civilian, because whether a civilian used reasonable force is an issue that the jury can decide without the aid of expert testimony. All of that will be contained in the court's order. The next motion, 4.69 is actually the motion regarding the restriction on extrajudicial statements. That has already been addressed. The next one in line, 469, was extrajudicial statements. That's already been addressed. 470 is the state's motion in limine as to THC.
Thank you, Judge. So state's motion in limine as to THC 4.70. The first thing I'd like to tell the court is that the state is not going to tender into evidence either the blood alcohol content via Amanda Cook of Mr. Ahmaud Arbery. It was negative. He had no alcohol in his system, but we are not going to put that evidence up. Just like we are not going to put up any evidence of any drug tests on Mr. Arbery. The drug tests all came back negative the very first time that the GBI did their baseline test for cocaine, amphetamines, THC, everything. It was only when Agent Dial requested a screening of Mr. Arbery's blood to see if he had any prescription medications in it that a minute amount of THC was discovered in his blood. And I apologize. It would be Jim Gordon who would do the BAC, but we're not going to put up his blood alcohol content. So having stated that that's the state's intent, we are not going to discuss what was in Mr. Arbery's system, what wasn't in Mr. Arbery's system. That's not going to be part of the state's case in chief. We learned from speaking with the defense that they did wish to put in his THC, so we filed a motion in limine to go ahead and keep that out, given it was such a minute amount. And when we spoke with Miss Amanda Cook, she said, listen.
There's a couple toxicology reports, so the state's not using any of the toxicology reports?
None of the toxicology reports. Okay. None of them. Not going to put any of it in. They were all negative up until we came up with this minute amount of THC. So we went ahead and filed this motion in limine to keep out this, because when we spoke with Miss Amanda Cook, who is the person who ran the toxicology and discovered the THC, she indicated to us that she couldn't tell us anything about how it affected the victim. I mean, it's THC, part of what's in marijuana. She had no way to determine how it affected Mr. Arbery, what was going to happen with Mr. Arbery if he smoked it, how long ago he smoked it, why it was in his system, when he smoked it. She certainly couldn't tell the quality or quantity of what it was, given, as we all know, marijuana now has marketing value. This one will make you mellow, this one will make you feel this way. She couldn't tell us anything about it. And so the state feels it's not relevant, and we were not going to put it in. In response to this, the defense then filed on October 11th a response to the state's motion. And for the record, the state filed its motion in limine on October 4th of 2021 to limit evidence of the THC in Mr. Arbery's system. October 11th, the defendants filed their response. Their response is that they are going to want to put up an expert, and their expert is the same expert that they were going to put up to go into his mental health. And they basically, with their response, went right back down the rabbit hole of she can come in and she can say what this minute amount of THC did to Mr. Arbery, because she's also going to testify then to the schizoaffective disorder and all of his mental health records, and then she's going to base that opinion and diagnosis was correct because she's looked at all of his other acts. So now we're backdooring, hey, he had a minute amount of THC in his system, and here's our expert to explain what effect that had on Mr. Arbery, and our expert's now going to go into a 2018 diagnosis. We're going to go into her supporting that diagnosis with all of his other acts, and that's exactly what they have said in their motion, that's exactly where they're going. We, of course, had no idea they were going to proffer and want this woman to then testify to everything that this court has already excluded and written extensive orders on. The state, of course, cites back to the hearings from May 12th and 13th of this year, and we have, of course, the court's ruling from October 1st of this year on the order on the admission of the victim's mental health records. So, Your Honor, we ask that the THC, because it's such a small amount, be kept out. Once again, they had no idea who Mr. Arbery was. He was a complete stranger. The idea that their expert's going to be able to come in here and put all of that evidence in when the court has already ruled all of it out is just a backdoor way to get that evidence in that the court has already ruled as inadmissible. And we ask that it be excluded, and we are not going to go ahead and proffer it or put up any of the toxicology reports from Mr. Arbery. Thank you, Judge.
Your Honor, before I begin, could I inquire whether the state did share with us that they intended originally to put up the absence of alcohol in the system because alcohol in the system could make somebody combative, and so it was their original intent, and they've obviously changed that, what I hear them saying now, but it was their original intent to introduce the absence of alcohol in Mr. Arbery's system at the time of the shooting to demonstrate to the jury that he didn't have alcohol, which could make him combative.
The answer to that question is no. The state had put I'll back up for a second. The person who originally did the BAC analysis is on maternity leave. So the state went ahead and said, well, will you guys stipulate to this fact? And we did it without really thinking it through. Totally admitted, hey, my witness is unavailable. Will you guys stipulate to this? This is how we can put it in. Will you, meaning you guys, the defense attorneys, stipulate to the fact that his BAC was negative? And we were doing it out of transparency. This is our case. We just want to put this in, being transparent. We then went ahead and found Jim Gordon, the peer reviewer, and we served them with that. And then once the THC thing came to our attention, and I apologize, I thought I had told y'all, meaning the defense attorneys, that we had then no intention of putting any of this in, because once we thought about it, and your ruling came out on October 1st about his mental health, none of that became relevant as far as BAC or what was in his system. So we changed it, especially when the defense withdrew their consent to that stipulation, we basically backpedaled, thought about it, and filed this particular motion. So I just want the court to be clear. I hate to admit it, but it was a little, hey, we're being transparent, let's thoughtlessly put this up, will you guys agree to it, without thinking through the implications of it. Once we got your ruling and talked to the defense, that's why we've withdrawn that evidence. We find it not to be relevant in line with the court's ruling, and we're not going to tender any evidence of the BAC and or the drugs.
I guess my question is that the state informed the defense that they were going to put up the evidence of no blood alcohol because the jury needed to understand there was no alcohol, because the jury could think alcohol, because of the aggressiveness equivalent, that alcohol causes aggression, there's no alcohol, so there was no aggression. And I think that the state needs to admit that to the court, because that was a conversation that we had, that the state recognizes that alcohol could cause aggression, which would make the issue relevant to a jury, but since there is no alcohol, then that was why they wanted to put that into evidence.
Well, let's talk about what the evidence, we're dealing with motions in limine, and so I'm just focused on evidence that is being proposed and what to do if there is anything to do pre-trial.
Okay, I think what's important here, Your Honor, is that the state has shared with the defense that they recognize the relevance of substances in the body.
Objection.
What's the
I
objection?
appreciate this is an objection. I appreciate Mr. Sheffield speaking for the state, but that's not at all what the state is saying. So I want it on the record, while he's speaking for me, that's not what the state intends at all.
Well, that's why I was inquiring. So let me explain to you why I'm saying what I'm saying, Your Honor. In a conversation with Miss Olivier, the state recognized to the defense that substance in the alleged victim's body at the time of the shooting in the case could go to the potential aggression of the alleged victim at the time of conflict. And their goal was to put into evidence that there was no blood alcohol so that the jury wasn't wondering about it, and to solidify in the mind of the juror that there was no alcohol in Mr. Arbery's system at the time of confrontation, because the jury could think alcohol makes people aggressive, so it would be good for them to know there was no alcohol in the system. I want the court to understand that the state has acknowledged the point I'm about to make, and I think it's important for transparency purposes. That being stated, Your Honor, what we know here is that at the time of the conflict in this case, Mr. Arbery had THC in his system. Now, that is a chemical substance that causes behavior. There are a line of cases that go directly to this issue where the defense can establish a causal connection between that chemical substance in the system of the alleged victim and its potential to cause aggression, to cause confrontational behavior, and to cause combative behavior. That's the beginning. Now, not only do we have evidence that Mr. Arbery had THC in his system at the time of the shooting, the autopsy in this case also confirms that he had what the medical examiner calls anthracotic pigment in his lungs, which is associated with extensive, regular smoking of large amounts of marijuana. The toxicologist also confirmed that the THC in the system also corroborates frequent use of marijuana. So there's no mystery anymore around Mr. Arbery's use of marijuana and that he had it in his system at the time of the shooting. Now, the cases that support the admissibility of this type of evidence go straight to really the ultimate question. Is there any connection? And the language that we find in these cases is the presence of this system in the body could cause aggression, could produce strange behavior, potential behavior at the time of the conflict. Those cases, the McWilliams case, which is a Georgia Supreme Court case, 280 Georgia 724, 2006, the court in that murder case excluded the ME who came in a pretrial hearing and said, you know, I've studied the literature on this issue about cocaine metabolites, and that case also involved alcohol. Didn't know the issue prior to reading literature on it, but studied the literature and found that those substances could cause aggression, combative behavior. The Robinson versus State case, 272 Georgia 131, talks about that causal connection. Gill versus the State, 296 Georgia Supreme Court 351 2014. Those cases stand for, does the alleged victim have this compound in his system at the time of the fatal encounter, at the time of the homicide? Now, what we know is that he does, but what's the causal connection? Ultimately, Your Honor, we have learned through our psychiatrist that Mr. Arbery has a diagnosis of schizoaffective disorder. I understand the court has ruled this out currently. But schizoaffective disorder, that diagnosis by Gateway, the same institution that this court, not Your Honor, but Glenn County turns to time and time again for diagnosis of people in the criminal justice system, diagnosed Mr. Arbery with schizoaffective disorder late in 2018, early 2019. Our expert has reviewed more information than that expert at Gateway had and concludes that that is an accurate diagnosis, and understands through literature and through her experience, this is Dr. Kelly Kaufman, that an individual specifically with schizoaffective disorder who uses THC has a higher incidence of aggression, that THC in particular, used by an individual with schizoaffective disorder, exhibits aggression. It's documented in the literature, it's understood in the community, and understood by our expert. So, the question for the court then becomes, does he have the compound in his system? Yes. Is there corroborating evidence that he has chronic use, excessive use of THC? Yes. Is it in his system at the time of the homicide, as Robinson stated? Is it in his system at the time of the fatal encounter, as Gill has stated? Is it in his system at the time of the shooting in McWilliams? Yes, it is. Now the question becomes, could it cause potentially aggressive behavior, combative behavior, confrontational behavior? Yes. The expert says yes. Now the state can cross-examine the expert. The state can say, you don't really know. That's weight. But it is reversible error, as McWilliams has held, new trial, to not allow this evidence to come in. Thank you, Your Honor.
Final word from the state.
Yes, Judge. Unfortunately, I'm unprepared to rebut Mr. Shepard's assertion that McWilliams holds as reversible error not to let any of this in, because we heard a lot of could it potentially do this and potential behavior at the time of conflict. And is there a connection between a minute amount of marijuana that could cause aggression? And we're right back down the rabbit hole that this court has already been down with the mental health and the 404B. In this particular case, why Mr. Arbery did anything Mr. Arbery did is completely irrelevant. That's not the question. It's what the defendants did. And they knew nothing about this. They knew nothing about what was in his system. And we're going to do our 403 again, where we go down the rabbit hole with Kelly Kaufman, because she's going to take the stand. She's going to then start talking all about his medical diagnosis. She's going to talk about it. And right now, Judge, you have ruled that the medical diagnosis is, from 2018, suspect at best. She never met Mr. Arbery. She never interviewed him. And she's going to look at the 10 worst moments of his life with the 404B evidence and basically go, okay, yeah, this is him. And therefore, I conclude these things. It's under 403, very, very prejudicial, and the prejudice outweighs any probative value with the fact that I don't even know if this is consistent. Frequent use of marijuana. Whether there's the stuff in his lungs means only marijuana. And they're talking about it causing him to be aggressive, combative, and confrontational. That is for the jury to decide. This is on video, and they can determine it. Dr. Kelly Kaufman's testimony on the effects of THC on Mr. Arbery are not relevant, and for the same grounds her testimony would not be allowed for his mental health, those are the exact same grounds that this court should find it's not relevant to her to talk about THC in his system. We ask that based on 401 and 403, and for the exact same reasons the court has already found in excluding evidence of his prior acts and his mental health diagnosis, that you deny this motion. Because at this point, those two rulings will go right out the window with Dr. Kelly Kaufman taking the stand, and we're going to go through all of that evidence. And at this point in time, the state would, of course, want to put up an expert to rebut this, and we end up with our mini trial within a trial again. So we ask that you exclude the THC evidence. The state will not be putting any of that in, and will not be putting any toxicology BAC in, and will not be asking the medical examiner about those reports. Thank you, Judge.
I don't want to restate my position, Your Honor, but I would like to address the mini trial. We don't need a mini trial on this, Your Honor. The defendant needs a fair trial, though. He's entitled to that. And for her to come up and say he has a diagnosis and that THC use by a person with that diagnosis does not create a mini trial. It creates a cross-examination. The state is threatening the court with a mini trial.
I'm hearing from both sides. You're throwing out. Let me direct you to your statement that said basically what McWilliam says. If I decide something different than what you just said, that's reversible error.
It is.
Listen, stick to your arguments.
Sure.
I'll listen to them. But let's not talk about either side threatening the court with whatever may occur. You all are advocates. Go ahead and advocate your position.
We gave the state our brief on this issue with McWilliam cited in the brief. State's had plenty of time.
All right, there are really two separate things that were just raised, one of which actually I don't think is briefed. The first is the issue that's brought up by Dr. Kelly Kaufman's potential appearance in this case. So let's address that first. Defense had filed a response to the state's motion in limine, addressing specifically the second toxicology report. Wanted to demonstrate that the presence of THC in the absence of Zyprexa, I think I'm pronouncing that correctly. You are. Talking about that. Now, that theory of admissibility derives itself from the gateway diagnosis. And there's no way to get past that. because it talks about, effectively the testimony, we talk about the combined effect of THC and Zyprexa. The gateway records have been excluded, and the court finds that the defense theories flowing from those gateways, or from the gateway diagnosis, would be inadmissible. And I've written down what Dr. Kaufman was going to testify to. That's in the record, I think was repeated accurately here. I did, in my notes, put in that, at least based on where I thought we were with this before argument, that really the thought-provoking side of this is this theory that is out there about alcohol and the lack of alcohol. What I'm hearing is that the state doesn't intend to go down that road, so that is not something the court's going to need to address, understanding that that is not an issue in the case. The other part of this, which I think I heard the defense argue, is that somehow the THC is just relevant on its own.
No.
Okay, I just want to make sure I was clear about that. I thought I heard a second argument in there.
No, it's not. It's relevant with Dr. Kaufman's findings. The gateway records, Your Honor, are documents of statements by Mr. Arbery. They're also observations made. The conclusion of his diagnosis, that may be by the RN and the PRN there at Gateway, but those records are a repository of observations and statements made by Mr. Arbery and then taken into consideration by Dr. Kaufman. The court has not allowed us to put up Dr. Kaufman yet. We have tried to summarize for the court, but we still intended to make a record through Dr. Kaufman of why she came to her independent diagnosis. So to say that you've already found that the diagnosis made by the nurse at Gateway now would preclude it, we would say to Your Honor, you need to still hear from Dr. Kaufman. She has much more education, much more information than the folks at Gateway did, and her diagnosis is firm. And so, but it would be, Your Honor, as Your Honor's pointing out, it's not just the presence of THC. It's unique to a person who's been diagnosed.
The court issued an extensive order on the mental health records, the Gateway records, and to me this is an additional layer to that, yeah, based on the court's prior findings and my understanding of what this particular evidence would be used for, that motion to eliminate is granted. You know, I may have reversed on the use of force. I think I said it was, the motion was denied. I'm reversing myself here. It's granted. It's the state's motion. So just to clarify the record on 4.68.
Is the court going to prevent us from getting into the autopsy and the findings of the autopsy and the results of the lab tests that were done? I understand the state's motion in limine is about that THC can cause aggressive behavior, etc. Is the court going to prevent us from asking about the full autopsy that was conducted and all the findings of the autopsy, included that toxicology was ordered and all of that, based on what the medical examiner did?
That's why I was asking whether or not that's the second part of that argument that I thought I heard.
Yeah. No, we're not arguing that the presence of THC in of itself has a factor to aggressiveness.
Well, no, that wasn't what that the presence of THC is relevant in some way to this case. That was the second argument that I was referring to.
Yeah, I understand. I understand what you're asking. I'm just asking, are we allowed to get into all that was conducted to the autopsy, that they did a toxicology, that they sought that kind of information, or is the court going to prevent us from asking any questions about findings in the lungs or doing toxicology?
What I understand is that the level of THC in the toxicology report is, and my brain's not working right now, but there's no expert, nobody that can explain what that level, what is it, 0.3 or 3 nanograms per milliliter, whatever the number is, what that means or what it is.
Except for our expert.
Okay. Your expert's going to come in, but your expert, you're saying they're coming in to testify that that amount, when combined with the lack of another drug in somebody in the mental state that she has decided forensically he was in, it has some sort of potential effect.
Yeah, the presence of THC.
That's what I've ruled on, is that's not all coming in.
I understand.
Okay. Now, the second level, which is the second argument that I was asking about really, is so the THC is out there. I understand nobody's at this point able to come in to say that that has any known effect at that level in this particular individual. Is that a fair?
Absent the connection to mental illness, right. Yeah, there's not an expert that we're going to present that would say at this level in just a typical person it could cause aggression.
So
That's correct.
what I need to think through, and I'll take under advisement, because what I understand the question really to be then is, if we go through the autopsy and the toxicology reports are out there and it shows that there's this THC, is the court not going to permit the toxicology report in that has that level? I guess that depends in part on what position anybody's taking on it.
Or the absence of medication. I mean, these are things that were investigated. There's a reason that the medical examiner's office investigated this, Your Honor. There's a reason that they wanted to understand this, but the court is going to be shutting us down because these medical... Yes, sir.
Okay, the court's ruled on the mental health side of it. From what I understand, the GBI was interested in the issue, and so they followed up. That doesn't necessarily mean that it's relevant at trial. This was the follow-up. So a second toxicology report was done, showed an absence of a particular drug, and because it was from what I understand from the briefing, a more involved, it brought up a small amount of THC. I don't know what that small amount of THC means. So maybe before I get to the point where I make a decision about the toxicology report, someone can educate me about what, if anything, that means. And if it doesn't mean anything, and what ends up happening at trial is I end up hearing arguments to the jury, well, there was this, it's marijuana in the system, and it becomes an issue in the case. I've got to take all of that into consideration. That gets back into 401 and 403, which gets back to my point is, I think I did hear the second argument, which is we kind of want that THC number to be there. We want the toxicology report to come in because it's part of the autopsy.
Well, I also, we're not trying to seek evidence for inadmissible purposes, but here's one of the issues that I'm asking about now. The medical examiner has an interest in understanding what happened at the time of conflict and dives down into the body of the decedent to understand what could have led to the conflict. The court has said, I'm not letting in evidence that this young man had a mental illness or was diagnosed as such. The medical examiner was interested in that.
Well, I understand from the briefing that Richard Dahl was interested in that, and he asked for the second toxicology report. He's not the medical examiner.
No, we've talked to the medical examiner. The medical examiner has an interest in understanding whether this gentleman was on medications or not.
Stop for a second. I'm not going to go further down here.
Okay.
The medical examiner in the original autopsy didn't do this. He was asked for the second toxicology report. He could have, and if he's not the individual that requested it, he didn't. There's now the report.
I'm talking about Zyprexa as well. He asked for Zyprexa.
I've already ruled upon the first part of this.
Okay.
That's not coming in.
So I
The
guess what we
second
would
part-
need to do, I'm sorry. I understand the court's ruling.
I've already said, the second part of it is, apparently, we're going to run into some debate about this toxicology report.
Right.
I guess the first thing to do is let's talk about it, because I don't even know if it's coming in. I don't know who's going to get it in. And then if there's an issue there, I'll see if I can address it.
Okay.
But this is a motion in limine. The motion in limine was specifically related, as I understood,
Right.
to this expert's opinion that touches upon some of these gateway records. I've ruled on that. That motion was granted.
I understand that very clearly.
Thank
So
you.
my point of inquiry was whether we'll be allowed to dive deeper into the autopsy and things that the medical examiner was interested in, like the gateway records, like the Zyprexa or absence of medication for the diagnosis. Those things, if in the court is essentially saying, no, we're not going to let you talk with the medical examiner in front of the jury about the medical examiner's interest in understanding those issues for the purpose of trying to make a conclusion during the course of the autopsy, then we just would need to make a record of that with the medical examiner. And perhaps it'll become more relevant at that time and the court would change its mind on prior rulings. But I think I understand you're going to prevent us from going into toxicology. You're going to prevent us from talking about corroboration of THC use, excessive THC, unless perhaps we can come back and educate the court on THC use in of itself causing aggressive behavior, confrontational behavior, outside and isolated from mental illness diagnosis.
I've
That was
ruled.
my question to the court, and I think we've
The
worked
court's
it out.
ruled. The court granted the motion in limine. So
That
at this,
was for that one issue, but we're also talking about other things that were done. So I thought I'd bring it up.
I would caution counsel, the court has ruled, made very clear in a very long order,
Right.
looking at 401 and 403, other relevant statutes and case law, where the court is on the gateway records and the mental health diagnosis. I would suggest that's a starting point to educate counsel on where the court is on those records. I've also now ruled that this other way of getting to the records, which is through the testimony of a lack of substance and presence of a small amount of THC, that's out. That's not another way that the defense is going to use to get to the gateway records. The court has an extensive order on the matter.
It's just a separate issue. It's not another way to get to backdoor. This is a separate issue dealing with aggression and primary aggression. That's all we're trying to make a record of, Your Honor. I understand the court's order.
Well, let's go ahead. Let's just go ahead and take a 10-minute recess. The next matter I have is 4.71, this motion eliminated from the state regarding probation. Probation.
Thank you, Judge.
Please be seated. All right, we are back on. Defendants present, represented by counsel. We'll keep moving through the various motions. Next one I have, as I mentioned, is the motion labeled 4.71, State's motion in limine regarding probation from the State.
Thank you, Judge. Came to the State's attention via conversations with defense counsel that defense counsel wished to just have the State stipulate that Mr. Arbery was on probation, not what he was on probation for, but that he was on probation at the time of this incident. And Mr. Rubin and I had a discussion about that, and I'm sure that they will correct me if I get this wrong, but my understanding is that they wish to put up evidence of his status on probation as to go to what he was thinking. In other words, he knew he was on probation, so when Mr. Albenze saw him and he's on the phone under the tree across the street calling 911, that Mr. Arbery somehow saw Mr. Albenze, and that Mr. Arbery's thought process was, hey, I'm on probation, I'm in a house I'm not supposed to be in, it's open, it's under construction, but some guy's across the street on the phone, and because I'm on probation, I need to run away. And that's why he takes off running very, very fast down the street into the neighborhood, not out of the neighborhood, but further into the neighborhood. And then again, that he chooses potentially to, as the defense keeps saying, attack Travis McMichael because he knew the police somehow were on their way, potentially, not sure, given no one in this case has ESP or the ability to read minds, but somehow he knew the police were on the way because he saw Mr. Albenze on the phone, and because he's on probation, as opposed to getting arrested by the incoming police officers for probation, he's going to engage in an altercation with a guy with a shotgun. And that because of his probation status, that would be the actions that he would take. The court's prior order on 404B other acts, and his status as a probationer was excluded with that order. However, Your Honor, I went back and looked at the order, the complete order, and there's actually nothing that specifically addresses his status as a probationer, because the order was about his other acts, and I don't believe when I looked back at the order there was anything that said his status as a probationer is excluded. The State assumed that his status as a probationer would fall under the rubric of the exclusion of the 404B other acts evidence. However, it isn't there. So that's why the State, out of an abundance of caution, wanted to bring this to the court's attention and request that the evidence that Mr. Arbery was on probation at the time of the homicide be excluded, as it's impermissible character evidence that doesn't fall under Rule 401, relevancy, and it would violate, in the State's opinion, Rule 403, as it's far more prejudicial than probative, because we're back, according to the defense's motion, and Judge, this morning I received an additional motion from the defense that also kind of addresses this, but what they're saying is there's alternative explanations for why Mr. Arbery did what he did, and we're entitled to explore what he was thinking. Even though he's deceased and can't defend himself and can't tell us what he was thinking, we're going to speculate as to the fact that he knew he was on probation, so therefore he must have been thinking, I'm about to get arrested for a probation violation, because that's what's going on and that's why I'm running away. So that's really what the defense's response here is that the court should deny our motion, basically based on they're claiming that it's not being offered for an impermissible character purpose because the evidence is relevant to the theory of the defense. Well, the theory of the defense is they were making a citizen's arrest, and the theory of the defense is that they had to act in self-defense. Mr. Arbery's thought process, once again, completely speculative, as to what he was thinking and why he chose to do what he did, goes right back into this speculation situation of, well, he was on probation, he knew that, so he probably took those actions based on a desire to not have his probation violated, all of which there is no underlying evidence for because Mr. Arbery's deceased and we can't ask him, and he never made a statement about that. We can't get to Mr. Arbery to say, Well, were you thinking you were on probation? Is that why you were running away? Oh, is probation the first foremost thing in your mind? So that is the problem. They cite to some res gestae, which of course, as you know, is inapplicable here. That concept of res gestae is out. It's hearsay under the first parts of Part 1, 2, and 3 under 804.
You're talking about Thomas and Mills?
Yes.
Those cases.
Right. And the McMichaels show that Mr. Arbery's probationary status on February 23rd is admissible because it's intrinsic to and inextricably intertwined with the events that took place on that day. Once again, the state will just restate its argument that it made with the 404B hearing, that it has absolutely nothing to do with their defenses, and his status as a probationer has absolutely nothing to do with what he did on that particular day. It would be speculation to go into what he was thinking based on his status as a probationer. And at that point in time, Judge, we ask that this fall under the same heading as the other act's evidence, and that you exclude any evidence that he was on probation. Thank you.
Your Honor, Mr. Sheffield and I are going to tag team this one because we have different responses. And I'm going to start at the end, and he'll come in and go back to the earlier response we made to State's 4.71 motion in limine regarding probation. In that one-page motion, they say in the third paragraph that the defendant's true intended use of the victim's other acts was to engage in speculation as to why Mr. Arbery acted as he did. And just this morning, and I don't know if anybody's had time to read it or absorb it, I filed what I would call a supplement to our response, I suppose. And that's the only part I'm going to talk about, and then Mr. Sheffield I'll tap out and he'll take the first part. I can give you one. I emailed one to Your Honor this morning, or maybe this morning or last night, but I think I've got an extra one.
I apologize. I have no idea what Mr. Hood's talking about.
Okay.
Well, I emailed it in response to an email from the state, and Ms. Dunikoski's email gave me an auto response that you were out of the office, which I am aware you are here in the same room with me, but I didn't know how else to email her back. Her email came to me, so you've got an auto response thing set up on yours, I guess.
Okay, just so that we're clear then, what I understand is we're about to argue something that was filed. I haven't printed it out, so let me look in my email.
Well, and I can say this, I mean, we can argue it, it's pretty simple, really. I mean, I don't even need to have filed anything, actually.
So, 8:09 this morning is when it looks like it came into my office.
Right.
Okay.
I finished writing it this morning. But it's just it's not even a required motion. It just supplements what we'd already filed. And my stating here in just a moment what's the substance of it will be sufficient for everybody to follow and track the argument. Because here it is. I go back to the state's motion, and they say that they think that our true intended use of Mr. Arbery's probation status on February 23, 2020. And Your Honor, if you like, I'll wait and not talk until you've had a chance to read it.
I mean, let's get it on the record. Go ahead. It's not as simple as that.
I can do either. I can state it, or I can wait and let everybody read it and then state it. But I would like to argue it with everybody's full attention.
Was there a reason that we waited until now to do this?
I didn't have to file it at all. I could have made an objection or done it at trial. This is a courtesy, actually. I think it's to help.
It's not a courtesy of the court to email an argument at 8:09 in the morning and then expect us to get up to speed with it, including not assuming the state, let's just be clear about it, particularly while we're in trial here. Just because you send something at 11 o'clock at night doesn't mean that everybody's going to have an opportunity to read and digest it, and that applies to both sides. I've gotten a number of things late at night or first thing in the morning. I'll tell you, it's not going to be an effective way of getting the court up to speed with the arguments. If you want to go ahead and make the argument, I'll listen to it. I'll try to process it. But and I think it was the first day of trial, I think I indicated to everybody that I don't believe it's appropriate for parties just to file something and assume everybody knows what's going on. So if the other party says I need a little bit of time, I'll give them a little bit of time. But until that point, particularly on a motion to eliminate, none of this gets discussed. So if I have to spend some time digesting, or the state needs time to figure it out, and we get into opening statements and this has anything to do with opening, it's not going to be talked about because it's an issue before the court.
Well, I'm not sure I'm tracking. Here's the position I'm trying to state
Hold on a
to you.
second. How can you not try it? We received this at 8 o'clock in the morning. If this brings up issues that the court needs to digest and think about and work through, I'm going to do that. The state, literally, as I understand it, is now doing exactly the same thing. We plan to open tomorrow. We plan to get to opening statements tomorrow. If this is something, and I'm not suggesting it is, but I'm just telling everybody generally, if this is something that the court's going to have to take some time to work through, in addition to the arguments that have already been made by Mr. Sheffield in his motion, then I'm going to do that. And until I have done that, everyone must assume that the matter is under advisement and it won't be discussed.
Well, here's why I call it a courtesy. I didn't have to file this, and I could have done what I'm...
And I appreciate that courtesy, but this still would apply. If it's a brand new argument and everybody's got to work through it, then I've got to take the matter under advisement and work through it.
Well, I could easily just go ahead and withdraw this and do what I plan to do in opening statement when I hear the state do what I fully expect the state to do, because I will be on good grounds to do it, and I will do it. And if the state objects and the court needs to then take a recess and send the jury out and rule on it, that's okay. I just did this so you wouldn't have to do that.
I'm not sure how you became antagonistic on the court's. I'm simply saying if I get something at 8:09 in the morning and haven't had a chance to digest it, then... Well, I don't understand that, because you've also indicated you're willing to argue it. I'm willing to hear what you have to say. I'm simply telling you how I'm approaching it. I'm not suggesting you can't argue the matter, or that it's not
I thought you
before the
wanted
court.
to read it first.
If I may, it's a little bit after 11. We normally take our lunch break a little later, but...
Yeah, let's do this.
Oh, okay, all right.
I'll argue, Your Honor, it's not very complicated. So, is the court ready to hear me argue it?
I'm here.
All right. All right, as I was saying, the state wrote in its motion in limine that they think that our intent to talk about Mr. Arbery's probationary status is to engage, and these are their words, to engage in speculation as to why Mr. Arbery acted as he did. Now, the act in question is his manner of locomotion, his running. The state has repeatedly throughout this case characterized that locomotion as running or jogging. Now, when you look at somebody in that act, you don't know why they're doing it. If you see a runner go past your window running, you have no idea what is motivating the person to run. It could be health, exercise, fun, or it could be fear or running from something or someone. The state has consistently taken the position, and I anticipate will do so starting tomorrow in their opening statement, that Mr. Arbery was an avid runner or jogger or both. Jogging, as we all know, is just a form of exercise engaged in by people who run at a moderate pace for health. And that's what, in fact, many of their witnesses on their witness list, as we've been able to uncover by talking to them, are prepared to come and testify to. Your Honor, if you want to read it, I'll stop talking. I don't think people can do both at the same time. I mean, I'd like to either have the court's full attention or stop and let you read.
You have the court's full attention.
Okay. I couldn't tell that I did. I see your moving pages.
Okay. Mr. Hogue, I'm not sure what you're trying to do here, but
I just want to make an argument to the court with your full attention.
okay, the court is listening to your argument. I am going through the brief that you filed so I can follow and pick up in the brief these arguments as you make them, so I can see what facts you're relying upon, what case law that you have, just to make sure that I'm clear about the argument. So to the extent that you are not having direct contact with the court eye to eye the entire time you're arguing, I apologize if you think that that is the court's inattention. But in fact, what I'm doing is what I do with just about everybody that's argued in front of me, which is, as you're moving through your argument, I am moving through my thoughts. I'm trying to figure out where the arguments are coming from, what citations you have out there. That's the court's process. You may be offended by the court's process, but that is the court's process. You can continue.
I'm not offended. I just know that when I'm talking to my wife and co-counsel and she's reading something, I will stop and let her finish reading so that she can listen to me. And I do the same for her as a courtesy to her. Because actually people can't do those two things at once.
Mr. Hogue, this is the second time you've suggested to the court that I'm not being courteous to you. I'm not sure what the issue is. I've explained what I'm doing. I don't think I need to explain any further other than to say this court is spending a lot of time working through issues presented by the state and the defense and doing everything that it can to ensure that this is a fair trial and that the issues that are presented are ruled upon to the best of my ability. And I will continue to do so in this case. If you wish to make your argument, you're welcome to do so, but we've spent a lot of time not on your argument in the last 15 minutes or so. I'm more than happy to hear the argument, read the brief, take it all into consideration as the court would normally do, and make a ruling.
I'm asking the court if it would do those two things one at a time. I mean, I don't mind sitting down if you want to read.
Listen, if you're going to abandon your argument, you can abandon it,
I don't
or you can
abandon
present
it.
your argument.
I'm not abandoning
Go
it.
ahead and present your argument.
All right. So, as I was saying, when a person is running and we see the person running, we have no idea why, what's motivating the person to run. The state has consistently in all pretrial motions and comments on this case, and I anticipate will do so again tomorrow in opening statement, and throughout the case when they call witnesses to talk about Mr. Arbery's penchant for running, will characterize that running as motivated by a desire for health, exercise, pleasure, and so forth. That is what they will inject into the case. Now, on February 23, 2020, that will be a speculation by the state concerning Mr. Arbery's motivation for running that day in that place. It's an inference they may draw from the other evidence they may try to present that he was an inveterate runner who ran all over the place all the time. They may even try to say that he ran in Satilla Shores regularly. I don't know that they'll have any evidence to support that. But at any rate, Your Honor, their point to this jury will be that when he was running in Satilla Shores on February 23, he was doing so for pleasure, exercise, etc. Now that is a speculative inference they've drawn and will continue to draw to the jury. Mr. Arbery's status on probation provides a reasonable alternative view, a reasonable alternative belief that can be formed, that we could argue, that says, well, they could be right. He may have been running there in Satilla Shores for exercise and pleasure, but let's tell you another explanation that's equally, if not more, reasonable. He's on probation. He's inside the English house. Matt Albenzi sees him in the house. All of this is on video and will be testified to. Matt Albenzi then picks up his cell phone and calls the police. And Mr. Arbery comes out of the house, sees him, Mr. Albenzi, and immediately turns to his right and runs at a sprint. 5 houses up the street is Mr. McMichael in his driveway, fixing boat cushions in the bed of his truck, using his truck bed as a workbench. Sees Mr. Arbery running past, and as we all know, Mr. McMichael's colorful expression for what he saw was that he was hauling ass. And he said he wasn't out for no Sunday jog. He was sprinting. He looked like a wide receiver. These are things he said as he noticed him. Now, obviously, he didn't know he was on probation, and we're not arguing, at least I'm not right here now, that Mr. Arbery's probationary status is relevant because Mr. McMichael knew it. He didn't know it. But when the state says he was running that day for pleasure, and Mr. McMichael sees a person running and he thinks he's running from something, being chased by someone, as he told the police that day, then a reasonable alternative explanation could be, well, Mr. Arbery's running because he's on probation. He's been spotted at the least trespassing. At the worst, back in a house he'd been in 4 previous times where burglaries had occurred, in a neighborhood where other burglaries and break-ins had occurred. And so when he was running at this sprint, not a Sunday jog, and continued to run until the end of this tragic scenario, a reasonable alternative explanation for that running could be, well, he's running because he's on probation. He sees a guy who's just had a cell phone to his ear, possibly calling the police, which in fact he was. And therefore, Mr. Arbery, who had had his probation revoked 2 times before, for which he'd spent time in the county jail, did not want to be caught trespassing or caught and interrogated for previous entries into that house where burglaries had occurred. And so when the state says, no, he's just out for a Sunday jog, we ought to be able to attempt to rebut that by offering an alternative explanation. It does not go to the mental state of the McMichaels. And I'm not arguing that it does. I'm arguing that it is an answer that the jury should have before it so they can determine why he's running, not just because the state says he's out for a Sunday jog. Let the jury decide which it is. We want to be able to give this alternative explanation. That's the argument that's in this short motion, and I leave it there and tap out for Mr. Sheffield to take over.
Thank you. I concur with that. On behalf of Travis McMichael, essentially what we're talking about there is opening the door to the intent of the running.
Covered here in the motion that
It is. Yeah, that's why it's a simple issue. I hate that we got sidetracked. The And, Your Honor, we're going to continue to do our best to put issues in front of this thoughtful court in a way that gives the court time to wade through these tricky issues, because we really are dealing with the type of evidence that the rules of evidence say under 401 it's relevant, but the court well knows, the state has argued against it, that it can dip into 403 but still be admissible relevant evidence under 401. So we understand the court is walking a fine line and trying to interpret. In addition to opening the door that the state has done repeatedly, and we believe will do during trial on this issue of running, it is intrinsic, not in the minds of the McMichaels, but it is intrinsic that this young man is on probation and has been jailed for failure to adhere to probation conditions by committing new crimes and by not reporting, and has been punished for that. He is currently on probation at this time in 2 cases, and he has a long-standing relationship with the probation department for those failures. And so under the cases that we've cited, those courts note that when the defendant in that case, the one who's actually on trial and risking going to prison, the state was allowed to introduce evidence that the probation was there and relevant, because if he indeed, quote unquote, ran from the police because he was on probation, that showed his motive. So we do get back into the motive and the intent of Mr. Arbery, not as an extrinsic element, not as a 404B, but as an intrinsic element to his life and circumstances at the moment that he chose to run. Now, the video very clearly shows that Mr. Arbery did not run into the neighborhood. It very clearly shows that he walked into the neighborhood, that he stood in the front lawn, that he looked left, looked right, looked forward, looked backwards, and then went into this home. And when seen and observed by the neighbor, he is running out of that house at a rate that is more than just a jog. The evidence will also show that he was informed, in fact, that the police were on the way, and that created more running and turning. And so we feel that we have a substantial basis for the jury to learn that he is running to avoid being arrested. And those cases that we cite, I think, are very clear. So obviously we join in the open the door, but we also feel this is intrinsic. And these cases, clearly, as used against defendants, make that type of evidence relevant. Thank you.
Final word from the state.
Thank you, Judge. That was quite a lot of speculation about what the state was going to argue in this case. An opening statement. Mr. Arbery was an avid jogger, and under the rules of evidence, especially OCGA 244406, habit and routine practice. Evidence of the habit of a person or the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, is relevant to prove that the conduct of the person or organization on a particular occasion was in conformity with such habit or routine practice. So, Mr. Arbery, being seen by people who live in Fancy Bluff running, indicates that he's an avid runner. In addition, the state has no intention of putting in that he was only running for his health, only running because it was good for him, or anything along those lines. We actually have evidence in this case that was put forth through Larry English's testimony on December 17th. The third video from Mr. Arbery going into the Larry English open, unsecured construction site is that Mr. Arbery steps outside, and you know what he does? He runs, and he runs away, and he runs onto the street and out of the frame. So there's actual evidence that when he was in 220 Satilla Drive, that when he left after staying there a few minutes, he ran away into the neighborhood, the exact same path that he took on February 23rd, 2020. And that has already been and will be testified to by Larry English. So the defense appears with this probation argument to try and go and skirt the court's order about the 404B evidence in a way that is speculative as to what Mr. Arbery was thinking, because this whole argument that we want to present an alternative reason for him to run away, Judge, I fully expect the defense to argue, yeah, he got spotted by Albenze, he was committing a crime, they'll figure out what that crime is and tell the jury, I guess, and that he was running away because 911 was on the way, because he has ESP and can tell that Albenze's not on the phone with somebody else, but is on the phone with 911, and that he took off running. And I'm sure they're going to argue that. And the fact that Greg McMichael didn't know any of that Travis McMichael was inside that house on his sofa, that Mr. Bryan, at the time that this all took place, was fixing the front of his house, makes it completely irrelevant as to why he was running down the street. Greg McMichael's words say it all. I saw him run down the street, he was hauling ass. And that's all the McMichaels knew. So what was, again, in Mr. Arbery's mind when he did this is completely irrelevant to Greg McMichael running inside his house, getting his son, getting his gun, and getting that shotgun and getting in their truck and chasing after him. Because what Mr. Arbery was thinking at the moment he saw Mr. Albenze, they didn't even know that took place. So this appears to be, from the state's position, just a backdoor way to try and impugn his character and go from there. Yes, he was on probation in 2 cases. Those 2 cases and all that information has been excluded as not relevant. In addition, the cases that they're citing to are obstruction cases. Okay, an obstruction case is when I see an officer who's in uniform. Okay, I'm on probation. I can tell this guy may or may not arrest me. He's a law enforcement officer coming at me. So when I run from him and charged with obstruction, of course it's relevant for the state to go, well, the reason he was running, he was on probation, he saw a law enforcement officer. So it's an obstruction case. So it doesn't really apply here, especially since the defendants had no knowledge. And once again, it's speculation as to what was going through Mr. Arbery's head. We ask that you, I'm trying to call it, my motions, I ask that you grant my motion to prohibit them from going into the probation. Thank you, Judge.
Very briefly, Your Honor.
So much for the court's instruction.
Well, if I may just respond briefly, I won't be long. Much of what the state just said, we don't disagree with. The fact that Mr. Arbery was an avid jogger, for example, that it was a habit and routine, for example. But what relevance is that to our case, that he had the habit of running, if not to make the inference that the state wishes to make, that that is what he was doing in Satilla Shores that day. That is what they want to do. And so the example of December 17th to support the habit theory that he's in the house and he jogs or runs away, well, it was at night. Nobody was there. He's on a camera that he doesn't even know is there, perhaps, and no one has seen him. The difference is what I described earlier that happened on the broad daylight of 2/23/20. So I just want to focus the open the door argument. The other argument I'll leave with Mr. Sheffield, but the open the door argument is that if they want to bring in witnesses to say he was an inveterate runner and that was his habit, that's fine, but that opens the door to other reasonable explanations for why he was running on that occasion. Because it's true that one can run on a given day or even at a given hour of the day for exercise, and then run on another day or another hour of the same day out of fear of being caught because he's on probation trespassing. Both of those can be true. And so it's not responsive to this argument I've made here to say that, well, he's an inveterate runner and we've got witnesses to say he ran all the time. Fine. But it's the inference they want to make that we want to be able to answer for the jury by rebutting it.
All right. Court's going to take the matter under advisement. I'll get a ruling out prior to opening statements. The last thing I had on the state side, 4.72 is a brief on character witnesses and opening the door to character evidence. I'm just going to take that under advisement. It's a brief. I think I've gotten something similar back from the defense. There was a, recently, I think, I just haven't had an opportunity to fully digest it yet, but something came back about opening the door from the defense.
Well, Your Honor, if I may, I was handed by my colleagues, and I think this is, we never titled what the brief was that we got at 8:09 this morning. I received something that I didn't receive it. I mean, I probably got it in my email, but at 8:09 I was here. So, defendant's motion for the admission of evidence pertaining to Ahmaud Arbery if the state opens the door at trial to the admission of such evidence.
I didn't read the title, but that is addressed to the probation matter. That was just argued.
Well, we used that motion, I believe, to address that issue, but there are other issues that we believe become relevant, Judge, under the umbrella of open the door. And the state...
There was actually a really good article, I think, recently. It was the Georgia Bar Journal or something that talked about litigation by motion in limine. Okay.
Cobb County judge, I believe.
Was it Cobb County?
Judge Manning.
Yeah, it was a fine jurist then out of Cobb County. I'm not going to do that. This whole idea of opening the door, I'm not going to prejudge the evidence that's coming in order to make a determination on opening the door and under what particular circumstances the door could possibly be opened. I'm not going to do that. Okay. I mean, I understand that the arguments may be presented that the door has been opened on something. I would suggest that if the door is currently closed, before you walk through it, we have a discussion with the court on that.
Okay.
But I've got these competing motions back and forth that start addressing these topics. And again, I don't think motions in limine are the appropriate time to do that.
And, Your Honor, if I may, that brief from the state was simply a way to keep everybody informed on what the state believes the law and the position of the law is, and to inform the court about the state's intention. The reason I did that is for what's happening here today. The defense has repeatedly told this court the state's doing this, the state's saying this, the state's going to do this, the state's going to do that. And I feel that I have not been able to adequately respond. So in this case, I did want to at least respond in writing to give the court what the state's intention with these witnesses was and to provide some law, and so that I could rely on that if it became an issue. And that was all I wanted to do, and I understand that this is a response to that. Now, my question, I guess, on this, the defendant's motion for the admission of evidence pertaining to Ahmaud Arbery if the state opens the door at trial to the admission of such evidence. Mr. Hogue, was that the brief that you were standing up here arguing and talking to the court about?
I did part of it.
Yeah. Okay. I just wanted to make sure I was on the same page. You didn't say the title, so I did not know, and I wanted to make sure I was looking at the same thing everyone else was looking at. So if that was it, then it's fine. And that is all that is. There's no need to argue it. Thank you, Judge.
Your Honor, for the sake of the record, we discussed it at the beginning of the first motion that we were taking up today about the use of force expert. We want to make clear we had adopted that motion. As to the motion regarding the THC, we wanted to adopt the motion that the McMichaels pursued, join in on that. And third, I think the one that's currently before the court is the probationary status in one way or another. We also want to adopt that. And I'm going to confer with co-counsel on if we have a lunch recess before the court rules, because I don't understand, maybe I missed it or was not paying attention, but there seems to be some case law fairly directly on point on this subject, which no one's discussed this morning. So I want to confer with them about that, and if there's something to bring to the court, we will.
Thank you. All right. Based on my notes, then, we move into the McMichaels' outstanding motions. First one I have that is still before the court. Let's see if I can get my numbering is right here. Looks like I've got, and it's actually couched as a motion associated with voir dire, but it looks like 5.7 is the motion to eliminate all doubt and a mathematical certainty language from the jury charge on reasonable doubt. I've got, why don't I go through and tell you what I have as open. I've got that. I have a motion regarding the vanity plate, a motion regarding Officer Duggan, hopefully I'm pronouncing that correctly, body cam, and the motion to seat all jurors in the jury box during the trial. Those appear to be the open McMichael's motions.
Your Honor, if I may, I think part of the big pot of State's 4.64, which is the State's motion in limine for a pre-charge jury, a pre-charge to the jury, and I believe then we had defendants 5.6, which was the defendant's response to the court's inquiry regarding a preliminary jury instruction. That was filed on September 1st by the defense. The state filed a response September 2nd, and that's part of the pot that I think goes with 5.7.
Okay, that makes sense. I'm just trying to track it. And maybe I skipped over it because I drafted a pre-charge, which I can get to everybody this morning. I just need to print it out and get copies of it to everybody, which included the requests for basic, and I use that term intentionally, pre-charges on certain aspects of the law that I understood from reading those submissions. Everybody had agreed they wanted a pre-charge on. So I've got that. I'll go ahead and get it. I'll get everybody a copy of that before lunch. Maybe we can address all of this then after lunch, once everybody's had an opportunity to review the pre-charge.
Yes, and that is my memory of how we did it. The state moved for pre-charge. You said, well, let's all just hear what we want in that, and then you'll consolidate it and make those decisions.
Yeah.
The only part of that that might be a little bit different is the 5.7 with respect to the reasonable doubt standard in the pre-charge as well as the final charge. So that might be one issue to litigate before we take a look at the...
Why don't we, it sounds like we can put the cart before the horse. I'll get you the pre-charge, and you can look at the language that the court is using. That language still appears in the pre-charge, so we still do need to argue it, but we can do that once the entire pre-charge has been reviewed, and we can just take it all up at one time.
Very good.
Okay.
Thank you, Judge.
So then I have the motion in limine regarding the vanity plate.
Do you want to do that now, Your Honor?
You know what time is it? 11:44.
Mr. Sheffield, and he thought we were doing the mathematical doubt and just stepped out.
Just stepped out.
That's it.
I was going to say, then we got the body cam, and well, why don't we go ahead and address the motion then with regard to the jury box?
Your Honor, do you know if that big TV right there is connected to the internet? And if so, I could pull up the current, as of right now, Glenn County. I've got the internet address in this motion, but I looked at it on my computer this morning, and the numbers have gotten even better. I see.
Are you talking about the Coastal Health District numbers?
Let me.
I can pull up the Coastal Health District.
Yeah,
numbers.
if you can pull them up for your.
I check them every day.
It's the COVID. Let me make sure. It's the COVID-19.gachd.org.
Yeah, I've got the Coastal Health District information as well as the state DPH information, which dovetails in.
Well, I just looked this morning, and my brief's already a little bit out of date. The numbers are even better today. I got the numbers up through November 3rd, which is yesterday.
There's been a uniform downward trend, which we had all hoped for given the nature of the case
Yes.
and the number of folks that we had coming in.
Well, so if you're ready for me to argue this, I will. In brief, the remedy we're seeking here is to have the jurors seated here in the jury box. 2, 4, 6, 8, 10, 12. There's 14, so we'd have to have 2 others outside the jury box, I guess. I won't repeat all the details that are in this brief concerning the importance of having a jury in the jury box. I think that's just something we all know well from being in court so many times over the years. As a practical matter, obviously, it would be so much better for all the lawyers, and I hope the state may ultimately agree with me. It would be nice that we all would like to have our jury right here, and we can just do our thing here in the well of the court like we are so accustomed to doing. So the way I see it, Your Honor, is that what we're doing is trying to balance 2 competing interests here. As many decisions in life are, they're a balancing test, and on the one side of the scale we have the defendant's rights under the U.S. Constitution and the Georgia Constitution. 5th, 6th, and 14th applied to the states for due process, the due process clause of the 14th Amendment itself, as well as the Georgia Constitution, Article 1, Section 1, paragraphs 1 and 2, regarding due process and a fair trial. On the other side of the scale, what we have in the balance is the health of the public, the health of these jurors in particular. And I acknowledge that to be a significant concern in this balancing test. And so the other part of the brief is addressing the current downward trend, fortunately, in COVID numbers here in Glenn County, suggesting that the scales could be tipping by now here in early November in favor of the constitutional rights of the defendants and the diminishing concerns for health risks to our jury. And I know that we have been here now almost 3 weeks with many people seated in the courtroom, many of us close together, not social distanced, not wearing masks even. Most of the lawyers and the defendants have not worn masks. Jurors could obviously wear masks if they're seated next to each other, and that would give them some protection. They would be closer than 6 feet, but they would have masks on if they chose to. I do note that yesterday when the jury was called into the courtroom to be told they're our jury, 5 of them did not have masks on. They were social distanced, of course, but they had chosen not to wear masks. And I think that should be left to their choice, unless the court ordered them to wear them, because if they were to be seated shoulder to shoulder in the jury box. So if the court's checking those numbers on the website, the court will see that they're going down, and that's good. In fact, we're down below, we're at 3.9 cases now, and as of yesterday, I think when I wrote the motion, it was at 4.7 cases for a 7-day rolling average, and 3.9 now is getting way down there low. I mean, we're in the area where it's getting just safer and safer to walk around and be in closed places like a courthouse for days at a time. Anecdotally, and I put this in the brief too, as the court knows, because of the scheduling issues that this court got involved in with another judge who presided over a death penalty case, I tried recently. I went to Grady County in late August the 24th, 2021, to start jury selection in a death penalty case. And we were in Grady County for 3 weeks selecting a jury up until mid-September. unlike you, Your Honor, the judge in that case never expected or required anyone to take any COVID precautions. It was very concerning to me, and I moved to continue that case many times because of that. And finally, we got that case to trial. And for 3 weeks in Grady County, where the numbers were many times higher then in August than they are here in Glenn County right now, we had jurors 60 at a time. I hear that too, and my hearing's not even very good.
Sounds like a radio outside the courtroom.
So we were in a courtroom where it was a large gallery area, and our judge called 60 jurors at a time and had them seated right next to each other in theater-like seats, and then broke them off into panels for us to do, like we've done here. We did general voir dire, and then we did individual voir dire, very similar to what we've just experienced here for 2.5 weeks. And over the course of that time, no one was social distanced. The courtroom was packed. Hardly anybody wore a mask. It was a bit bizarre, but we didn't lose any jurors to COVID. It was kind of amazing to me. We went back to Putnam County. We tried the case for 2 more weeks with these jurors seated in a jury box like this next to each other, and only 3 of them wore a mask. Witnesses came in and testified. It was a 2-week-long trial, and to my knowledge, and I've not received any reports to the contrary, amazingly, nobody got COVID. So I say that as an anecdote. Obviously, that's not evidence of what would happen here. I mean, somebody could get COVID here. Somebody could have it right now. But because of the diminishing numbers and the importance of trying this case in a normal fashion, I'd like to note, too, that if we have jurors seated back here behind us, where I see those numbers on the benches, and then we have family over here, family of the defendants, family of Mr. Arbery, and I think you had media on a row, and who else? There was one other row of people, whoever. That side, I suppose, would be filled with people shoulder to shoulder, while the jurors are the only ones that would be social distanced. So I just don't know how much difference that's going to make in our fight against the transmission of COVID. There's my argument, Your Honor.
May I just add to what Mr. Hope said, not repeat what he said, which he said well. Thank you. And I kind of assume the court's thought all of this through because you've been inundated with this public health information for a long time now. So I know you're thoughtfully considering all the options in the case on this issue. The 2 concerns with the way it's set up, or 3 concerns really. In opening statement tomorrow, I'm giving opening statement from Travis McMichael. I'm going to have to address both the jury here and the jurors back there the way it's set up, which means literally talking over the state's head, which is...
Won't be sitting right there.
Won't be there. Okay, so that's obviously we're missing some information here. The other concern and bigger concern is...
Well, and just to be clear, we're shifting a table because there's a number of issues there. One is potential sightlines. 2 would be your ability to use the area as well and address the entire panel. And 3, anything that's on the state's table doesn't need to be seen by the jury. So that table is going to be shifted to address all 3 of those issues.
Thank you, because that addresses my other concern, which is the way the jury is seated now, and Ms. Dunikoski and I talked about this, numbers 5 and 6 can see our computers. And not to mention people in the gallery, the press, the families can see our computers, and that's a real concern. And
that would be the case. Whether the jury was sitting there or not, there's always going to be people in the gallery behind. I'll go ahead and take a look at 5 and 6, though, and try to work through that.
Typically, though, in probably every case I've tried, the decedent's family is not sitting behind the defense side, they're on the prosecution side. And so we don't have that concern. I mean, it's another point of concern, plus the fact that they're seated shoulder to shoulder with what that does for the spread of COVID, if any concern at all. So these are additional concerns to what Mr. Hogue raised, and I would ask the court, or I would join the motion, ask the court to seat the jury in the box.
Anything from Mr. Shaw?
Your Honor, our concern, we very much appreciate the thought that's gone into the motion. Our primary concern is about the masks. Our contention is under the 5th, 6th, and 14th Amendments to the United States Constitution, the parallel provisions of the Georgia Constitution, that the defendant is entitled, and his counsel are entitled to be able to see the faces of the jurors during the trial. It's important that we have that ability. Part of what lawyers do during a trial is they try to assess the feedback, the nonverbal communication from the jurors during the jury trial process. It's been the way it's been since the foundation of this republic. Given the compelling health evidence that Mr. Hogue has presented to the court, our contention is whether we seat the 14 or 16 up there in the box, or we seat them as currently planned, we believe that we're entitled to have a jury that is not masked. And to the extent it impacts that process, and I know the court is dealing with, I don't know, probably maybe unprecedented to me at least, logistics issues and geography issues in the courtroom, and I appreciate that. But under the existing seating arrangement, the jurors can be socially distanced, and I was hoping that the court was doing that so that they would not need to wear masks. If they're going to be wearing masks, then we certainly think there's no reason not to put them all in the jury box. Because if they have to wear masks anyway, we might as well have them where we can all see them and not have this complication in terms of the presentation of the evidence. But our primary concern here, more so than the seating arrangements for the jurors, I'm curious about this table arrangement. So I'm not sure how that impacts us over here, but you'll tell us at a suitable time. But I am concerned that constitutionally, I think we have a constitutional right to be able to see the jurors in the jury room as the evidence is presented, to see them as we give our opening arguments and our closing statements so that we can see how they're reacting. If you're making an argument to the jury and everybody's kind of looking down or shaking their head no, or they're laughing when they're not supposed, smiling when they're not supposed to be laughing, then it's kind of a hint to counsel and maybe we should move on to something else. We are deprived of that nonverbal feedback when we mask the jurors. So that is our primary concern, and that is not a matter of convenience to the parties. That is a constitutional right.
One other concern that
I failed to raise, and that is that, obviously, any case like this, and maybe especially this case, is very emotional. And the proximity of jurors to the family members on both sides is going to be difficult, maybe influential, inadvertently. We would expect, as it's been so far, that we feel the emotion in the courtroom. We would expect it's going to only be raised during the course and presentation of evidence during the course of trial. And so we think that is also going to be difficult for the jurors to put that aside, and may in fact create problems down the road, which we would all want to avoid. Thank you, Judge.
Anything from the state on the matter?
No, Your Honor, we leave it to the discretion of the court. Well, the state doesn't oppose it, if that's what you're asking. The state does not oppose sitting the jurors in the box. Obviously, these are benches. Those are much more comfortable seats. I have no idea if the court will seek input from the jurors themselves. The state's vaccinated, so I have no idea how many jurors are vaccinated. I have no idea how many would want to wear a mask, want to be socially distanced. We don't know how many want to be in the more comfortable chairs. these are all things that can be considered, but the state does not oppose the motion.
Okay. A couple things. First of all, the setup of the court is actually the setup that was part of the Glenn County jury resumption plan. This particular setup has been used, I know, by Judge Scarlett in the adjoining courtroom, which is an exact mirror of this courtroom. And that's how cases have been tried in that courtroom. I'm not sure if Judge Kelly, I assume Judge Kelly's probably tried some cases in this courtroom, but I don't know. But I know that the exact setup has been used in Glenn County for jury trials, including, I would imagine, some significant felony cases. So we're consistent with that, from what I understand. Okay, again, I'm here from a different circuit, and so I'm adopting this circuit's plan, and this is where we are. I have reviewed the plan, or reviewed the setup, and tried to work through exactly what some of the issues are, and we're still, well, I think we're most of the way there. This juror 5 and 6 issue is something I appreciate counsel brought up. I need to work through that. But the bottom line on the changes, first of all, CDC guidelines are still in place. What may have happened, and Mr. Hogue said this, it's anecdotal, what may have been done in Putnam County, that's up to that particular jurisdiction to determine how to handle what they do, their business, and their particular approach to cases. But CDC guidelines are still in place. I think it's important, and important enough where the Supreme Court, when the Supreme Court was issuing its emergency orders, pointed out a number of times, we've got a unique set of circumstances when it comes to jurors. When we suspended jury trials, part of the calculus in that was that when we have jury trials, we are compelling members of the public to do their public service. We are not asking, we're not inviting, we are ordering people, a cross-section of the community, to come into the courthouse and do what we ask them to do, which is sit as a panel and listen to the evidence. In order to do that, they need to be comfortable. In order to do that, they need to be able to sit wherever they're sitting and listen to the evidence without in the back of their mind thinking, oh, that person next to me who is shoulder to shoulder just coughed. And I just use that as an example. There are other examples I could come up with. And so the reason that this court plans to adhere to social distancing at this point is, one, CDC guidelines are still in place. The jury plan was enacted in this circuit and has been used. We are compelling these jurors to be here for an extended period of time. What the rest of the public does in this courtroom and what you do in this courtroom, I have not gotten involved with, because I'm not, other than the fact we're having the case and I'm telling you when to be here, it's very different from how a juror is appearing. The members of the public that are here, the media that are here, I'm not ordering them to be here. If they want to sit in this courtroom under the restrictions and the circumstances that we have, that's up to them, but that does not apply to the jury. And the court has to take that into consideration. And the jury is a significant, if not a priority for the court, to ensure that they are able to do the very important work that they are doing without distraction. So that is why we are here. As to the numbers, I agree they're coming down, but the transmission index, we can pick out whatever we want from CDC. But in my discussions with the Public Health Department, it was suggested that the transmission index is probably one of the best indicators of where we are. And because the numbers are trending downwards, that transmission index is getting lower, but it's creeping lower. It's still in the moderately high category for Glenn County. Glenn County was ravaged with COVID no more than a month, 6 weeks ago. Those numbers were extraordinarily high in this community. And so I can't imagine it's still not at least a concern to some that are coming into this courthouse. So I say all that because there are other things that I'm going to look at based on what was discussed, mentioned. I guess it wasn't really a discussion. It's more of a presentation presented here. I'll consider the motion, but based on where the numbers are currently, the jury plan and the CDC guidelines, I have not seen any evidence that this court should deviate away from the circuit plan at this point. We may modify a few things, again, based on some of the comments made.
Just for the sake of the record, I very much appreciate the thoughtfulness of the court in all of this. The three courtrooms are close, but I would not agree to be on the record that they're identical.
It's effectively a mirror of what we've got here.
Well, I can remember, for example, at least for some years, if not still to this day, the witness chair in one of these courtrooms, the original courtroom for Judge Williams, sits ahead of its original location because an issue came up as to the ability of the counsel and the attorneys to see the witness in the witness box. And I'll just see you. There's a history here. We also have historically had issues as to whether counsel or defendants can see the witness, sometimes I think it was a witness, in the jury box. I can remember in the middle of a trial with an especially short client, shorter I believe than Mr. Bryan, sitting in here having my investigator take measurements and put them in the record. So I wouldn't be, I'm just cautioning the court, I wouldn't be so quick to rely on the fact that because other people and other judges in Glynn County have conducted court in these facilities that you should necessarily assume that meets all constitutional or other requirements. Because that has been an issue at times in the past.
I didn't say that. I just said that they were trying cases consistent with the circuit jury plan. I know Judge Scarlett's tried cases over there. In fact, he's got plexiglass up. So there's even more protection. Well, we could debate what plexiglass does, but there's more outward signs of protection in his courtroom. And my point was simply it's a mirror. It's a similar setup. So I'll continue to work through this probably up to the point that the jury is impaneled and probably even through the trial itself, just to make sure that we are doing this appropriately and effectively given the unprecedented circumstances that we are trying the case with regard to the public health issues that this community has experienced.
Judge, we did begin to discuss with the Sheriff's Department this morning, albeit not at the highest level, but whether there would be, as an option, as we're working through this, some kind of a barrier.
I heard that as an idea, and just hearing it and processing it, I understand it. It makes a bit of sense. How effectively and efficiently that can be addressed, there's other things I need to check on.
I'm willing to help build whatever it is.
Okay. All right, it's probably a good time to break for lunch. Let's see, it is 12:09. Let's plan on rejoining at 1:15. If y'all could give me a moment to print out the preliminary charge, and then you're welcome to come back maybe 5 minutes or so and grab a copy of the preliminary charge.
Yes, Your Honor, and one of the things that Mr. Sheffield and I had discussed in regard to defendant's motion in limine regarding Officer Duggan's body cam video, I have prepared a jump drive with that video on it, and I think both parties agree that it might be more prudent it's only 7 minutes long, and the front part is about 3 minutes long, that I believe is the part's contention. If the court wishes to look at it in camera, because of course the court's going to have, us describing it isn't going to do the court any good. So I wanted to put on the record, and that was handing you a jump drive that has Officer Duggan's body cam video on it for an in-camera review. Is that correct, Mr. Room, Mr. Sheffield?
That's correct.
Yes, Your Honor.
Just a thought before we adjourn for lunch?
Well, I'm making sure there's consent that the court review the video and camera.
Yes.
Okay. And I have been handed a jump drive, and that's the only thing on the jump drive.
The only thing on the jump drive.
I think the court will agree that a lot of progress has been made this morning on the remaining matters before the court. We haven't even really begun to discuss the charge issues. I'm just throwing it out there for the possibility to consider whether we might inform the jurors that we might want them at, say, 11 or 12 o'clock tomorrow for their opening statements, because I just have a feeling that we're not going to get through everything we want to this afternoon. But I'm just throwing that out there because I know the look I'm going to get if I come up at 4 o'clock and say, now it's time to call the jurors. Just for what it's worth. Putting them back a little bit would also give counsel, and I think Ms. Dunikowski might share in that desire, to have a little more time to be ready to do the opening statements adjusted to the court's rulings this afternoon on what's allowed. Oh, I stand corrected.
I fall into this same category back when I was on the other side of this bench. What I have found, Mr. Goff, is if we give everybody 4 hours, we'll take 6. If we give everybody 6 hours, we'll take 8. I'm not going to limit. I'm going to see how much we can get through today. I'm cautiously optimistic that we'll be able to address what needs to be addressed today.
You know me, Your Honor, I'm always a pessimist.
So I said I'm cautiously optimistic. All right, let's go ahead and we will be in recess until 1:15. So I'm guessing this microphone placement has worked better. Y'all have been able to hear me better the last couple days?
Yes.
Okay.
Usually, yeah.
Usually.
Yes, I've been able to hear you, and I appreciate it very much, Your Honor. I don't know whether it was brought to your attention over the break, but there was a lot of personnel, courthouse personnel in here. We're looking at the courthouse situation, and it was conveyed to me, and I'm just making sure it was conveyed to the court, that there is a concern that it is hard to hear most everyone, other than me and some other particularly loud person, that if you're sitting on the back two benches in the courtroom where the last couple of jurors would sit, that they can only hear two of the 20 million lawyers in front of the bar. And I'm not sure if one of the other people is you, but obviously if the jurors can't hear you, we're going to have a real problem.
That has not yet been brought to my attention. I will follow up on the acoustics and make sure I understand what may have occurred at lunch, because I was not involved. I was taking care of other matters.
There are turf issues in this courthouse, and the reason I brought it up is sometimes people feel that it's not their place to say.
The flash drive that I was given before lunch, I have reviewed. I'm going to give that to the clerk as courts 2.
I have one.
We had one.
And I think Mr. Goff had put some exhibits in. It may have become courts 2 about some of the photographs on that side.
But I saw it with this. I'm going to call this courts 10.
Very good.
This is going to be courts 10, and then we'll figure out which one we're in. Okay. I'll keep a list. How's that? Okay, so that's been submitted. The court did review the flash drive in camera, which was the Duggan body cam. All right. Defendants are all present, represented by counsel, and we are on. The court provided to counsel, right at the beginning of the lunch break, a proposed preliminary jury instruction. Well, the easiest way to do this is do it the way we would do it for a charge in a charge conference. So, from the state, any objections or exceptions to the preliminary instruction?
No objections to the preliminary instruction. The only thing I noted, Your Honor, was that on page 7, the third paragraph down, I instruct you, ladies and gentlemen. And then the fourth paragraph, again, to maintain the integrity of the jury system.
It's a little repetitious.
Correct.
Yeah, it's intended that way.
That's all I wanted to make sure, because it seemed like maybe it had been a cut and paste, but obviously it was intentional. All right, then no objection to the charge.
Yep.
Oh, I'm sorry.
That's good. Page 2, first line, the defendants are charged in the indictment with A crimes.
Thank you. With crimes.
Second paragraph, line 4, 3 into 4. This presumption remains with the defendant unless and until? I think unless and until are used together again.
I'll look at the actual.
Okay.
That is a standard charge. That's the language I think came out of standard charge.
And I just had a question about page 3, last paragraph. 1, 2, 3, 4, 5, 6 line down.
Okay.
They make motions regarding the conduct of the trial.
Correct.
Is that the right language?
Yeah,
Okay.
that's the direct
Just
language.
sounded awkward.
Yep.
Okay. Otherwise, nothing further.
It's different when you actually see it in writing, right?
Your Honor, I would ask that on page 2, the first paragraph, that it should read, "The defendants are presumed to be innocent, period." And then each defendant enters upon the trial of the case with a presumption of innocence in his favor. A presumption remains with the defendant, and we join unless and until overcome by the state, etc. Then we have a motion with respect to the last line on the third paragraph concerning all doubt or to a mathematical certainty. And then on page 5, there is a typographical error at the second to the last line on the second paragraph. It says "you missed" instead of "you must disregard it." Oh, this was just, I put this in, it helped me, and I think it might be an omitted comma. On page 6, second full paragraph, the third line from the bottom, "until actual deliberations begin."
Let me get there.
Actually, I'm on the
Second paragraph.
second paragraph where it's 4 lines up. "Until actual deliberations begin," and this part's fine, that is, until after you've heard all the evidence, comma, the lawyer's closing arguments. In order for me to read it properly, I have a comma in there, "and have been fully charged on the law that applies to this case." But I just noted that for myself.
I will submit that change to the Superior Court at its next
That would be
conference.
you. I read that you were on the committee, right?
No, not anymore.
Previous?
Due to the commas and parentheticals and other things that get debated, I decided there were other matters that I might be better charged to address.
Well, I noted that, and I wasn't sure if it was omitted by accident. Then on page 8, the second to the last sentence of the top paragraph, it seems odd to say that you'll consider all as a whole all the instructions I've given you and will give you, it says during deliberations. I suspect that's before deliberations. But if that comes from the pattern, you're not actually giving them instructions during deliberations.
No, that's from the pattern, and I guess you could read that a couple different ways, but
Well, I think it's read, "You should not single out any one instruction during deliberations." And then the parenthetical, of course, is "you should not single out any one instruction, but must consider as a whole all of the instructions I have given you and will give you during deliberations."
That does, with that emphasis, yeah, it does make better sense. So now I agree with that. See the importance of a comma.
well, the comma exists there, though.
Yes, it does.
Yes.
And now it makes better sense to me. I know what you were about to say, the one we used to use with our children. Yeah. "Let's eat, Grandma, comma, let's eat, Grandma." Yeah. So that's why it's important. On page 8,
Commas save lives.
commas save lives. That's what we've told before. On the page 8, the second to the last sentence, "whether or not you make such," it's a typo, it says "and inference," it should
Such
be "an
and, yeah.
inference." And I know you're thinking right now how annoying it would be to be my law partner, so. Page 9.
Well, just for the
citizens-
record, since I have some staff attorneys here, I did not give this to my staff to proof. This was just
This
done.
is not a criticism, but I'm just my.
No, because they want me to make sure everybody knew that we're squared away. And we're normally much more squared away.
Should have brought it right to their attention. Page 9, under citizen's arrest, the last sentence of the first paragraph, "a person may arrest him upon reasonable and probable grounds of suspicion." I don't think that comma is in the statute. Upon reasonable, comma, and probable grounds of suspicion. It makes it sound like two different things. But I think reasonable and probable in the statute is straight through, without the comma.
I'm not sure where I would have gotten the comma from, but I'll look at that. However it's in the statute, is however it would be in the charge. Again, they're not going to be getting a copy of the preliminary charge. Just so everybody knows how I usually operate. The preliminary charge to me is exactly that. It's It's to make sure that the groundwork is set for the jury to understand its roles and responsibilities, and it's just an explanation to them of where the court expects them to be in the trial. The final charge, though, which repeats a lot of this, ultimately I do send out a written copy of the charge with the panel. But of course, if there's going to be exceptions or objections to that, I'll hear from the parties on it. But my general practice is to send out a copy of the charge.
Very good. That was all I saw in this charge, with the exception of the issue concerning the motion on the removal of all doubt.
Mr. Goff.
We would adopt all of the suggestions made by learned counsel. I also remember, I think it was on page 2, and Mr. Sheffield was pointing out an issue. I think the charge referred to defendant rather than defendants plural. And if it did, although that's probably the pattern, in this case it might make more sense to refer to defendants in the plural.
Well, I tried to go through and make sure it was each defendant or defendants, so they're referred to both ways. If anyone sees one in there, just let me know. I mean,
but I have more, I think, important issues. And first, let me acknowledge, the court's under no duty to give a pre-charge at all. And I understand that. Nor can a pre-charge be expected to be as lengthy or detailed as the charge the jury received at the end of the case. And I'm certainly not suggesting that. But we are discussing some of the legal principles in this case. And if we're going to do so, I would humbly submit that we do so completely and accurately. And I sense that the court has been perplexed at times in the past when I have suggested that charge issues needed to be addressed, and probably also irritated because of all the counsel in this case, I have probably been the last to get anything before the court. So I understand the dual issues there. Nevertheless, given the importance of the case, I feel that we should address some issues earlier, sooner rather than later. The charge on burglary, I would respectfully contend, is incomplete.
Now, I do want to point something out, though, before we get too far into it, just so everybody understands what the court did with this charge. I was asked to give a preliminary charge on some issues that may come up. Burglary in the first degree, burglary intent to steal, criminal trespass, citizen's arrest are all directly out of the Superior Court charge book. The only charge here that is, the only charge here that the court had to pull together is what I have marked here as the Bruton charge, which really isn't a Bruton charge, it's just an evidentiary instruction. So before we get too far, what I tried to do for simplification of the initial charge was simply go to the existing pattern charges, fully realizing and understanding that at the end of this case, once all the evidence has been submitted, the court's going to have a charge which addresses the evidence presented at trial.
I wasn't in any way, I didn't mean to imply the slightest questioning or criticism.
No, and it wasn't. I was simply explaining to everybody my thought process here, because this is the preliminary charge. This is very basic. It could be expanded upon, but what I didn't want to do was provide a charge that ended up not being consistent with the evidence and trying to explain too much.
And Your Honor, I believe that it was originally the state's motion to have those in, and I believe what your direction to us was that we should all agree upon this. And I did receive responses from Mrs. Hogue, and she said, yes, we're going to agree to this, and we have some alterations, and that was her motion. And so, unfortunately, this is the first time I'm hearing that Mr. Goff is not in concert with the rest of us, because we've all agreed to.
Well, and we don't know that yet. I just wanted to do that because, and I guess the other part of this, and I have received your submission, for example, on citizen's arrest, which is a proposed charge, as well as a whole bunch of supporting law on that. I've looked at it, okay? But again, at this point, since all of the evidence in the case has not been presented, normally I don't put any charges on the law in a preliminary charge. And so in order to avoid the problem down the line of having something in the preliminary charge that doesn't actually end up getting in, I've tried to be very careful with it.
All I can do this afternoon is bring some issues to the court and ask the court to consider them. And I don't expect that every suggestion I make is going to find its way into the charge of the court. It may be that none of them do, but because we will have this conversation at the end of the case, and I suspect probably during the trial as certain issues come up, I feel if the court will indulge me, it would be a productive exercise.
No, that's fine. I just want to make sure we're all on the same page.
And I think we are. Your Honor, the problem isn't that the charge itself is wrong. It's that it's incomplete for this particular case. To be, in all candor, if this was the usual case involving a burglary, it wouldn't have taken 17, 18 months to get here. This is a case that involves a unique juxtaposition of relatively uncommon principles of law. For example, in the burglary statute, my concern here is that there is nothing for the jury to decide as to whether the English residence is a dwelling covered by the burglary statute. Now, my concern is that the way this is the state is presented, and I think the state is the one who suggested this particular charge, is inviting the jury to consider whether the English residence is in fact a dwelling under the statute. I think, consistent with Georgia law, that a house under construction, which is so completed as to be capable of sheltering people, animals, or property, constitutes such a structure under Georgia law. It doesn't matter if the dwelling was occupied, unoccupied, or vacant. So I think that that additional language, which comes out of Georgia case law, and I don't think the state disputes that that's the law, I believe that should be included in here. So with all the other considerations the jury legitimately has to consider, tough questions in this case, we're not sending them down the rabbit hole as to what a structure or dwelling is under Georgia law. Now, furthermore, I think the case law is relevant that to prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. I believe that language is appropriate. It's less important than the first part. But here's my concern, Your Honor, and this dovetails into the charge on criminal trespass, which dovetails into the charge on citizen's arrest. With all due respect to learned counsel, all of whom disagree with me, there is no criminal trespass in this case. Either Ahmaud Arbery committed a burglary on either February 11th, previous occasions, or certainly February 23rd. It's a burglary or it's nothing. Under Georgia law, it's clear that if theft is the only crime that the evidence would suggest, you're not entitled to a charge on the lesser offense of criminal trespass. And in this case, there's no reason to charge a jury on criminal trespass because either they find there was a burglary or they find no crime at all. There's no factual scenario under which they could find a criminal trespass. Now, whether that's good for the state or bad for this defendant or that defendant, I think that is the law. And that, again, takes us to the citizen arrest statute, which...
Before you move on.
I'm sorry.
Yeah. We want to adopt the argument on burglary in terms of how a structure is defined, as well as breaking the plane. We would like to adopt that. We did not move for that originally. On behalf of both McMichaels.
Thank you, sir. No. I'm glad you stopped me.
Mr. Sheffield just yelled squirrel and we stopped.
I'm just pleased anybody agrees with me in this case. I'm a happy camper. Your Honor, with respect to citizen arrest, I submitted that proposed charge and authority a long time ago because I think it's a central issue in this case. Here's my concern, and I've expressed it to the state and I've expressed it to my learned co-defendant counsel in this case. This absurd path we're on where the court, doing what good judges do, which is in default, for lack of any other reason, charge a statute. And I get that. And the state appears to be happy for the court to charge the statute, and the co-defendant counsel seem happy for the court to charge the statute. I have a problem with it. And here's my problem. There is no criminal trespass in this case. There's a burglary or there's nothing as far as Ahmaud Arbery is concerned. And I think you've heard enough of the evidence in this case to understand why I say that. There's no reason, and there's no question as to whether the structure is covered by the burglary statute. There is absolutely no reason to charge the first sentence of the citizen arrest statute because it's not this part of the statute that covers or governs felonies. A private citizen may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If we're talking about a misdemeanor, that is the law. But there is no misdemeanor upon which to conduct a citizen arrest in this case. Nobody can tell me what that would be. There's no reason to charge it. The second part, punctuation, or issues about punctuation go back to 150 years. Whatever the court decides on that is fine. But what's going to happen, Judge, is you're going to read this statute, okay? I think you are, and you're charged for the jury. The state is going to get up there and find, no disrespect to the state, some clever way to talk about knowledge and immediate presence, and I'm sure they can find one. They're going to say that there's no citizen arrest because it didn't take place in the presence and immediate knowledge. The McMichael lawyers are going to get up and say, well, that's just not true. The law is that you can arrest someone for a felony without the person being in their presence and within their immediate knowledge. And apparently everybody but me is happy with this scenario. But here's what I see, and I say this as a former law clerk. I see the jury coming back with a question. What do we do with the statute? And the default response for most judges is going to be to say, I cannot give you any further information unless the parties have agreed, which they won't. You're going to come back and tell the jury, I have charged you on the law, and that's what you do or apply. And then the jury's going to go back there, and we're going to end up in hung jury land because they're not going to be able to decipher these two competing versions of what the law is without the direction of the court. And to avoid all that, since it has no relevance to any of the issues in this case under any plausible scenario of the fact, there's no reason to charge first sentence of the statute. The second sentence, the part that applies to felonies, is all that should apply. Now, I think there's things that should be added to that. I don't think that necessarily has to be in the pre-charge. We can discuss that later. But it is fundamentally a bad idea, with all respect to my learned opposing counsel, to leave the jury sitting there through the whole trial trying to discern the difference between the first sentence and the second sentence, and all this confusion of whether it's a dwelling place or not, or what this presence and immediate knowledge is. We're inviting these individual jurors to go down their own personal rabbit trails for 2 weeks, and then at the very end, we're going to get two competing versions of the statute, and in all candor, if we get there, normally you're just going to tell the jury, you give them the charge, and then they're going to be stuck. I don't want to be there. Take out the first sentence, because there's no misdemeanor under any set of facts in this case. It's a burglary or nothing. And if anybody, I'm sorry, go ahead.
No. I thought you were done with that.
Well, on that citizen arrest issue, I am.
I respectfully disagree with Mr. Goff. And here's why. We should have the whole statute on citizen's arrest, and we should have criminal trespass. Fundamentally, it's the probable cause in the minds of the defendants, otherwise known as reasonable and probable grounds of suspicion, as the old citizen's arrest statute put it, and not whether Mr. Arbery ever committed any actual crime. He may not have, for all we know. It's whether the defendants had reasonable and probable grounds to suspect that he was fleeing from the commission of a felony in sentence 2. And I do agree there's probably no evidence in the case that anyone witnessed or had immediate knowledge of a misdemeanor. But the first sentence is both felony and misdemeanor. It applies to both. The second sentence of the statute only applies to felonies. But again, furthermore, and of most importance in this discussion of the charge, is that there doesn't have to be evidence that Mr. Arbery actually committed any crime. It comes down to the reasonable belief of the defendants when they attempted to detain him.
Which is why we're not getting into great depth in the preliminary charge, because I don't think this addresses that either way, and I'm neither agreeing nor disagreeing. This charge is general enough where I believe it covers what we're going to at least get into in the evidence of the case. Whether the ultimate charge on citizen's arrest reflects exactly what you're saying is still, I understand, and again, I referenced Mr. Goff's significant brief on citizen's arrest before we got started. So the court is not at this point acknowledging anything but what is out there in this pattern charge. The idea here is simply to give the jury an idea on what citizen's arrest is without getting into all of the arguments of counsel simply in the preliminary charge. Okay.
I have nothing further to add to that. I did have a few other points, if the court will bear with me. I talked about burglary, and I missed something, and I want to go back to it. The court is charging generally about intent to steal. However, there is also case law not reflected in the pattern charge that makes a consideration not just whether items of value were present, but where there seems to be no other reason for entry. That is to say, when no other motive is apparent. There are cases that discuss that, and I believe, although it's not in the pattern charge, I don't believe on intent to steal, it's relevant to this particular case. We've heard stories about maybe speculation, somebody was looking for water, maybe speculation, somebody wanted to go to the bathroom. I believe that that part of the Georgia law on burglary should be included in the charge on intent to steal. I also believe that an instruction on flight is appropriate here. If we're going to charge the jury about intent to steal, we should also charge them on flight. The combination of flight, intent to steal, plus flight gives you probable cause for a burglary, almost as a matter of law in this case. And if you're going to charge on intent to steal, you charge on flight. I think you have to have both. And that's all I have to say on the burglary. And I'm sure some other people want to have their say.
Not on that. I wanted to talk about the reasonable doubt part when you're done.
Okay. All right.
Well,
Yes.
yeah, the state's still here. State could address the court. I mean, hi, I'm the state. With regard to part of what Mr. Hope said, yes, I'm about to agree with him on the fact that all I know goes down to the whole citizen's arrest part should come in. With regard specifically to flight, with Mr. Goff's just recent flight argument.
Okay.
Since January 10th of 1991, it's been reversible error to charge the jury on flight. However, recently, the Council of Superior Court judges decided that it may be advisable to give such an instruction if requested by defense counsel as a limiting instruction. Evidence of alleged flight or similar acts like escape, bribery, intimidation has been introduced. Usually this would be introduced by the state. So evidence of alleged flight, such evidence is governed by the rules concerning circumstantial evidence you have already been given. Furthermore, you may only consider it if you find more likely than not that the defendant actually committed such act and that the reason, I think for the flight, was because of consciousness of guilt or to evade the charge now on trial. My assumption is that the defense would ask for this to be changed up to the evidence of alleged flight has been introduced, because they're assuming and going to argue that he's fleeing. Such evidence is governed by the rules of circumstantial evidence. Furthermore, you may only consider it if you find more likely than not that I'm assuming they're going to do, the victim actually committed such act and that the reason was because of consciousness of guilt. But I just wanted to bring it to the court's attention that this is new, this flight pattern, and it's a limiting instruction. Therefore, I think it only comes in well after the evidence has been presented.
And it is one of our requests to charge at the conclusion of the case, Your Honor.
And to further simplify the matter, Your Honor, although I don't think it needs to be in the court's preliminary charge, as I understand Georgia law, although in civil contexts, the law is that where a reasonable man would investigate further before instigating a prosecution or making an arrest, he may be liable for failure to do so, which would seem to impose on the McMichaels in this case, and arguably on Mr. Bryan, a duty to inquire. And the reason I'm bringing it up, because I think there's going to be some discussion tomorrow in opening statements about what I would call the Nancy Drew problem, which is there's a right to arrest, but there's arguably no right to investigate. However, I think you can investigate as long as you're not breaking the law, and in fact, one could make the argument applicable to this case, that the McMichael defendants were under a legal duty to ask him what he was doing before they arrested him. And certainly that would go to the reasonableness of their actions on the day in question.
However, if I may, on that note, and I may be taking us off in a different direction, however, in both the interview the Hogues gave and the radio interview Mr. Sheffield gave to Court TV, they both used some key language, and I noticed the key language was that the McMichaels were effectuating a citizen's arrest detention so the police could come and investigate. And these were key words. A citizen's arrest detention so the police could come and investigate. That obviously, there's no such thing as that. And I only bring it to the court's attention right now because it's of concern to the state that conflating we get to detain and hold somebody so the police can come and investigate this is not what citizen's arrest is. And I just agree with Mr. Goff that that concept is concerning to the state. And I will just leave it at that. Obviously, if that's what's put together in the opening tomorrow, I will be objecting because that's a misstatement of the law. But I just agree with Mr. Goff that detention and to hold somebody so the police can come and investigate is not what a citizen's arrest is.
I wasn't implying that that's what happened, but I do think the evidence, as I understand it in this case, will be that this started as a consensual encounter, driving up on the side of the road, and I'm not trying to put words in anybody else's mouth. This started as a consensual encounter. Stop, we want to talk to you. And under the law, flight is certainly relevant. And if you have an obligation to inquire in good faith before arresting somebody, the fact that someone won't stop and talk to you kind of explains the escalation on this day. At least that's one defendant's view of that. I'm certainly not speaking for the McMichaels on that. And I certainly think that it's relevant. But beyond that, I'm ready to move on to the next issue, if I may.
Sure.
Your Honor, I also believe that we are charging on burglary. I think that we are entitled to a charge also on, I would leave it to the discretion of the court, others may feel differently, either carjacking or motor vehicle theft. The evidence we believe will support that. And of course, theoretically, and I've gone through this exercise, you can find all kinds of potential crimes out there, but I think that carjacking or motor vehicle theft are reasonable to charge the jury about. It focuses the jury's attention on one of the important issues in the case. And I'm going to stop and see if anybody agrees with me.
We adopt on behalf of both McMichaels.
Oh, I'm sorry, adopting a carjacking
Do we
preliminary?
instruction?
Oh, okay, yeah, all right.
I can now say we adopt on behalf of both.
One took me off guard. Very
So
good.
what I understand we're adopting is simply that carjacking should be added to the preliminary charge.
Yes,
Okay.
his motion to add it, so we can specifically.
Or the alternative, motor vehicle theft, if the court feels uncomfortable going that far.
And, Your Honor, the state's sole intent with requesting this preliminary charge was because numerous witnesses misused these terms. We've got breaking in, burglaries, criminal trespass, which Greg McMichael says, and on video with Officer Rash, so that they know exactly what citizen's arrest meant. The sole purpose of this was so that when people used terms of art that we all know very well as lawyers, that there would be some explanation for this jury in advance as to what those terms of art were. At no point in time does Mr. Bryan say carjacking. He says he was, after he cornered him, he attempted to, or what appeared to be, reaching for his car door. So this idea that we're going to make out of whole cloth, after I took my car and cut him off so close to him and cornered him, he appeared to be reaching for my door handle, and I sped off so he couldn't get to me, turns into a carjacking. The state's very, very concerned about inserting at this point in time carjacking or theft by motor vehicle into this case. And in fact, if we're going to go down this route, the state will just withdraw wanting any of these charges at all in advance for the jury, and we'll just go with the preliminary charge up till you should not single out any one instruction, but must consider as a whole all of the instructions I have given you and will give you during deliberations. The state would be perfectly comfortable in taking out all of this stuff if we're going to go down this road right now. It was simply to assist the jury in understanding some of the inartful language some of the witnesses, especially the McMichaels, were going to use in this case.
And if the state wants to withdraw that, that's fine, but I'm going to adopt the motion, and their withdrawal doesn't matter. We're entitled to the charge on these substantive principles. And the suggestion that the solution for the state is simply to withdraw substantive charges and leave the jury uninformed, I won't speculate as to what was going on behind that. But, Your Honor, I'm ready to move on to the next point unless somebody else wants to further address that one.
I would just like to add, Your Honor, there is, I don't know if the state's going to put it in, but Mr. Bryan says Ahmaud Arbery was trying to get into his truck, so he slammed it into drive and jumped out away from him. That he was trying to reach for the handle of the car to get in the truck, and there'll be testimony about Mr. Arbery trying to get into Mr. Bryan's truck and what that meant. So I think there's a good faith basis to help the jury understand that before the trial.
I'm ready to move on. Your Honor, I seem to be the only lawyer in this case that thinks that the jury needs to be charged, the pattern charge, 3.16.40, arrest, right to resist unlawful force in making an arrest. The only change that needs to be made is where it says police officer, it should say a private citizen is authorized. How is the jury going to make any sense of this case if they don't understand that Mr. Arbery has the, and I'm not saying that he was correct or that this is in fact the case, but how are they going to process the evidence in this case without understanding that not only is there a common law right of citizen arrest, there is an equally old and ancient right, still recognized in Georgia, a minority of jurisdictions at this point, to resist, first to resist an unlawful arrest, but second, to resist the excessive use of force in a lawful arrest, and to wait to the end of the trial to inform the jury of legal principles that they probably wouldn't have any idea of, is going to put a situation is the jury's going to be looking back over weeks of notes trying to figure out how they apply that principle of law, because I expect they're going to be blind, other than the people with law enforcement training, they're going to be blindsided by that issue. Even several of the jurors who are career federal law enforcement officers are unfamiliar with citizen arrest or the right to resist an unlawful arrest or to resist the excessive application of force in the context of a lawful arrest. And with all due respect to everybody else who thinks I'm crazy, to me, that's really the primary issue in this case. There's no question that there was probable cause to conduct an arrest. That's just my opinion. The issue is not whether there was probable cause to conduct a citizen arrest. The issue is going to be, ultimately, whether the Travis McMichael, and perhaps Greg, used excessive force in effectuating a lawful citizen arrest. And the flip side of that, which is why the state disagrees with me, is the jury's going to have to decide, even if the arrest was lawful under Georgia law, whether Ahmaud Arbery was entitled to resist what he had perceived to be an excessive use of force. Instead of looking at this primarily as a citizen arrest case, you can or you can't, the real issue in this case is whether the McMichaels or Arbery or both employed the excessive use of force. And to not let the jury know that that issue is out there is a disservice to the jurors, and I think it's a disservice to the justice process. Not that anybody's trying to not serve justice here, but this is a critical issue in this case. Because to simply say whether it's a citizen arrest or not decides this case, that's not the end of the inquiry for the jury. That's going to be the beginning of the inquiry for the jury. So we can't ignore this issue. And I have, and I don't mean any disrespect to co-counsel, but it's like watching three-dimensional chess through a fog or a mist and trying to figure out what's going on. I can't follow all the machinations here, but we're at trial, and I have to look after Mr. Bryan, and I feel that these legal principles need to be addressed, among other things, not necessarily addressed in the preliminary charge, but we've got lesser offense issues that inevitably are going to, and inextricably going to be intertwined with this concept of resisting arrest or resisting excessive application of force in an arrest. And I just think we need to have the jury be aware of this issue and not blindside them with this at the end of the case and have them coming in here with questions. Can we rehear this part of the testimony or rehear that part of the testimony? Because at the time we heard it, we didn't know why it was important. Why put ourselves in that position? I think that needs to be in the pre-charge. On that subject, that's all I have to say. I have 2 or 3 issues left, depending on how this one goes.
Well, that's what closing arguments are for. Here are the facts, and this is how the law that the judge is going to give you applies to those facts. And so while I have actually submitted excessive force and resisting lawful and unlawful arrest as jury charges, the state doesn't necessarily believe that it's appropriate in the pre-charge. The court is absolutely right. This is a minimal overview to be given right before opening statements, and it's unnecessary for them to have an entire charge at this point.
If I may, yes.
One of my frustrations in this case is we haven't even begun to explore how you adjust the pattern charge on use of force to the facts of this case. And I understand why the state would like to look at this as a self-defense case. And I understand why the co-defendant's counsel looks at this as a self-defense case. And justification, it's easy. If one party is the aggressor, they're in the wrong. If the other party is the aggressor, they're in the wrong. But it's more complicated than that. It's not just who's the aggressor, it's the context in which the aggression takes place. This is an arrest situation. As a matter of law, one is not required, a police officer, for example, is not required to engage in an even fight. You know, in the old days, they used to say, if he brings his fist, you bring out a club. If he brings out a knife, you bring out a gun. And arrest is never intended to be an equal application of force. You can't simply give the pattern charge on use of force in this case without creating real problems. And we need to be focusing beyond that to the finer points of this case, which actually is what the jury ultimately is probably going to be looking at. And I just think, once again, we need to be focusing more attention on whether one or both parties in this used excessive force and how we charge the jury on that concept instead of, with all due respect, what seems like an infantile analysis of who's the aggressor, because it's more complicated. They can both be the aggressor in this case. Having said that, I'll move on to my next one unless Ms. Donikowski wants to be heard again.
I'm good, thank you, Your Honor.
Your Honor, we believe that we are entitled, I won't say entitled, pre-charge is kind of discretionary with the court, but we would ask the court to charge good faith. That's, I think, part 3 of the citizen arrest charge that I had previously submitted. Your Honor, relying on Henderson v. State, 95 Georgia Ave. 830, cited in State v. Hemd, H-E-M-B-D, 232 Northwest 2nd, 872, Model Penal Code, Section 3.07, in parentheses 4, Commonwealth v. Klein, Massachusetts case from 1977. It's also referenced in what I previously submitted. We contend that good faith on the part of Bryan, defendant Bryan, is a defense in this case. And we believe that the jury should be charged on that. And we're asking for that because Mr. Bryan isn't coming to this with a gun. He's coming to this with a cell phone. He is unarmed. And we can quibble about how to most accurately define that. The bottom line is he's unarmed, notwithstanding whether a 5,000-pound vehicle can constitute a weapon. He is essentially unarmed, and he is coming to the aid of the others involved in this case. And good faith is a defense, and we would like the jury charged with respect to Mr. Bryan that good faith is in fact a defense. It doesn't matter in the end whether the McMichael defendants were authorized to conduct a citizen's arrest or not. That he at all times acted in good faith, and that based on that, even if the jury were to find the McMichael defendants guilty of one or more of these offenses, that they could still acquit Mr. Bryan based on his good faith as a third party in this situation. I don't expect the state's going to agree with that, But the sooner we have that discussion, the better we'll all know what the applicable law is going to be.
The state disagrees with that. There is no good faith exception. The thing is, Mr. Goff is partially right. There's mistake of fact. And that is an appropriate jury charge, not to give pre-charge, because that is once again something for a charge at the end of the case based on the evidence presented. So we ask that good faith not be given at all.
Your Honor, I think we've asked the court for enough when it comes to use of force for a pre-charge. I'm not going to ask the court to add any more law on the use of force, but I would, again, implore the court to consider whether there's a lot more to this case than whether or not there's a citizen arrest. Excessive force is what this case is really about, by one or both or none, and that'll be for the jury to decide. But we should at least get them started on that path as they're hearing the evidence as to what those issues actually are, because they're only hearing half the law in this case. It's not just citizen arrest, it's also the right to resist arrest. Thank you.
Since we're still addressing the charge, I believe Mr. or Ms. Sugg, you had the argument on the reasonable doubt portion of the charge.
Permission to remain seated so I can navigate my stuff. Thank you. If we look at the pre-charge on page 2, paragraph 3, the last sentence, that's what's at issue in the motion I filed, and I don't know if I filed this before or after the pre-charge thing came up. Yeah, I saw that. I just don't know when. I had filed it originally intending it to apply to the final charge, but since reasonable doubt's in the pre-charge, it applies here as well. So in paragraph 3, just read that whole paragraph, it's not long. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. And this is the sentence at issue. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. Without reading the whole next paragraph, but just pointing it out in it, is a second type of doubt, and it's called vague or arbitrary doubt. So the pattern charge acknowledges two kinds of doubt. One is reasonable and one is vague or arbitrary. And reasonable doubt, of course, is the one that the state has to move the minds of the jurors beyond. And the problem with that sentence is several problems, but it's misleading and it's confusing and it's actually faulty or erroneous. And to illustrate it, I'd like to call the court's attention to a recent case. I don't know how to pronounce this name. I'll spell it and try to pronounce it. It's Debelbot versus the state, Debelbot. And it's at, I just have the Southeast 2nd site. It's 839 Southeast 2nd, 513. It's a 2020 Supreme Court case. And I bring it up for illustrative purposes because of the mistake made by the prosecutor in this criminal case. A mistake that illustrates the problem with the charge, not a mistake I think that any of these fine, experienced, excellent prosecutors would make. I don't think they would. And I don't know who this prosecutor was, but this is what he or she did. During closing argument, I'm reading from the opinion, the prosecuting attorney attempted to explain to the jury that proof beyond a reasonable doubt does not require proof to an absolute mathematical certainty. That is, the law does not require the state to prove the guilt of the accused with 100% certainty, and that the standard of proof in a criminal case is not readily susceptible of quantification. In doing so, however, the prosecuting attorney set the bar far too low, going so far as to argue that something less than a preponderance of the evidence would be enough to authorize the jury to find the Devilbots guilty. And then they quote from the closing argument, and I just do a little piece of it here. And this is the lawyer in closing argument. Reasonable doubt. The judge will charge you on reasonable doubt. Just keep in mind, and he will charge you, reasonable doubt does not mean beyond all doubt. It does not mean to a mathematical certainty, which means we don't have to prove that 90%. You don't have to be 90% sure. You don't have to be 80% sure. You don't have to be 51% sure. It does not mean to a mathematical certainty. And of course, that was completely wrong, and the court pointed that out. And so I bring it up to illustrate not what I think anyone over here will do. I know they won't argue like that. But here's a lawyer confused about it. And I have raised this many times in many of my own murder cases. And it's never been granted. It's never been taken out. And it's made it up to the Supreme Court now twice. Once in Anthony v. State, which was a murder case I tried. And you can see how things went. It went on appeal. And this was one of the many issues. And then later in Rowland v. State, another murder case I tried. You can see how that one went. And it cites the Anthony case, but Rowland and Anthony.
You get one sided to the other on the same issue.
That's right. But here's what, and I think Your Honor might appreciate this metaphor I'm about to give you. It's kind of like the dead bird thing. But here's what the court said in Anthony. They said, the fact that the sentence of which the appellant complains.
Right in front of me was introduced by the word however.
Yes, you've seen that. If I read the end of it, I'll give you my analogy on what I think this type of ruling means. However, it does not change the meaning of all doubt or mathematical certainty. Even assuming that the use of those terms amounted to error, we will not reverse the judgment on that basis because the charge as a whole properly informed the jury of the state's burden of proof and the meaning of reasonable doubt. And that was Rowland citing Anthony. And so the metaphor I came up with for that kind of ruling, where they're saying that if you put that possibly assume erroneous sentence into the whole charge, everything's okay. So it strikes me like this. It's like saying to the jury, well, other than the worm that has burrowed into my apple, the apple as a whole is still edible. Just eat around the worm. So there's this worm in the charge, and I'd like to get it out of the charge because I think it is misleading and confusing. I have spoken to jurors. This is anecdotal evidence, of course, and they have expressed to me their confusion about what this does. What it does, I think, is it diminishes the burden of proof by introducing the idea of all doubt in the paragraph with the reasonable doubt, which hasn't even been defined yet, and before the other kind of doubt has been introduced at all, which is vague or arbitrary doubt. So if you modify all doubt by inserting the only other kind of doubt that's been mentioned so far, what you're hearing, if you do that, is all reasonable doubt. So the sentence is possibly heard as, the state is not required to prove the guilt of the accused beyond all reasonable doubt or to a mathematical certainty, because at that point no other kind of doubt has been mentioned. And the contrast to vague or arbitrary doubt, it apparently doesn't even apply to that sentence. So it's partly the placement of the sentence, and as I put in the brief, it creates an ambiguity. The particular one that it creates is called an amphiboly, where, and my favorite example of it is Groucho Marx. who said, "I shot an elephant in my pajamas this morning." How he got in there, I'll never know. It's that kind of ambiguity that this creates. But on a more serious note, it is confusing to the average juror, as it was confusing apparently to a bar card holding prosecuting attorney in this Devilbot case. I guess it was confusing. I don't know how that lawyer thought that you could reduce reasonable doubt all the way down to preponderance practically. And then the second part of my argument is the mathematical certainty part. I'm sure everyone has read René Descartes' Discourse on Method, published in 1560. But common sense, the phrase doubt or reasonable doubt, common sense often starts out as a novel theory or an idea or a belief that over time just infiltrates the groundwater, seeps through the sand, and finally reaches the aquifer, and then we all drink from it. I mean, until 600 years ago, it was common sense to believe that the sun revolved around the earth, and that the earth was flat. And then we changed our minds about all that when somebody came up with a new idea that was more useful and more effective and more powerful. So the idea that that mathematical certainty is some kind of mental state different than beyond a reasonable doubt is, I think, a holdover from the days when modern philosophy started with Descartes being the ultimate skeptic who set out to doubt everything until he realized, well, I can't doubt that I'm the one doing the doubting. And we've all heard the little phrase, cogito ergo sum, I think, therefore I am. And then we're off to modern philosophy, a subject I enjoy and I know a little bit about. So mathematical certainty, I submit, Your Honor, is no different than beyond a reasonable doubt. And the example I use is this, and then I'm done. Mathematical certainty that 2 + 2 = 4. Nobody in this room doubts that. That is a mathematical certainty. By the same token, nobody in this room doubts that we are, in fact, right now sitting in the Superior Court of Glenn County, Georgia. We are just as certain of that fact, which is a physical fact about the world, as we are about the mathematical fact that 2 + 2 = 4, which is just an idea. And the reason we're equally certain is because we know how to use the words in the right way. We know what 2 and 2 plus and equals means. So I think this is antiquated carryover from what the law does. As we all know, it often is 50 years behind science. There'll come a time when intent and all of the issues we have with moral culpability being applied in criminal law may be completely different than they are today because of the discoveries being made by science. Maybe, maybe not. We don't know. But the law catches up eventually, and I'm just trying to prod it along here and get rid of one little sentence in a pattern charge that's been around a long time. And usually judges tell me, well, it's in the pattern charge and I'm going to keep it there. I'm not going to change something that we've been saying for 150 years. So I'm just taking my little hammer and hitting the rock, and maybe one day it will crack. So I ask Your Honor to remove that sentence from the pattern charge.
Your Honor, we join in that motion.
From the state.
Thank you. Your Honor, it's a pattern charge. We ask that you not remove all doubt and mathematical certainty. And the reason is because the jurors are regular people. And you know what regular people say? You got to prove it to me beyond a doubt. Okay? They actually say that. I've actually had them say that that's what they believe the state has to prove. I've actually said, or jurors have actually said to me, well, I'd have to be 100% certain, meaning that that's the burden they expect the state to prove to them. I've had jurors tell me that, yeah, I'd have to see it with my own eyes in order to find somebody guilty. Now, were they trying to get out of jury duty? Probably, when they said these things. But jurors are not lawyers. And some of them back there may turn to each other and go, well, I think beyond a reasonable doubt means we have to be 100% certain. Or I think back here that it has to be beyond all doubt. But that's not what we're held to. We're held to the standard of beyond a reasonable doubt. So this language is not directed at anyone but jurors who do not know the law, and it's directed at jurors so that they understand that the state is not required to some sort of mathematical formula, and that the state is not required to eliminate every single doubt they might have. There is a charge on circumstantial evidence. There's a reason, because in this case we do have a video. But what we don't have a video of is what happened on Burford Drive. We don't have anything about what happened on Burford. So we don't have anything when Mr. Bryan went ahead and backed up to change Mr. Arbery's path to go up Holmes. We don't have that on video. But that's something that the state's going to have to go ahead and show and prove. And there's circumstantial evidence, and there's the statements of the defendants to prove that. But the state is not held to a standard other than beyond a reasonable doubt, and this is language in the pattern that was put there to assist jurors who may not understand the standard and actually attempt to hold the state to a higher standard. Thank you very much.
Your Honor, if we're going to talk about it, there's a substantial federal body of case law on reasonable doubt, and there's some great language in there which would address the concerns that's raised by Ms. Dunikowski about how you would handle the most serious of your own personal affairs. And maybe she'd like to, I'd be happy to work with her on coming up with adding that language into the charge. Just because we've been doing a charge for 150 years doesn't mean it's right. For 125 years, we were charging about hypotheses of innocence. Somehow, which was great language for the defense, and we don't get that anymore. I think it would be appropriate in a case of this gravity for the court to take a serious look at the charge on reasonable doubt.
Okay. Sounds like we have addressed the arguments then in the preliminary jury instruction. Let me just note the comma in citizen's arrest. That was the court's error. That comma does not exist after reasonable, and I have removed it. So that's consistent with 17-460. The court is going to keep with the few edits there that have more to do with proofreading than anything else. I'm going to go ahead and make those changes. Beyond that, I'm going to keep the charge the way it is, including the language just argued about reasonable doubt. The court doesn't simply rely, I realize some people just simply rely on the charge, but there's more to the charge. The charge usually relies upon some precedent set by the courts. So that precedent's in Anthony and Rowland, which have been referenced here. I've got the language about, for example, the however language dating back to 1892 with McTire. And there's also other cases that address the charge itself and well-settled principles, Coleman v. State, for example. And Williams v. State, which talks about as a fundamental rule in Georgia, jury instructions must be read and considered as a whole in determining. All of that leads the court to the denial of the motion to remove that language. I do also point out the state, to its credit, I assume we'll give credit where credit is due, I think cited Delbot. In State's 4.56, which the state actually was the one arguing not to use percentages with regard to reasonable doubt. So I hope everybody, well, it sounds like everybody is on the same page with how to properly argue, at least that improper argument with regard to reasonable doubt. Okay. So that's the preliminary charge. I'll get that cleaned up. It will be ready for tomorrow. During the break, the court again looked at the body cam footage that was submitted. Why don't we go ahead and argue the McMichael's motion in limine regarding the Officer Duggan body cam.
Did I understand the court's ruling correctly, implicitly denying all of the requested changes to the charge, or is the court taking those under advisement?
Those are denied for the preliminary charge. Again, I have not, the court is open to argument with regard to the final charge of the court, but with respect to the preliminary charge, yes, those motions are denied.
Thank you, Your Honor.
Okay.
Grab the state's motion, Your Honor.
Just for the record, Your Honor, I'm sorry, check over.
It's fine.
We object and want to preserve the record on the alterations to the pre-charge that we requested by saying thank you. I appreciate the court's consideration, but I want on the record that we're preserving our right to have the charge corrected, the substantive charge corrected. Thank you.
Thank you.
We are moved to limit the playing of Officer Duggan's body cam. Now, there are some things on his body cam that the state is trying to have access to. It looks like the part that shows the defendants interacting with each other at the scene prior to being interviewed by law enforcement. Let's see. Also, perhaps to show Travis McMichael's demeanor in the aftermath of the shooting. I think the body cam may show some of that as well. That's really not. Also here, depicts in real time what was seen by the second responding officer when he arrived on the scene. Shows where the defendants were located at the scene in relation to each other. Do you have the motion, Your Honor?
I do. I have my notes that
Okay.
I'm looking for. I'm listening, and I've read the submissions.
Yeah.
So I'm following you. I'm just trying to find my notes.
Shows where they were located at the scene in relation to each other. Also it says without sound in the first 30 seconds. It shows Duggan interacting with and speaking to defendant Travis McMichael. This is important since it's believed that this is when Travis McMichael stated to Officer Duggan that he had shot the victim. These don't appear to be issues that we're concerned about that the body cam reveals. Those are not what we're concerned about. There is, however, a moment where Officer Duggan kneels over Mr. Arbery. And I think the court has now seen that. Turns his body over. He's giving pressure to some wounds. And the body camera is hovering 6 inches or so, maybe a foot over the body. Very, very graphic, very explicit. The question becomes, what's the relevance of the state and what's the necessity of that in comparison with what we just put forward in our motion, which is the substantial inflammatory nature of what that video is showing at that moment. And so it may be that the state could speak a little bit more on 401 and we can speak on 403. But certainly the things that the state desires out of that video that are not included in the moments where the camera is kind of hovering over Mr. Arbery's body in that way, and I don't know if the court could acknowledge there's several moments before that happens, then there's a good maybe 30 seconds to 45 seconds, maybe even a minute of being over Mr. Arbery's body. There's a different position of the camera at that moment versus when he first arrives on the scene. So the question then becomes, is there a necessity for the camera viewing the body in that state at that close proximity? Does that make sense, Your Honor? Okay. And I guess the questions as we anticipate or the evidence that the state anticipates to give to the jury is going to include that Mr. Arbery was in fact shot and killed, that he was shot and killed by Travis McMichael, that his injuries caused the shooting and the injuries as a result of the shooting caused his death, and where those injuries are on the body and how they led to his death, etc. So we're asking the court to consider alternatives to that particular moment in that video. Are there other ways to show the injuries? Certainly. There's other photographs, still photographs, either at the scene or at autopsy. The medical examiner we've both talked to have confirmed that Mr. Arbery died upon being shot, and that even was deceased before falling to the ground. That what's heard in the video, there are sounds that are characterized by some of the personnel on the scene. Those are not signs of life. Those are not signs of struggle to live.
Well, there's two things going on there. There's one, you can sort of hear in the video what I think is just the officer's breath. That's not what we're talking about. What you're referring to, I think, is just the officer's and I don't want to get into details because I don't know if that video has been played anywhere.
It has not been played anywhere.
So without getting too far into it, the officer makes a statement about his observation of the individual and what he thinks he may have heard to, I believe it's the EMTs that are arriving on scene.
There's a couple officers that do that, make statements what they classify as a quote-unquote death rattle.
Okay. I'm just with Doug, and the only one I'm looking at right now is Doug. I'm just trying to understand what we're talking about there, because being told what I was going to hear, I was a little confused over what I was supposed to be listening to for argument. What I heard was him talk about what he heard.
Okay.
And then while there with his hand on the chest, you can hear him breathe, him being the officer. But I think it's after that he then describes to the EMTs what he thought he heard. So it's his descriptive. It's not the actual sound that gets picked up. At least I didn't hear that.
Okay. So there is a part of that video that's very inflammatory, in the same way that autopsy can be inflammatory. And I perfectly recognize the state's right to put up their case. The question for the court, though, is to try to balance that in a way that is not going to incite the jury in a way. And so if the interests are such that the state has to prove certain elements, I am asking the court to engage in a balancing test over whether or not that particular portion of the video needs to be played, and whether the state's burden can be satisfied through other means of photographs that will depict injuries, testimony that will testify about various facts in existence at the time they were observed, as well as the medical examiner's testimony, etc. So I'm just asking the court to engage in a balancing test under 403. The way that I read the state's response to this is they have a need to present certain things. There are a lot of avenues for that. We are going to see the shooting in the case. We are going to see Mr. Arbery fall. We are going to have testimony that is as a result of being shot and that he was killed as a result of those shots. To then hear what we will, I think, later learn in medical terms is simply the expiration, although is not indicative of life or consciousness or awareness or still the ability to be resuscitated. I think that's what becomes inflammatory, and I'm asking the court to limit that. The state can still have the portions of that video that satisfy these other important aspects that they feel need to come in, like the position of the defendants. I'm not saying we're not going to see Mr. Arbery's body on the ground there on Holmes Road. I assume that we're going to see photographs of that and a lot of evidence of that. It's just, as the court has now seen, that part of the video is very inflammatory. Thank you.
Your Honor, we would join in that motion.
From the state.
Thank you, Your Honor. Officer Duggan is the second responding officer to the scene. He arrives and does have dash cam video that has absolutely no sound to it. As the court noticed, he hits his body cam video, it comes up, and then there's like a a little bit, 30-second delay before the sound kicks in. And he can be seen pointing at Travis McMichael, who's standing next to Greg McMichael off to the side in the shade. They are standing near the shotgun and near Mr. Arbery's body. Minshew is the only other officer on the scene. So you've got 2 officers, you've got 2 pickup trucks, a shotgun, and 3 men who are not law enforcement officers there. And there's a series of what do we do because officer safety, and is there a way to save this person? The reason it's important is because it shows exactly what took place as far as Mr. Arbery on the ground. Mr. Arbery is face down. Greg McMichael admits that he ran up and pulled his arm out in order to check for a weapon. At this point in time, Officer Duggan, when he comes up, rolls him over. And you can see the extent of the injuries, and you do see them. And this is, for lack of a better way to say it, this is real. This is real. And to tell the jury, oh, we're not going to show you what really the result of pointing a shotgun at someone is. Travis McMichael left his house with a shotgun. Then he got out of his car with the shotgun and pointed it at this young man, and then he shot him with it. And this is the result. And Officer Duggan is an officer who had to go to the scene. This is a human being who has to stand over this young man and put gloves on. And he's thinking, what can I do for him? And he puts his hand over it, and he then says, there's nothing I can do for this gentleman. And the other part of all of this is that Travis McMichael is standing probably right there during this whole entire thing and seeing this. The state has no idea if the defense is going to get into Travis's demeanor at the scene. He's upset, he's in shock, he's all these things. Well, that explains a lot of it because this is the result of his actions. And we think it's very probative because it shows where everybody was, the condition of Mr. Arbery, what Mr. Arbery actually had in his hand, and this sort of intimation out there that may or may not be in these jurors' minds that nobody ran up, including the defendants or the police, to assist Mr. Arbery. Obviously, it's going to be explained to them by the ME that the first shot killed him. Just because, like in the movies, he didn't fall down immediately, that didn't mean that that first shot didn't kill him. It did. He just kept going because it didn't hit his heart. So we want to show all of those things, and we think it's very, very relevant in this case to show exactly what the aftermath is and what the officer did, rolling him over, looking at his wounds, and they'll be able to actually experience that through the body cam and see that. My understanding, of course, and I'm just going to segue right now, is that the defense has no objection to the dash cam video, which is stationary and very, very far away, and you do see Officer Duggan doing all of these things from a distance. But it's just the body cam video that the court has seen. We ask that the court allow it, that it is it's more probative on these issues of exactly where everything was, everyone was, the evidence, and how Mr. Arbery was, including his clothing and the condition he was left in on the scene, than it is prejudicial for these jurors. Thank you.
Just a very brief conclusion, Your Honor. As the state has said, we do have the beginning of the video. We do have the car dash cam video. That shows the scene. It shows everybody is. We have Officer Minshew, who is first on scene, who has video on him as well. That shows where everybody is and is still playing when Officer Duggan arrives. And it's not relevant what the officer's experience was. That's not we don't need to understand the emotional experience of Officer Duggan. This is obviously a careful balance, but the state's needs, and this is what the court would do in circumstances like this, the state's needs are satisfied through other relevant evidence that will be admissible and doesn't have that same substantial inflammatory impact. We understand this is real. We're not shying away from that, Your Honor, but this is you've seen it now. Thank you.
Well, yeah, I watched the video and considered the arguments of counsel. I'm denying the motion in limine. We'll permit the body cam footage. I might put the court's order into a written order into the record just so we have it. I've got a number of cases. Instead of rattling through those cases, I'll just maybe put those into a written order so that everybody's clear on where the court stands on it. But generally, the video would be admissible to show the manner of death, how the body was found, the wounds, and how the defendants and the witnesses interacted at the scene at the moment the police officer arrived. Although I'm not sure I've got the cases here, there are, I believe, some cases that talk about the state's entitled to prove its case the way it believes the evidence is appropriate. The court does have to balance that out with 401, 403. And having done so, I'm going to go ahead and permit it. I think this would be a good opportunity, and I'm going to say this again probably tomorrow and then maybe again at some point during the trial of the case. The state makes a good point. That video is a very real depiction of a scene that may be shocking to some. This court does not expect, and I would hope everybody would respect the fact that there would be reactions in the courtroom to any evidence presented or any outbursts even not associated with any evidence as it is presented. We are going to have a very small gallery, so I don't expect there to be a lot of folks here, but there's a lot of emotion associated with this case, and so I say that, and this is not the only case I've said that in. A lot of more high-profile murder and sexual assault cases that I've been involved in, I've said the same thing, and I realized as I was watching that video that I probably hadn't said that, at least in this courtroom, so I do want to make sure that everybody understands. If you don't feel like you will be able to sit in this courtroom and do so in a way that's not disruptive, I do ask that you go ahead and take a step outside if you need to. All right, the last matter I have then on the McMichael's motions is the vanity plate.
And I also made the state aware of our a motion in limine that we wanted to make, and I was going back over the state's list of exhibits that they wanted to play during opening argument, and one of those is the photo in life.
I thought we'd gotten past. Don't we just have one?
One what?
One photo in life?
Yeah, we wanted to move in limine to not use that photo, and I made the state aware of what we were asking for, and then I wanted to make the court aware that we're objecting to the use of that photo in life, and just wanted to bring it up to the court now. We can do the vanity plate since it's on the menu, but we also wanted to bring up that, and I made the state aware of this. It's not in writing, it's an oral motion in limine.
Okay, well, let's go ahead with the motion on the vanity plate.
Okay. We have what appears to be a photograph taken of the truck that shows the old Georgia state flag vanity. It's not a vanity plate, it's just an old flag plate that is the one that the court allowed us to ask questions about during jury selection, that a lot of people saw as a symbol of racism. It appears that the state is not intending to make this case about race or racist motives unless the defense opens the door to that type of evidence, wherein the defense would intentionally put in the character of Mr. Travis McMichael. That plate, though, is something that the state has responded by saying this is a plate that Mr. McMichael chose to put on the front of his truck to drive around town and to advertise to the world as sort of who he is and what he's about. So I think the state, as it's characterized it to us or to the court previously, I can't remember if the state has gone on the record with it at this time, but it certainly has shared with us that they intend to argue that this is a statement by the defendant, and it's a racist statement by the defendant, or one that is certainly suspect and could demonstrate motive to go after Mr. Arbery on this day for reasons other than investigating or trying to delay somebody through citizen's arrest. I don't believe the license plate is really visible in a lot of the video, but to the extent that it is, we would ask that the court limit the playing of any photograph or video of the front plate, because it's inflammatory and because it injects into this case something that we all have been trying to avoid and trying to obtain jurors who don't have strong opinions about this as well. and for that reason feel like it's an improper comment, at least as we understand the state intends to use it, on Travis McMichael's character, which is not in evidence until he places it into evidence. And so we're asking for the court there's a photograph, if the state wants to show the truck and its placement, that we at least blur out or black out the license plate on the front of the truck.
From the state.
Well, two things. First off, that is not what the state is intending, is to put in character evidence of his motive. Character evidence is character evidence. Motive evidence is motive evidence. The state at this point in time is not anticipating putting in its case in chief motive evidence of racial animus. And there is no limitation. I don't want Mr. Sheffield to be under the impression that the limitation is when Travis McMichael opens the character door. No, if Travis McMichael opens the motive door, the state's going to walk through it, because the state is entitled to present motive evidence. The fact that the state at this time is not anticipating tendering motive evidence of racial animus does not mean that that's not going to happen when Travis McMichael takes the stand and starts talking about his motivations, because it's not character evidence, it's motive evidence, and there is no need for the state to provide advance notice of evidence of motive, even though we have in this case provided that with ample notice, out of an abundance of caution, filed it as a 404B, and then withdrew it as a 404B because it's not coming in our case in chief. And then we did actually provide it to the defense on a jump drive with all of the racial animus evidence that we anticipated tendering should the issue of Travis McMichael's motive come up. So I don't want the defense laboring under some misapprehension because I didn't speak up right now and inform them that character and motive are two separate things. So right now we don't anticipate putting it in, but we do anticipate, if it comes up, to discuss his motive, and one of his motivations being racial animus. With regard to the vanity plate specifically, the vanity plate is something he specifically put on his brand new truck that he purchased the truck after January 1st of 2020. There's been no indication that it's something that it came with the truck and he just didn't remove it from the truck. It's just that he placed it on the truck. He placed it on the truck and drove around in the truck for everyone to see that on the very front of his truck. To now come into court and complain that it somehow shouldn't be put before this jury, and the state has a couple of problems, Judge. Which photo are we talking about? This truck is in about 10 of the state's crime scene photos. And then it's also can be seen vaguely, it's very fuzzy, in Officer Duggan's camera when his car is there. It can be seen repeatedly in all the body cam videos as the officers are walking around. They can see it very, very clearly. So the practicality of the motion is that it's almost impossible for us to blur this out every single time. I actually wouldn't know how to blur it out of body cam video. I'd have to edit that, and I wouldn't even know how to do that. But we have numerous crime scene photos. The fact of the matter is that this is something Travis McMichael put on the front of his truck. He wanted the world to know this. He put it out there to see people, for people to see him driving around with this particular plate on the front of his truck. Little disingenuous at this point to ask that it be blurred out as if somehow it's not relevant to this case. And it is relevant to this case because there comes a point that's in Mr. Bryan's video where Mr. Arbery is running down the road on Holmes. The white truck is coming toward him. At that point, he turns around and runs back past Mr. Bryan's truck. This happens at the blue mailbox. So the defense, of course, is going to argue, well, there's no evidence he saw it. Well, he turned around for some reason. Whether he saw that on the front of the truck or not, he was looking at the truck, and that's what's on the front of the truck. So at this point in time, we ask that you deny this motion because this is a choice Travis McMichael made. It would be as if he chose to put on a T-shirt that had the Confederate flag on the front of it and then somehow wanted us to blur that out. That was his choice of clothing that day. This is a choice of something he put on his car to advertise to the world as he drove around in Brunswick, and we do have circumstantial evidence that Mr. Arbery did see the front of this truck because when the white truck is coming toward him, Mr. Arbery turns around and starts running back past Mr. Bryan. We ask that you deny the motion.
There's two issues going on here, and I think it's worth addressing. The first is the fact that the plate exists on the front of the truck. Okay. The second is an interesting issue because it dovetails into something we spoke about earlier today that's under advisement, and that's whether or not probation is relevant. To me, there is parallel logic in the two arguments. Let me explain. The defense argument in the probation matter that it should be in is that it is evidence, and I'm not going to be very artful with this, but it's evidence that it's not character evidence. Instead, it is informative with regard to Ahmaud Arbery's actions when confronted or when this chase was going on. Okay. Parallel logic, and this is what I'm trying to figure out, maybe we'll get it when you come back up, we'll talk to the defense. Parallel logic is then, and I'm just throwing this out there, I'm thinking out loud, which is always dangerous. If the state's argument is exactly, well, I guess it is exactly that, you know, the truck was coming towards him and Mr. Arbery saw this truck coming down the street with a 1956 flag or whatever the year was. Did that inform his actions in some way? It's an interesting parallel, which maybe helps the court with taking the probation matter under advisement, because I think I need to think through the logical equivalencies there in ruling here. So, anything on that?
Yes, Judge. The state's not saying he turned around and ran away from the white truck because it had this flag on the front of it. As I just said, I can't prove he saw that flag. I can't prove that that's what he noticed. What he saw was a white truck coming toward him. I guess to me it's not parallel in the sense of the speculation about what was going on in Mr. Arbery's mind about his probation is complete speculation as to what was happening in his head. We know he saw the white truck. We know he saw the white truck and he turned around and he ran. What was on the front of the white truck is what was on the front of the white truck. It's a fact in the case. Whether that is why he turned and ran, I don't know. And I actually am not comfortable making the argument that, hey, that's the reason he had to turn around and run away. But it is a part of the case, and it's what is on the front of Travis McMichael's truck. And for the state to be required to blot it out or hide it from the jury so that they don't see what he put out there in the world, it's difficult, because if it does come up as racial animus, which is something, if Travis McMichael takes the stand, we're going to ask him, well, why do you have that on the front of the truck? Now, his answer could be, heritage, I like the symbol, it's the old flag, whatever he says. The state is then allowed to cross-examine him on, isn't this part of your racial animus? And doesn't that dovetail into all of these other things, that's the bucket of racial animus? That's a cross-examination question, and that's why the tag becomes relevant, if it does, for motive and racial animus based on that. The fact that it was on the truck is a fact. The fact that Mr. Arbery saw the white truck coming and turned around and ran, I'm not going to speculate in my closing argument that he saw this plate, and that's why he turned and ran. He saw the white truck with the men who'd already threatened him coming towards him. So that's kind of where we're at. I don't see that they're parallel as to speculation as to what was going on in Mr. Arbery's head. Speculation that he did this because he was on probation and the probation fear was what was driving him is complete speculation. And it also is more prejudicial than probative, because the only reason to get into the probation is we're getting into Mr. Arbery's character. Speculation as to whether he saw that plate or not doesn't get into Mr. Arbery's character. It doesn't get into Travis McMichael's character, because he's the one who put it out there. It's not putting that license plate on the front of his truck doesn't go to his character. It's something he specifically did and adorned his truck with. So they're completely separate kind of issues, Your Honor, and that's the state's position on that. Well, if I may have one moment, I want to check with my colleagues.
For the record, we join in this motion.
And as my esteemed colleague has pointed out to me, which I really thank her for, is the fact that this is intrinsic evidence. It's part of the case. It's what happened. It's on his truck. It's intrinsic to what's going on. Probation is extrinsic. Probation is a status. Probation is something that's going on in Mr. Arbery's life and has been for a number of years. So it's extrinsic evidence to speculate as to what's happening in his head. This was on the car during the incident. So it's intrinsic to what's actually happening during the entire incident that leads up to the homicide.
Just maybe an inquiry first, if I heard the state correct. We know he saw the truck, and that's why he turned around. I'd just like to inquire, what is the evidence that he saw the truck? Because the state seems to know that he did. So the state has now jumped into his mind. They're offering what he knew. I'd just like to inquire what evidence exists that he knew and saw the truck.
Not sure if the state wants to engage on that, but
Yeah, the state's not going to take this bait.
I'm sorry, it's not bait. It's a reasonable inquiry based on the state saying that they know what was in Ahmaud Arbery's mind when he turned. As a matter of fact, the evidence will bear out that Mr. McMichael's truck was nowhere near that moment. So the state is allowed to say to this jury and to the court what it knows Mr. Arbery knew, but we're not allowed to. This becomes the issue for the court. I think we have to be careful here. We're either going to talk about what's in the mind of Ahmaud Arbery or we're not. And so, I think the court's inquiry is interesting. Essentially, you're saying Ahmaud Arbery does something because of another thing.
well, I was asking on the arguments that I was hearing, whether I was hearing two different arguments, because what I heard was what I guess you could couch as an intrinsic evidence argument, which is it was on the truck. Right.
And he was on probation.
You're putting words in my mouth.
No, I'm putting words in my mouth and giving them to you. I'm not giving you words. I'm putting words out there for you to hear.
It's a very artful way of saying that. The second issue, which came to me as we were sitting there listening to it, is I still have a matter under advisement. And so I was just working through the logical equivalencies of both. And sometimes, as I have discovered in this case, actually talking about what I'm thinking while I'm thinking it results in rabbit holes.
It assists us in trying to address the court on matters. We appreciate it when you think out loud. But I will say this. We know for a fact that Mr. Arbery was on probation, and I know this is under advisement, so I won't delve back into that. But to the extent the state addressed it, it's intrinsic, and the cases have interpreted as intrinsic, that somebody is actively on probation. And we have a long history of seeing the way that he has interacted with probation.
Yeah, and I flinch only because those cases, I understand, were actually running from law enforcement cases.
I understand, but law enforcement wasn't aware that the person was under probation at that time. And that's not being offered as character evidence. So the state wants to go directly to why you should exclude it, but it's being offered for other purposes. Now, the truth is that the evidence will show, and the jury will be told, that by the time he turns around, Mr. McMichael's truck is way past him, and that they have already gone up that road. We don't know why he turns. And the state, if they start to say why they think he turns, then they're jumping into his mind, which becomes interesting. The flag being put out there, and I think what the state is saying to the court essentially is they're going to use the flag on the truck as a way to ask him, why do you have this flag? And even though his answer might be, because it's a Southern symbol, not a racist symbol to me, that then they can say, well, now that we've asked you about the flag, let's get into all of these posts and all of these other things that demonstrate racial animus. And the flag on the truck becomes maybe the can opener for that in some kind of a way. And they're not going to put it in their case in chief. So how does Mr. McMichael taking the stand and talking about what he did that day and his intent on that day, how does this flag then help establish motive when his actions are not about motive on that day? His actions are about what his intent was that day. That's what he's charged with. He's charged with intent to commit crimes and his intent to use self-defense. Motive plays no part in it. What we're asking is that the state not be allowed to travel under this way of trying to say, oh, we're removing all of our 404B, we're denying the defense a hearing on 404B. We had hearings on 404B, Your Honor. You had a rule in place pre-motion and all this that we're going to do 404B. 404B addresses motive, and the state has denied us that. They have removed it now. The court order that you put out was it was time before, and now we're past that. And now the state is saying, as you've heard, we're going to use this as a can opener to get into all the 404B stuff because the license plate happens to be on the truck. The remedy here is how many photographs of a truck do you need? There's lots of videos that can alleviate this problem. And so I think it's a simple solution to just not show it because it's an impermissible. I understand the difference between character and motive, but in this case, the state is assuming that just because he testifies that it opens the door. I certainly would say at a minimum, the state should not bring it up in opening. The state says they do not intend to offer it in their case in chief. And if something comes up on rebuttal or cross-examination, perhaps we take it up at that time. But until then, we should not be seeing this license plate on the front of the truck. I think that would be the fairest way of handling this issue.
Your Honor, I would like to be heard on that. It might take a couple minutes, but I desperately need a bathroom break.
Okay. Let's go ahead and take a 10-minute recess. All right, let's, everybody's up. Okay. We're good? All right, let's come to order. I thought maybe there was something going on.
I'm sorry, I thought I was going to do my rebuttal, my second rebuttal thing right now on the vanity plate issue.
Okay, let's do that, Mr. Brown. Instead of having to walk a long distance, if you just...
I'm kind of feeling like Rodney again, but okay, I'll just stand over here. All right.
All right, we're back on. Defendants present, represented by counsel. Let's go ahead from the state.
Just so we're clear on the record, the state is not going to argue what was in the mind of Ahmaud Arbery. That is not what we're arguing. So just wanted to make sure that that was clear as the last point before we took our break, that that was what the state was going to say. Thank you, Judge.
Okay. Mr. Goff.
Your Honor, it is, with all respect to learned opposing counsel, it is utterly disingenuous to argue to the jury on the one hand that it was fight or flight. Ahmaud Arbery fought for his life because he had no choice, and then at the same in the same time try and say that you're not going to present evidence of what you contend. I don't know how they could overcome the proof problem as to what Mr. Arbery saw, but assuming they could, how you get around the argument that he saw the license plate, and that's why he felt fight or flight and feared for his life. It just seems somewhat disingenuous, and when the court presents the evidence, unless the state's going to craft a limiting instruction, it's still going to be considered. My primary concern here is a process issue. We've had a bunch of motion hearings in this case, lots of conversations between counsel, and it may yet be that I've misunderstood the last exchange that took place on this break. But, coming into jury selection, and certainly it was something we took into account during jury selection, my understanding, and apparently I was mistaken, was that if a defendant testifies in this case and places their character into issue, opens the character door, that evidence of racial animus, if that's what it is, the state would try and admit that in rebuttal. And that was my understanding. Now I'm learning today, after we've already selected the jury in this case, that if a defendant simply testifies, that the mere fact that they're testifying is now going to open the door to evidence of racial animus. And the way I would put it to the court is, supposing that the defense calls Travis McMichael to the witness stand. One question: what happened? I shot Ahmaud Arbery in self-defense. No further questions. And simply having said that he acted in self-defense, now the state, as I understand it, contends that the motive door has been opened, and they're going to bring in all of this troubling information. Your Honor, it's deeply troubling to me that late in the game, it turns out we've been playing hide the ball all along. If I understood correctly on the last break, that's troublesome. Here's another issue that's troublesome, is if the state is going to present evidence of racial animus as to one or both of the McMichael defendants in this case, and of course I can't predict whether they're testifying or not. I couldn't say. But if that happens and Roddy Bryan doesn't testify, and evidence of Roddy Bryan's racial animus is not admissible, how could we possibly avoid the spillover effect to defendant Bryan of this highly charged racial animus evidence against the McMichael defendants? The practical reality is, if the state's going to go down that road, and the way I heard it, the state is going down that road. The state has just cleverly couched it for the court in such a way as a court couldn't address it before jury selection. Well, it would have been nice to have done that so that Mr. Bryan could have made an election about severance prior to the trial. And of course, we do have the added complication that Mr. Bryan has a speedy trial right running in this case. And as I understand it, the state thinks they could turn around and retry this case a second time in January. And if they can, more power to them. But the practical reality here is it's just a completely unnecessary nightmare scenario. And the easy answer is not to let the state do this, and once again, try and have their cake and eat it too. They've made representations. I thought they made them to the court. I know they were made to counsel. Maybe I misunderstood them. But to come in now and say that basically if Travis McMichael gets on the witness stand and says pretty much anything more than his name, that all of this stuff is going to come in, I don't care whether you call it motive or 404B. This is exactly the kind of stuff this court has labored long and hard for 17 months to address these issues beforehand with ample time to ponder them and the implications and not get jammed up in the middle of this trial. And even if the court would otherwise allow it or otherwise consider it under the rules of evidence, I think just as a matter of process, the court shouldn't allow the state to do that in this case. Your Honor, I'm also concerned about the state's theory. I still don't understand the state's theory that they're pursuing, but I guess I don't have to. I mean, I have all different scenarios. I guess I'll find out in the morning what the state's theory of this case actually is. But getting back to the issues at hand, the court has rightly observed the parallels in the evidentiary issues in this case between the admissibility of the probationary status of Mr. Arbery and the admission of this, for lack of a better phrase, Confederate license plate.
Well, just to be clear, I noted that there could be or may be issues there, and I was asking counsel to inform the court as to their positions.
Well, I certainly didn't mean that the court had prejudged the issue. The court simply raised it and brought it to our attention. I do think that there are important parallels. I have maintained from day one that the mental state of the deceased was an issue in this case. We will be addressing it at some point again with respect to the issue of aggravated assault. We're not going to go there this afternoon. But certainly I could see why the state initially came before Your Honor and said that this is why Arbery feared for his life. I understand the argument, but let's follow through with that for a moment. Under 403, what is the probative value of this license plate? And the problem here is that the state's argument proves too much. Surely it cannot be the law that, particularly given the First Amendment, that the court is just going to admit any evidence that any person ever displayed a Confederate flag, sung Dixie, had a bumper sticker. I mean, I can remember in law school singing Dixie at Gray's Inn in England. I didn't realize that today I could be determined to be a racist because of something I did. Now, the temporal issue here is obviously closer, but still, can someone really say in Ahmaud Arbery's shoes that just because they saw a Confederate flag or a bumper sticker or any of those things, that would meaningfully inform their decision and what they've done? And once we get to think about the larger ramifications, there's lots of other symbolism out there that is troubling beyond the Confederate flag. And if we're going to go down this road, I don't know where it stops, but in this particular case, I think it's a stretch to say that simply seeing a Confederate symbol, particularly a state flag of the state of Georgia, a flag which until not so long ago still actually flew around government buildings in southeast Georgia, including, I think, at least one prison. The probative value of that is extremely limited. And it's almost like converting a Confederate symbol into a license to commit violence. And while I understand where the state's coming from, I think when you follow it through to its logical conclusion, the state is trying to put far too much weight on something that has little evidentiary value. Well, at the same time, it is incredibly prejudicial and is probably going to trigger a severance in this case. Your Honor, I think when you compare it to the probationary status, putting aside what I think is pretty clear case law on that, but I'm not going to add to what's already been presented by the McMichael defendants, but the probative value of that evidence is substantial. And when you're comparing it to this license plate, there's no question that the license plate's not admissible.
because under 403 it's hugely prejudicial and has almost no probative value. I could think of all the police officers around the state who are watching this trial thinking, oh my goodness, 10 years ago, 5 years ago, I had the Confederate flag bumper sticker. I had a party at my house where there was a Confederate flag. I went to a reenactment. And any participation in that activity, which would otherwise be protected by the First Amendment, can suddenly be taken in retrospect and used.
The way you're going may undermine the prejudicial effect if you're just suggesting that it's not something that is that.
The probative value is minimal, the prejudicial effect is high, and it impacts not just this case. There are huge, broader societal implications. Among other things, it has huge implications for law enforcement officers at a time when people are leaving law enforcement in record numbers. This kind of gotcha, that's the only way I know how to describe it, gotcha prosecution. Oh, he had a Confederate flag license plate. Gotcha. Now all of a sudden we're going to transform a citizen arrest case, an unlawful arrest case, an excessive force case, we're going to transform that into something else. And that's deeply troubling. And I think that the court should seriously ponder whether or not this is admissible. I think the court also needs to seriously consider, and I think the court is beginning, and I could be wrong, but I think the court's beginning to see the concern that I have had and that other counsel have had from the beginning of this case, that this theory the state has traveled under, that the mental state of Mr. Arbery is not relevant to any issue in this case, simply doesn't hold up the deeper you get into it. It might not be relevant to this one issue, it might not be relevant to that one issue, but it does turn out to be relevant to a whole bunch of other issues in this case. And I think it would inform the decisions of the court if we address that more fully. But we don't have to do that now, and I think I've said more than enough, and I'm going to sit down and defer to learned co-counsel.
I think we've argued all sides of the issue. Okay. As the court's indicated, I'm working through a few things on this motion along with the probation motion. I'll take it under advisement. I realize that we're heading to openings tomorrow morning, and I will get an order out prior to opening so that everybody knows exactly where we are. All right. A couple things. Well, first of all, those are all of the what I've listed as open defense motions.
I mentioned to the court the oral motion now
Yeah.
on photo and life.
And I was going to get to two things that I think are follow-up, and that's one of them. One of them is there was a motion with regard to Mr. Bryan's video, and there was a motion about playing the video and opening. At our last motion hearing, I believe, well, based on my notes, it was my understanding that the parties were going to be coming to some sort of agreement about the video and the use of the video in opening statements.
Yes, Your Honor. Actually, this morning we exchanged emails about which pieces of evidence that we'd be using to display in our opening, and I sent the defense my list, and I think from that list is what came of Mr. Sheffield's motion about the photo and life. I've not actually had a chance to look through Mr. Rue's, but I've received it, but I have not had a chance to look through it. And the host, I've received Frank's, but I have not had a chance to look through yours either. And I will attempt to respond if there's any sort of objection well in advance. But you guys have had a chance to look at mine? Yes, okay. And Mr. Goff, you've seen mine as well?
I've seen yours.
Okay. So I believe at this point in time we are all playing the video in opening. Is that correct?
Or portions or stills from it, yes.
Yes.
And so therefore I think that we're all in agreement on that.
I think that answered my question, but really this was done in two motions because one was an admissibility of the video. Has that been resolved, or are we still working through the admissibility issues on the video? Or
No,
authenticity and admissibility, I should say.
I believe that we filed that. Once again, it was, I believe the court ruled it was premature, we should follow the rules of evidence, and that we should go ahead and make sure that we can tender it in. I think we did it out of an abundance of caution because we were putting the law together to support that. Obviously, having talked with defense counsel, I don't think anybody's going to object to us tendering that video in, given we've all just played it in opening statements. So I think it's probably a moot issue at this point.
Yes, Judge, I don't anticipate any issue with the authenticity of the video or the relevance, anything like that.
We're good.
Okay. All right. So, and I just want to make sure, because that was sitting out there as we're going to discuss. It's a relatively significant piece of evidence in this case, so I just want to make sure that it was clear. This picture, so my other notes from this, and I couldn't find the motion, but there was some discussion about the use of photographs of Mr. Arbery. I thought that was addressed, and there was an agreement that we're going to reduce that to 1, and now apparently there's a debate over the 1.
Yes, I've learned a lesson when, as you said, if you give a lawyer 4 hours, they'll take 6. I agreed very early on that we would limit the photo in life to 1 photo, and they also requested that we not put it in through a family member, and I agreed to that. And then, of course, I said I might have to put it in through a law enforcement officer, and then I was told, no, you have to go ahead and get a real witness up there, so now I'm having to find my regular non-family member witness, which I believe I have, and now there's an objection to the photo I want to use. So that is where we're at with that, Your Honor. And I believe it's just a motion in limine. I will go ahead and cite to Walker versus the state, which is 862 Southeast 2nd, 285. It's actually an August 10th, 2021 case. It was a murder out of Fulton County. And I actually think it's my case. So this is one of those. It's where the holding is that the trial court did not err by allowing the state to introduce an in-life photograph of the victim wearing a graduation cap and gown and holding a diploma, while declining to allow the defense to offer its own in-life photographs of the victim, as the state's photograph depicted the victim alone and was proffered through a non-family member. The mere indication of the victim's graduation was not offered or argued as evidence of good character, and did not open the door to the admission of evidence of the victim's alleged bad character, which was featured in the other photographs. The defendant did not argue that the defense's photographs were offered to prove a character trait that was an essential element of a charge, claim, or defense. So basically what this case held was that when the state tendered in the photograph, even though it was an older photograph, even though it was a photograph of graduation, it was what the state had to offer. And it's not inadmissible, because the complaint, I believe, from the defense is that the photo the state wants to put in is an older photo. And it's kind of a professional photo. It's the sepia tone photo where he's got his hat. And they're requesting that we find another photo, something more along the lines of how he looked at the time of his death, which the state is allowed to put up the evidence the state needs to put up. And that's what we intend to do. So I will let the defense make their argument. But based on this case, the state is allowed to place the photo in life in.
What's that case?
This is Walker v. the State. It's a Supreme Court of Georgia case. It is 862 Southeast 2nd, 285, from August of 2021 out of Fulton County.
Thank you.
Just taking a look at the case, if that's all right.
Yeah, good. That'll give me an opportunity to do the same.
Thank you.
Yeah, I have one brief motion to make if we have a minute. It'll take less than 30 seconds, and it's something the court may already be planning to do. But I'm moving the court to each evening when we conclude to give the jury the normal admonitions about media and so forth, but each morning inquire of them before we begin evidence whether anyone had any contact or media, inadvertent or otherwise, just to make sure that our jury's being untainted.
So here's the challenge with that, and I think that's a good idea. When we get into this, we fall into rhythms in cases, and because I'm not used to doing it, unless I put something out in front of me, I may forget to do it. I will try to do that. I have no problem with you reminding me to do that. It's just creatures of habit. I generally do it every evening. I don't generally follow back up first thing in the morning. So, but I don't have any problem in this case, given the the attention being given the case and the jurors. I'm happy to do so.
Okay. I see the case here. Appreciate the site by the state. And it looks like Walker essentially says, the court says, we have held, generally, in a murder case, a photograph of a victim in life may be relevant to prove an element of the corpus delicti. That is, that the person alleged to have been killed is actually dead. I followed these lines of cases all the way back to 1983, where essentially Mincy versus State said a photograph is relevant to any, this photograph which is relevant to any issue in the case is admissible even though it may have an effect upon the jury. So that's fine, I understand that. The in-life photo I understand is going to be offered by a non-family member. That's fine. The photograph that we understand that's being offered is from 2012. It's not a photograph that depicts Mr. Arbery as he looked in the years leading up to February of 2020. To the extent that the photograph is not an accurate depiction of him around that time, we were asking that the state not use it. To the extent that the state has to prove that he was alive and is now actually dead, they're going to be playing the video that shows him running through the neighborhood. That certainly satisfies that requirement. The video itself is a wonderful photograph of Mr. Arbery. It does not accurately depict the man, however, on February 23rd. We do have some photographs of Mr. Arbery closer to that time. We intend to offer those into evidence through this witness, potentially. And so we're asking that if the state is representing that they want to accurately depict that he's alive, they can do that through the video. The video will be played in opening statement and tendered into evidence. And that while on its face, it's not good character, certainly that is something that the state could begin to elicit, and that only makes it relevant if they do. So we're not arguing at this time that it opens the door to good character evidence. So with that, we're asking that the court exclude it because the video satisfies the state's needs. And if they don't, then if they put it in, then we'll put in other photographs through the same witness.
Okay. That sounds like almost exactly the scenario that occurred in Walker v. State. What I'm reading here is that the state was going to introduce an in-life photo. It was a graduation photo that was older, wearing a graduation cap and gown, holding a diploma. There's an issue about whether that was character evidence. The defendant's trial counsel then was going to offer 5 other images, apparently from a social media feed, depicting the decedent holding cash and a handgun and flashing gang signs. Apparently those were not admitted. It became an issue. No, I'm not suggesting you are. I'm going through Walker. I'm going through Walker. So it sounds like we're on point here with Walker. So what is the photo? What is the objection?
It's a very nice photo of him in a ball cap. It's a professionally taken photo from, I think, 2012, after high school graduation or around that time. It's just 8 years prior to this. Also, the issue, Your Honor, is, and the state is not conceding identity in this case with those prior videos, and so we intend to prove the identity of the person that was in the house on October 25th and November 18th and December 17th and February 11th, and we think the photos that we're offering, and we'll show them to the state prior to our cross of this witness, they're not bad character photos. They're just photos of him that we obtained through evidence, videos, whatnot.
Your Honor, we would join in the motion. I don't think we formally put that on the record. I would also point out, although I think the court's aware of it, there are not just the one in-life video. There's other videos from February 11th and other dates that are also technically in life.
I don't know that the state concedes that those are Mr. Arbery, though, but certainly on the day of February 23rd, they do.
I thought they did that on the record at a previous hearing, but I could be mistaken.
Agent dialed it, but not the state.
Very well. Just to be fair, I mean, if there really is an issue with having a recent in-life photograph, I mean, I think that puts the case in a different posture. But if there are more recent in-life photographs, then what would be the point of presenting one from 9 years ago? Other than to try and suggest to the jury that he was a jogger that day because he wears athletic clothing and a ball cap, which is clearly not proper.
The court has got it by precedent. There's a Georgia.
Your Honor, I'm having that same kind of problem now. That might be.
Let's try that. Okay. There is Walker's Supreme Court precedent sounds like it is squarely on point. The court will permit the state's use of that photograph that was described. I'm just based on the offhand comment and no understanding of what the other photographs were. I can also, Walker's also a guide for the court on what would be permitted from the defense.
100%.
Okay, and obviously whatever, I haven't looked into cases cited in Walker and what they may say, but it would at least provide some recent guidance to the parties. Okay.
Very good.
I have not seen any photos from the defense, so I don't know what photos Mr. Sheffield is talking about that they would be tendering in, having not received them in discovery. So,
All right, as far as open motions before the court that need to be addressed before the jury is brought in and openings occur, let me hear from the state and then I'll go around.
all right, Judge, what I have left, the first is I wanted to let the court know that the defense in the state has we actually entered into a stipulation. I know, and we've signed it. We signed it the first day we got here, so we're good with our stipulation. We will tender it in at the appropriate time.
What's the stipulation on?
I will.
You don't need to read it to the court, just generally what's it on?
It's on some of the state's evidence where we had out-of-state witnesses that we didn't want to have to fly in to just lean into the microphone and go, yes, I did this enhancement, or yes, I tried to enhance the audio and couldn't. So it's mostly GBI agents and some people out of Tennessee that we're not bringing in, and the defense has agreed that we don't need them to authenticate the evidence.
Okay. I generally give a charge on a stipulation, so if a stipulation is going to be used, I give the charge. I'll pull the charge just so everybody's aware of it, so the jury understands when we say stipulation, we all know what that means. Maybe the jury doesn't, so that's the way I handle this. So please let me know if anything's stipulated to. We'll make sure the jury gets charged.
Right, we will do that. As far as Larry English goes, I believe we informed the court, and I think I sent an email to your office, and we have all agreed to use his deposition given his health issues at this point in time. In addition, we received the transcript and we received the video. We have reviewed the video, and the video has been edited to everyone's satisfaction here. And so we've all agreed on the video. Is that correct, counsel?
Yes.
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 And so that is the video that will be tendered in. In addition, to make things really fun, we have also all agreed that at certain points, Mr. Camarillo is going to have to stand up to play potentially some of the original evidence, because the camera's on Mr. Camarillo, the camera's on Mr. English, and the evidence needs to be played over there. We are working with Cedric to do a split screen situation or a stop where the jury can see the videos and or listen to the 911 calls.
Okay, I understand.
Yeah, and we will work that out. The second to last thing, two more things. We need to sign the indictment. I believe we had, due to COVID, we virtually joined issue when everyone pled not guilty, but we have not actually formally signed the indictment. And the indictment on the bottom only had the 2 boxes, so I have asked the clerk's office to make an additional copy of the front page so that everyone can sign, and then the indictment would go back with the signature blocks on them.
Okay.
I haven't gone back and reviewed it, but I thought I had a demur, and I thought the signature was one of the issues in it. Maybe I'm wrong. I thought I raised every defect I could think of, including the judge's name at the top of the document. Maybe I overlooked it, but
I don't think you get to come back in and sign the indictment after we pick the jury. I mean, either the document is valid as it is or it's not.
You don't want your client's signature with the not guilty check on it to go back with the jury.
Was this the issue that came up? I think, is this from the arraignment? Because the defendants were present by video at the arraignment. We arraigned them, and they entered their plea. So this is simply their signature on their not guilty plea?
Correct. That's all I'm asking for, is that the actual indictment had their not guilty signature. They couldn't do it at arraignment, which was when we would normally join issue and have them sign not guilty and everything.
If learned co-counsel have no problem, then I have no problem.
Yeah, I can't remember how we were dealing with it at that time, because in Chatham County, the way we were doing that, a lot of times the clerk would enter the signature on the face of the indictment, or they would get processed through the jail. I'm not sure. I'd have to go back into the actual record to see how we did that and what everybody agreed to.
I had the clerk go back in the record, and I had her pull out the transcripts of what we actually did, which you kindly did, so she can give them to you for your review on how we handled it due to COVID and them not being in the courtroom or courthouse.
Certified compliance to the Uniform Superior Court rules and all that. Okay.
Yes. Yes. And then the last thing, I think we have the bench conference issue. My understanding with bench conferences is there's 3 ways to do it. Actually, I think there's 2 ways to do it. To waive presence at bench conferences, and then with the assurance that defense counsel goes back to the client and informs the client completely of what happened, or no waiver of attendance at bench conferences, and then we don't have bench conferences. So I have no idea what the election is on bench conferences.
Yeah, we're not expecting that the court is going to bring our client with us. We'll come up to bench conference and we'll let them know what's going on. It'll be reflected on the record. We have no objection to doing it that way. That's not a problem.
Make sure that you've consulted with your client, because anything substantive that's discussed at a bench conference and decided at a bench conference, I need to know that your client knows and understands what the issues may have been and has given your authority to discuss those matters. The challenge is we don't know what those bench conferences are. So I generally try to keep them to a minimum. I mean, I don't think we try the case at the bench. And what I have been doing, particularly with COVID, is just clearing the jury out. If something really comes up we've got to discuss, is clear the jury out and discuss it. So I only say that because that sort of gives everybody the parameters. I don't do a lot. Coming to sidebar is just not something I do regularly. So I guess the question then becomes how we want to address anything that does result in sidebar. I guess the way to do it is if it requires discussion of something other than a procedural matter, then the clients need to be consulted and see whether or not they wish to join. And if they do, I'd have to clear the jury out.
All right. We'll make it clear for the record that we are going to come up for brief bench conferences on probably minor issues of presentation, and we'll reflect it back to our client. Our client has no objection about that. If it's a more extensive matter, then we'll ask or indicate that we need to take it up outside the presence of the jury.
The issue would be if it's material, substantively material,
Right.
then we need to make sure that they're aware of what the issue is and what's been discussed.
100%. Thank you.
We concur.
We concur.
Okay.
And lastly, I have our Bruton issue. And what we did with Bruton, per the court's instructions, was defense counsel, when we were here in July, I think we gave Mr. Rubin and everyone 2 weeks to look at the transcripts of all of the defendant's statements per the state's motion about Bruton. At which point in time, we all approved the transcripts. The state then did as the court instructed and went through and yellow highlighted all the parts that we wanted in that we felt did not violate the Bruton position. I then emailed all of them to opposing counsel. Opposing counsel, Ms. Hogue especially, was very responsive and returned them with blue, meaning I think this comes in because it's rule of completeness, and red, this should not come in. We then had several Zoom conferences about this, which was pretty helpful. And we responded with comments. In other words, the state's okay with this, and we agreed to some things. The state disputed certain other things. And we then copied the court on that with all of the different highlights in all the different areas. Travis McMichael's statement we had all agreed to with the yellow highlights. There was no dispute about that. But of course, when it came to Greg McMichael, his statements were very intertwined with a lot of stuff, as was Mr. Bryan's statements. The unfortunate part, Judge, is that this all happened September 11th, and on October 5th and October 7th, we got our comments back to the defense. So this has been everything. This morning, unfortunately, Mr. Goff came up to the state and went, "No, here's what I want to talk about in opening statement." We had no idea. This is the first we've heard about it, and a number of items, in our opinion, violate Bruton and talk about the defendants, Travis McMichael and Greg McMichael. In addition, some of the items are pages and pages that we did not put in, meaning we find them to be, what am I trying to say, self-serving, and we were not going to put those statements in, but now Mr. Goff wants to put those statements in. And once again, it's the state saying, here's the statement of the defendant we're putting in. If there's a rule of completeness around it, that's great. And now we've been handed these documents this morning where he's saying he wants to talk about them in opening statement. And at this moment, I don't know what to do about that except to object, because it's completely untimely. It's not what the court ordered us to do. Back in July, August, the first week of August, we received all these transcripts. By September 11th, we had returned them to the defense for them to get back to us. We didn't get anything back from Mr. Goff. We responded back to the defense October 5th and 7th with our comments, and here we are November 4th, and Mr. Goff is finally, right before opening statements, telling us, well, this is outside of Bruton and I want it in, and the state would object at this point at all.
Is it, are they, by bringing the, I don't know what we're talking about specifically, but what are you suggesting to the court is that these things that had been excluded based upon the agreements that have been discussed were Bruton issues that were removed?
Yes, so for instance, I'll give you for instance. We had not intended to put in anything Investigator Lowry was talking to Mr. Bryan about, because Investigator Lowry was giving his opinion and suggesting some things, you're telling me this, and then we end up talking about a whole bunch of stuff. We weren't going to put any of that in because it's not relevant, especially about how Mr. Bryan's phone ended up with 2 copies of the video on it, which Officer Minshew is going to explain how he tried to make a copy of it and email it to himself, and all that's going to come out in advance. But it appears Mr. Goff wishes to put this in, where the state never highlighted that when we sent it to him. And he never responded back to us in this entire time since we sent it September 11th. So there's parts of these things that, some of it we're okay with. There's a couple of things where we don't have a problem with. It's just, I feel like we're about to go down a minute rabbit hole on the eve of openings, where if this had been given to us on September 11th, this wouldn't be an issue. So I guess I don't mean to complain, but it's just so frustrating. Would the court like us to get with Mr. Goff, and the things that we think are okay, just tell him about it?
I would prefer counsel to get together and work through this. And then if there is a Bruton issue that exists, we're going to need to know what that is.
Your Honor, if the court would permit me a brief response, I think we can work these things out. I tried. I'll just leave it at that. But I do want to briefly address the court so the court understands where we are. And I can do that.
I can hear you.
All right. Your Honor, there's no Bruton issue here. First of all, the state, I don't think the state has a right to object to Bruton. That would come from co-counsel. First of all, they're the rights, they're impacted. But in submitting that, I'm not trying to talk about anything that Greg McMichael or Travis McMichael said. I'm concerned about what my client said. So as far as Bruton, I don't think Bruton's not really an issue here. The only Bruton issue I had was with a statement that Gregory McMichael had said about how he knew my client, and maybe I misunderstood, but I thought in the last draft that one part was taken out. I don't think that they're doing that. So this isn't really a Bruton issue at all. This is a rule of completeness issue. Because I'm not trying to get in anything that the co-defendant said. The rule of completeness issue is pretty clear under case law. I'm looking at Morales v. State, 337 Georgia F. 614, which basically
is also citing the Supreme Court cases that went before that, which I think Ms. Hogue had provided to all the lawyers, not necessarily to the court. But the idea that because a statement is self-serving, that you can keep it out, that's just no longer the Georgia law. The state doesn't get to put in the first half of an explanation of an issue without the rest of it. You know, they can't put in, for example, the part of a sentence that says, I shot him, and then leave out in self-defense and make the defendant testify to get that in. It's the rule of completeness. And I'm certainly willing to work through this. I don't really think there's a rule of completeness issue there, because under the current case law, particularly given the confined nature of what Mr. Bryan's talking about, they don't get to go into half of the conversation. And it gets complicated because it seems like every interview, the same subject is covered 2 or 3 times. But those subjects are reasonably covered. Now, I don't understand what objection the state would have to anything that the detective said. That's not a self-serving statement issue, anything that the police officer said. But my client's response to what the police officer has asked or what has said, to the extent it's relevant to conversations the state is introducing, are highly relevant in this case. But I think we can work that out. But this isn't really a Bruton issue. This is a rule of completeness issue, and I think the case law is pretty clear that pretty much everything that Mr. Bryan has said in the interviews with Detective Lowry and the statements on the street with Officer Minshew, I don't think there's any real issues there. There may be some finer points with respect to investigator secrets, but I'm not sure about that either, because the state, as I understand it, isn't really planning to say much about those, other than the video going through the neighborhood, which I think the state has said that he's basically going to testify to the same stuff anyway. I think we can resolve those issues, and I'm sorry that the state somehow feels surprised. I have worked on this as best I can, but technically, in terms of the rule of completeness, I don't know that I need the state's permission. I'm just bringing it up, again, in the spirit that counsel, I think, have worked really hard on in this case to try and resolve as much by agreement as we can, and I think we can do that this afternoon when we're done. But the Morales case and the Supreme Court case it cites, which I think is the same one that was cited by Ms. Hogue, it's really hard under the current case law to parse the defendant's statements on a subject. If the statements relate to a subject that the state is going into, everything part of that comes in. This idea that we're going to try and parse sentences or parse paragraphs, that's just not the current state of the law.
Okay, let me just hear from both the defendants, and then we'll get back to the state.
Thank you, Your Honor. I'm just looking at what Mr. Goff gave us that he's seeking to put in that was left on our table this morning. And our Bruton objection to that proposition is on page 10 of what he's labeled Minshew Body Cam Excerpt 4, where it looks as if Roddy Bryan is saying, it's getting a little fuzzy right there, but they all jump out the damn truck. So I just don't think obviously that is a Bruton problem right there, and I think the rest of it looks as if this is between Ms. Dunikoski and Mr. Goff, because it doesn't look as if anything else implicates the co-defendant. Did you see that? Anything on Lowry's?
No, nothing. I have the first part that Mr. Goff gave us. I didn't have this part, and I agree with Ms. Hogue. And the rule of completeness issues, I think, are between them if they can resolve them.
Well, at minimum, it sounds like the Bruton issue needs to be, based on my understanding of the agreement amongst counsel all the way through, is that the Bruton issues would be excised from any statement. So my expectation would be, if that is considered to be objectionable as under Bruton, then that's not going to be part of whatever is played. I don't have the transcripts in front of me. I don't know what's being debated, but I do ask counsel, before we spend a bunch of time talking about it here, to sit down and take a look at it to see whether or not it can be resolved.
And we will. But to be clear, as it is the only specific issue that was raised, the issue here is Mr. Bryan's uncertainty about the events and difficulty processing the events at the time of the interview. The part that it's fuzzy to me is what matters.
not what part of the interview or what statements he's fuzzy about. We're not trying to get into anything with the McMichael defendants, but he has said more than once in the course of these statements that he's uncertain about the information that he's relating, the details of it. That has nothing to do with the McMichael defendants. That has to do with his mental state and his ability to recall things at that time. So if that's the Bruton issue, then I think we've got that resolved. But I will certainly make sure. And again, to keep it in context, the state is not using the transcript. I thought the state was going to call witnesses and ask them to testify about subjects without necessarily using the video or the transcript. Similarly, when I'm examining a witness, I'm going to be asking them specific questions to avoid Bruton issues addressing the other defendants. And although I highlighted or identified larger portions, it's in the context of asking the things relevant to Roddy, Bryan within those. And if I wasn't clear earlier, Ms. Dunikowski, you do have my sincere apologies, because maybe I wasn't.
No, Mr. Goff was not clear. He's clear now, though. So I am going to assume Excerpt 4 will be taken care of appropriately per our discussion right here that we were handed. In addition, the only other thing, and I wanted to bring it to McMichael counsel's attention, was on page 14. I believe Mr. Goff is seeking to have Officer Minshew talk about, well, Mr. Bryan says I was back a little from where I am right now, but the context of that question was, where were you when you saw Travis McMichael holding the shotgun? And so I'm assuming we're not getting into that part. It's just about, well, I was a little further than where I am right now when the incident took place, or something along those lines?
Exactly.
Okay.
When you see the video, when the video ends, Mr. Bryan appears to be a good distance back, but when you see the vehicle on the body cam, it appears much closer to the other truck and to the deceased, and it's clear that the vehicle was moved between the end of the video and the body cam, and we just want to make sure the jury understands how far away he was at the time of the shooting. It's got nothing to do with the McMichaels or what happened.
The only other thing with regard to this, Your Honor, is that it is hearsay. So, number one, it's a statement of someone who's not on the stand and going to the truth of the matter asserted. So the rules of hearsay would apply. It becomes a admission of a party opponent because that's who the defendants are, but it doesn't automatically make it relevant. So I do want to address Mr. Goff's assertion that all of Mr. Bryan's testimony comes in because it's what he said. Well, there's a relevancy situation, and the state will go ahead and cite to Jackson versus the state, 301 Georgia 866. It's a 2017 case out of DeKalb County, and basically, the state is allowed to introduce partial parts of recordings of phone calls, statements, body cam video, for only the relevant parts to prove certain aspects. Now, I understand what the rule of completeness is, and you don't get to put, I shot him, and then take out the part where the person says in self-defense, if that's their entire statement. The state understands that, and I think we've kind of worked that out, and I've assured all three counsel that any place it said we, us, that kind of thing, the officers are going to testify appropriately to just me or I or that kind of thing. And just so everyone's clear, because I'm trying to put this on the record right now, there are going to be general questions in the sense of what did he tell you his name was? So we're not quoting things, but there are times when we are going to quote, and I understand the defense is okay with those quotes because sometimes you want those quotes, specifically what their clients specifically said, and our officers are directed to use the transcript for those specific quotes, but they're the ones that don't violate Bruton per our agreement. So I think what we'll do right now is we'll get with Mr. Goff and we'll make sure we're on the same page as to how he's going to present these statements in his opening.
We will, but I do want to address this last point, Your Honor, because Ms. Dunikowski correctly cites hearsay rules, but then she overlooks, and I'm sure she just doesn't have the benefit of the Morales opinion, in which the court concluded, quote, we agree that Morales' entire statement should have been admitted under the rule of completeness. Going on to evaluate whether it was harmless error, they addressed the very argument made by Ms. Dunikowski. On appeal, the state repeats that under these general principles, the exculpatory portions of Morales' statement remain inadmissible hearsay. But such a result would ignore Georgia's long-standing rule of completeness, now codified as OCGA section 248822, which provides that when an admission is given in evidence by one party, it shall be the right of the other party to have the whole admission and all the conversation connected therewith admitted into evidence, emphasis added. So, Your Honor, the state is correct. If they do not present any of Mr. Bryan's statements to the jury, then we could not present his self-serving statements. But once they present part of the statement, then regardless of whether or not it would otherwise be hearsay, it comes in under the rule of completeness.
Your Honor, you just cited Morales, and the key word there was they kept out the exculpatory portions of the statement. So, Mr. Goff, with his case, it would only apply to the exculpatory portions in conjunction with the inculpatory portions, not everything in the statement. Thank you, Judge.
And with all due respect, if it wasn't exculpatory or inculpatory, we wouldn't be talking about it.
Okay. I understand the issue. Sounds like the lawyers are going to talk about it. All right. From Travis McMichael.
Yeah, we've gone through.
Yeah, no, I'm not sure of the question, but we've gone.
I'm just tidying up the record, making sure we're good.
Yes, we've dealt with the Bruton issue with Ms. Donikoski and the state.
Actually, sever. I think I got I'm talking, I was over here with the state, I had gone through my list of things that needed to be addressed. I didn't know whether there was anything else.
Nothing else that I'm aware of, right?
The question we have is how the courtroom is going to look, and we won't, we're asking the court, and I haven't even discussed this with anyone else, but the idea of showing up at 8:30 or so in the morning, figuring out where all our things are going to go and where the screens are going to be.
It's basically going to be set up the way this is. Nothing. The screens aren't going to move. Defense table's not going to move. We talked about this morning. I have not had an opportunity to follow up on some of the things like possibly a screen. That's a good idea. The more time we burn in the day, the less time I have to address these things. Counsel, as I indicated, the state's table is going to be shifted around so that the jurors get sight lines, and just like I talked about this morning. But other than that, we'll be effectively where we are and what everybody's gotten used to while we've been here. There'll be a screen right there where there's been a screen all along. There's another screen that's available to the jurors if they want to use it outside the gallery, and we'll transition the table.
My apologies. Is it split? In other words, if you're juror, whatever, I guess that'd be 16, are you looking at the screen and seeing the witness? I mean, I don't think juror 16 can reasonably see the witness.
Sidelines. That's what I was doing this morning. I'm going to do it again once we take a break and make sure that I'm clear once the council table has been moved. But I understand what you're saying. We've been working on sight lines and making sure everybody's got a good view.
Okay, so the answer then is that the witness doesn't appear on the screen. That's just for exhibits?
That's the evidence screen.
Well, then I want to talk to the team, but I just don't see how this is the kind of situation where a juror is going to have the opportunity to view a witness for purposes of deciding credibility, demeanor. They're just so far away. I mean, I think we need to take some measurements and be able to put that on the record, which we will. But do we have, is there any flexibility in the court's mind with how you've arranged this courtroom?
I've already explained where I am on things.
So that's a no, it sounds like.
I mean, it sounds like you're renewing the motion to consolidate into the box. I've already ruled on it.
Well, now I'm just trying to find some more of a middle ground. Just the, in my mind, I thought that there would be some sort of, the people in the room that we're calling the overflow are actually going to be able to see the witnesses better than our jurors will. Is that accurate?
You're asking me?
Well, I imagine that if you're looking at a screen.
I'm addressing what's going on in the courtroom. Whatever's going on in the overflow, that's been the Glenn County Sheriff's Department and IT. I have not sat in there to see how it's set up. I don't know.
All right, well, it sounds as if there is no wiggle room in the court's procedure right now with respect to where the jury is seated.
As of 9 o'clock this morning, I explained where we are. The more time I have to think through some of the issues that have been raised, the greater the probability is we can at least work towards addressing some of them. But I haven't had a chance to address any of them since we started this morning.
If I may, for what it's worth, the court.
Are we on this topic?
We're still on this topic. I have a couple others, but I'm not going there yet. I'm trying to be good, Judge. I'm going to suggest, just having tried a lot of cases in here over a lot of years, there may be issues in the morning. I think that it might be one positive suggestion, Your Honor, with respect to the witness box, because this is a problem, particularly with short witnesses or witnesses with bad posture, that they are difficult to see even in a regular case. If we could get a booster seat, for lack of a better phrase, so that the shorter jurors can be seen, it could make all the difference in the world. Otherwise, and you may have to deal with it anyway, with shorter witnesses or witnesses who don't stand up straight in the chair, you're going to constantly be encouraging them to do that. And I know the court doesn't want to be in that position, but it can be an issue. I was going to suggest, because some things won't happen until we're done for the day, it might not be a bad idea to let the jury come in an hour later, and if we have any measurements need to be taken, I ain't bringing my tape measure, but if anybody else wants to take measurements and make it part of the record, or take photographs, which we've also done, to make it part of the record, I mean, I just think it would be easier. We can't do it now because we're not set up as we will be in the morning, although we're reasonably close. I think some extra time would be good. I'll leave it at that.
All right. Anything else then from Greg McMichael?
Nothing else from Greg McMichael.
Anything else from Mr. Bryan?
A couple issues, Your Honor, mostly housekeeping. As if Your Honor did not have enough things on your plate, we had a little bit of an issue earlier this week with respect to the workspace for defense counsel. It is a very small space. There's not even room in there for everybody's boxes. I mean, we barely can get everybody's travel bags in there during during this process, and the issue has come up. And frankly, sometimes the Bryan lawyers want to talk privately. More often, the McMichael lawyers want to talk privately, and the McMichael legal team has been most gracious to us all week. We have generously used their Keurig machine and their refrigerator and so forth and so on. But there have been several instances where they have kind of politely tried to suggest that we needed to get out of there so they could conduct their business. That each of the three courtrooms on this floor have 2 witness rooms. I understand the state has commandeered, maybe that's not the right phrase, utilized the other witness room for this courtroom. There are 2 other courtrooms with witness rooms. I still don't understand why the attorney workroom, which was designed for these purposes, is not available, but we're not going to go back down that road. But I'm just suggesting that it's going to get difficult at points during this trial, particularly if the defenses are to get more antagonistic, for counsel all to be fitted in the same 8x10 room, particularly with all their gear and stuff. And I'm guessing sometime tomorrow morning printers are going to show up because the McMichael team can't go back to St. Simon's Island. It was suggested, Your Honor, that graciously, I don't mean to imply any lack of professional courtesy, that the Bryan team return to my law office on breaks rather than their room. I won't say their room. Well, we'll call it that for now. Your Honor, if we're going to be taking 30 and 45-minute lunch breaks or even an hour lunch break, it's really impractical to get to and from there. And of course, Ms. Bruton has her own issues that we've discussed before, and that really keys off her being able to use the facility that's here. So then I'm going to be going back to my office and she's going to be remaining here. Getting a second witness room from an adjacent courtroom on the floor would be a good solution to that. Also, the length of the breaks. I mean, I suppose if the breaks are long enough, we can traipse down to my office. It's a couple blocks away. It's just a little bit longer than walking distance. I don't know how many people are outside. I don't know how many people are going to be outside tomorrow. But if 20,000 people actually descend on Brunswick, Georgia tomorrow, there ain't going to be any parking downtown. So that's going to create another level of complexity. Whatever assistance or advice the court can render would be appreciated. And like I said, I know you got 100 other things on your plate, and I'm sorry. Second issue, in cases, I can't say I've ever had a case exactly like this, but in other significant multi-day trials, we have been able to work out some common arrangement, and maybe we can or we have. I'm not always, sometimes I feel like I'm playing catch-up, as to the witnesses to be called the following day or the following morning, so that everybody can figure out what they need. Because the files in this case are substantial, and I know everybody else is very digitally savvy here. Much of my stuff is still in boxes and paper, and it's very cumbersome. So it would be very helpful, although the state is not obligated to do that, to make best efforts to give us some idea of what we're doing the following day at the end of the current day. I don't know what the court's preference is or policy is on that, but usually it results in a lot less continuances and delays. Third issue is family members. In the past, during motions hearings, if I recall correctly, each of the defendants was allowed to have 2 family members present, at least 2 because we had 2 here. With the current arrangement for jury trial, the court's already indicated to counsel that space is limited. All I can suggest is that if the victim's family is allowed to have a half dozen representatives in here, including their civil lawyers, it seems reasonable that each defendant should be able to have 2. That's a total of 6 out there. And I just want to make sure that we don't have that issue. In a motion hearing, it's not that important. We have more time. But when we got juries coming in and out for trial, it's very difficult for the lawyers to keep up with all that stuff. And I just want to clarify that. So, for example, Roddy's family are driving, I think 2 hours to come here and back and forth every day, that when they get here, they actually have a place to sit in the courtroom. Fourth issue, I'm going to, if I can, I'm going to file a motion to reconsider the special demurrer as to count 7, the aggravated assault count. If I can, I will go ahead and submit a proposed jury charge on aggravated assault, which I can only guess would be of substantial length because of the problems with it. I have reviewed the court's order, and although the court's order was well written, with all due respect, the legal authority on this issue is considerably less than for some of the others that the court addressed. And I'm just putting the court on notice. I think we have serious problems with the aggravated assault count, and I think out of fairness to all the counsel, it would be wise for us to know what the court's leanings are on those, not all of which are fully addressed in the order on the special demurrer. I'm not saying the court's going to do anything in the morning, but I'm letting the court know that I'm going to, if I can, I'm going to try and address that after I figure out what portions of my opening statement I can and cannot use based on the agreements that Ms. Dunikowski and I reach and everything else that's gone on today.
I have been made aware to the sheriff's office that there are 2 other witness rooms attached to each court. The issue, Your Honor, is that to use those rooms, it needs to be staffed by a sheriff. That is in the actual courtroom. If court's in session, then there's no issue. We can use those rooms because there's a sheriff personnel in the courtroom. If court's not in session, though, we can't use those rooms, again, unless there's a sheriff personnel in the courtroom. What we're asking is that we get one more sheriff personnel and have them here every day of the trial to either be in the courtroom when it's being used, and it's not a problem. If it's not being used, then we simply have them in the courtroom. Yesterday, or maybe it was this morning, we went and toured the other courtroom. We got to see all the plexiglass panels, and there was a sheriff's representative in that courtroom. Well, the lights were kind of dim and off or whatever. But I think one additional sheriff personnel would resolve this issue, and it would no longer be a problem. So one person can solve this problem for us. And we expect that court's going to be in session on many of the days anyway, So we could use one of those rooms, but I think that's the big solution there. That's an easy one.
I know nothing of the discussions, and I've not participated at all. Sounds like the first place you need to go is the sheriff. I have been involved off the record on this issue starting, not off the record as in right now, but when it was discussed 2.5 weeks ago. I've explained to everybody where I am on it, and if you can get it resolved, fantastic. So I appreciate that everybody's working on it. All right, sounds like all the matters then before the court. I'd hoped y'all would have a little bit more time. Oh, clerk's passing me a note. That hasn't happened already? No. Okay, the clerk has asked me to remind everybody to get an exhibit list to the clerk and court reporter. Okay.
I am so sorry. I've given it to our court reporter, and I will make sure that the clerk has a copy of this. And I'm so sorry about that. Our court reporter does have our witness list and our exhibit list.
Addresses that. Now, court's issue. I don't have my jury list in front of me, but the juror that I expressed some concerns about yesterday that had a medical issue, I have received a note dated today indicating that she will not be able to participate as a juror due to medical reasons. I don't have the number. If I have the name, last name begins with a W?
Yes.
Yes. Oh, there's my list. 579. The note, and I'm only going to not going to refer to the individual patient, is expected to be in court tomorrow, meaning Friday. There, and I'm not going to get into the diagnosis, but there's a back issue, is bedridden, will not be able to sit upright. She is on narcotics, which affect her judgment. And the request is that she be excused because she is not able to perform the duties of a juror. Anything from the state?
Nothing from the state, Your Honor.
Anything from Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan? Based on, and just on the record so that we're clear, this juror contacted the court, when I say contact the court, contacted the clerk, I believe it was, Tuesday, indicating back issues. Wednesday, we were provided some information that she, I assume it's she, would not be able to attend that day, which was not sufficient information to have the court strike her at that time as an available juror. Then today we have this additional information. It appears that she is not going to be able to participate due to not just the diagnosed condition itself, but also the fact that she's on narcotic pain medicine, which would affect her ability to sit and listen to the evidence. Based on that, juror number 579 is struck from the panel. She was a participating juror, so alternate 1, which is juror 282, is now one of the active 12 members of the panel. Anything from the state on the court's ruling?
No, Your Honor.
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
All right, that's all the court has. I'm going to bring everybody back at 9 o'clock. The panel's coming back at 9 o'clock. We may have some things we need to address first thing, but they'll be available, and hopefully we'll be able to get started on a relatively timely basis tomorrow morning. We'll see where we are, but they will be available at 9 o'clock. Anything from the state before we recess?
I'm assuming that the court will have us do openings and immediately segue into the presentation of evidence. So I should have witnesses and the evidence here.
That will be the plan. And I'll make sure everybody has a ruling on the 2 open matters. I realize I have 2 matters under advisement.
Do you expect to email those rulings to us tonight since?
See how quickly I can process them. If you want them by email, I can give you a basic ruling.
I think we would all appreciate that since they'll probably impact the way we would do our openings.
Fair enough, I'll try to do that.
Thank you.
And we're seeking to work with tech now.
Okay. Yeah, tech's available and you can do that. That's fine. So nothing from Travis McMichael, anything from Greg McMichael before we recess?
No, Your Honor.
For Mr. Bryan.
I'll talk to the state privately about the witnesses.
We are in recess.
connection.
No, it's on the bottom right
Right.
now.
Mm-hmm.
Oh, it's down here.
Yep.
So once you open up, it's gonna go down there.
Oh,
There we go.
Okay.
It had a little camera symbol.
Okay.
And then
Make it big.
make it big. And then I think there is also.
So it's going to be open down here.
Correct. If not, I'll just,
Yeah, we'll pick it up
pretty much
there.
just showing you, so.
So we see it up there,
Mhm.
see it down here, camera, expand. And if I do that again, it'll still stay up there.
It just has the little icon, but behind it, you see the little orange screen.
Yeah.
That's for WebEx. So right now, if I just stop sharing, right now you see all of this. We had all those cameras and then the PCs that y'all had on y'all desks or so. We had that early on for showing everything that's in the courtroom. Right now, today, the only ones we had up was just the overview one and the witness or so. So everything else, this one has a camera, but it's disconnected. We're having it out of play. Back there, that doesn't have a camera, so it's out of play. So all of these are connected to the WebEx, but they don't have a view.
We're never going to use this.
Right.
No.
We're just using the share portion of it. So,
All right, so how do we get out of this and get back to our stuff?
so share. And so when y'all
Let's
come in
never
here,
have to do
Let's
that.
never go back to
Let's
that.
Right.
never go back to that.
so that's why, if, like the day
Never
when
go
y'all
back to
came
that,
in,
yeah.
it was already there. So I
Right.
wasn't sure if y'all was going to do anything, but it was already